Harriet Wistrich. Harriet is the founder and director of the Centre for Women's Justice. She's a solicitor and has worked for many years with Bernberg Pearce Limited. She won Liberty's Human Rights Lawyer of the Year award in 2014 and Legal Aid Lawyer of the Year 2018 and the Law Society's Legal Personality of the Year 2019. Really, it's a lot of accolades. She's a trustee of the charity, the Emma Humphreys Memorial Prize. She's acted for a number of women in appeals against convictions for the murder of their violent partners. Most recently, Sally Challen, I'm sure you'll all remember that case, very recent. She also acted for Ferriesia Martin. So please everyone give a big round of applause to welcome Harriet Wistrich.
Well, thank you very much indeed for your invitation to speak today. When I first received the invitation, I thought it might be a mistake because I know virtually zero about housing law, but I've been assured that I am giving you more of an overview about domestic abuse and our changing understanding of domestic abuse, particularly in recent years. And I'll talk about it. I will come to the Domestic Abuse Act, which is very important, and the criminalisation of coercive and controlling behaviour. But I'll also sort of thread in through the talk a few of my own insights from the sorts of cases I've done occasionally, and also a little bit about the work of the Centre for Women's Justice. If anyone doesn't know the Centre for Women's Justice, we're a legal charity. We were established in 2016 with the aim of holding the state to account around violence against women and girls. And specifically, we focus on the criminal justice system and criminal justice failures. Back. So this is starting with my slightly before my personal experience. This was I don't know if it's an urban myth or actually true, but it was said that the way in which you could judge whether a man could beat his wife was if he used a rod no thicker than my thumb. So that's where we've come from, and sometimes I feel we haven't gone very much further with some of the things we see, but we have moved on a bit from the rule of thumb. On the Centre for Women's Justice website, if you're interested, we've sort of produced a bit of a timeline, which you can see how kind of some of the key laws, key legal cases and developments around domestic abuse and violence against women up to the modern day. It's just gives you a bit of an idea of where laws have come in and developed, and in there you'll see some of the kind of progress around domestic abuse and an understanding of domestic violence and the criminalisation and the rights of married women to own property and so on as we've moved forward. So my first kind of real introduction to the law and what drew me actually into becoming a lawyer was through campaigning and through a campaign called Justice for Women that we set up to highlight the issue of what was sort of described then as battered women who kill. So women who are in relationships with violent men who end up being driven to kill them. And one of the things that we highlighted was that women were often convicted of murder in circumstances where they were essentially victims and had either tried to defend themselves or had been driven by the kind of oppressive nature of the relationship. And they were not really able to use the available full or partial defences. Often they were being convicted of murder. Whereas in contrast, men who were in relationships with women who were often violent towards those women were often able to use the partial defence to murder known as provocation by saying that I was provoked because she behaved in a way, we used to sort of summarize the defense as the nagging and shagging defense. So I was provoked because she was constantly nagging me, or I was provoked because she was having an affair, or I believe she was having an affair. Anyway, the defense of provocation, which reduced murder to manslaughter, was a partial defense. And it was actually repealed under the Criminal Justice Act of 2009, where it was replaced by really quite a similar defence called loss of control, which also doesn't really work very well to assist women in those circumstances. So that was my kind of introduction to the law and an understanding of domestic abuse, and understanding abuse really through a gendered lens, if you like, to understand the underlying dynamics of what goes on in the power of relationship. We used to sometimes, quite frequently, when we would go to court with one of these cases, and we used to do a number of appeals of women who'd been convicted of murder, and the judge would say, well, this isn't really a battered women sort of a case, because there was no kind of bruising or broken bones, and that was really how battered women were perceived, as victims of physical violence. But it kind of, our task really was to try and show domestic abuse, domestic violence as something that was much more than just physical abuse. And so over time, we've developed an understanding of domestic abuse as incorporating a whole range of different elements of coercive and controlling behaviour. Now, where am I pointing this up? Oh, there we go. Okay, so the concept of coercive and controlling behaviour was articulated really powerfully by Professor Evan Stark in a classic text, which is well worth a read if you feel like reading a long book, called Coercive Control: How Men Entrap Women in Personal Life. And really, the way that he formulated that concept was to look at it not as an issue about violence and about physical harm and psychological harm, but to look at it as essentially a sort of political concept. It's a pattern of behaviour which seeks to take away the victim's liberty or freedom, to strip away their sense of self. It is not just women's bodily integrity which is violated, but also their human rights. So it's a sort of human rights kind of conceptualization of domestic abuse, and that concept was eventually incorporated through our own laws under the Section 76 of the Serious Crime Act 2015, which criminalised coercive controlling behaviour in intimate or family relationships. And that is the way in which it is conceptualised. And obviously you can look at the law, and also I'd strongly recommend the statutory guidance, which is published alongside the law, and that kind of encapsulates really many of the different elements of coercive and controlling behaviour. So here you'll see it's not specifically about physical violence, although physical violence may and often is part of the pattern of coercive control, but it's about a whole series of behaviours really which seek to entrap a woman and to deny her sense of self and her liberty, essentially. That concept we were able to use effectively in the appeal by Sally Challen against her murder conviction. And Sally had been convicted prior to the law coming into place. And we argued her case was a classic case of coercive controlling behaviour, so that she was in this marriage for a very long time and was completely controlled by her husband. There was hardly any physical violence in the relationship. So to the outside world, you might see somebody who was very submissive in her relationship, who was also kind of very committed, apparently, to her husband, but it kind of belied what lay beneath. And so we sought to argue that the new understanding that was eventually passed into law in 2015 provided a kind of a whole different lens by which to understand Sally's behaviour. And once you looked at her, the way in which she behaved in the lead up to the offence, and at the point of killing it was portrayed at the original trial as somebody who was sort of motivated by jealousy. But once you put the lens of coercive control into it, you saw somebody who was actually totally gaslit and who was essentially reality checking what was going on in the relationship. So when she was watching her husband and trying to understand what he was doing and how he was behaving, in fact, it was her having been so kind of gaslit by his manipulation of her that checking was really about her reality checking. So that was the challenge in the Sally Challen case, and I think from a public awareness point of view, it has helped through the campaigning of her son David to really kind of put the idea of coercive control, to broaden it out and to make more people aware of it. Although I have to say, through the criminal justice process, there remains a very distinct lack of awareness of coercive control. For people who are sort of interested in the issue of women who kill, the sort of underlying issues of how women experience the criminal justice system and the barriers to justice that women experience, Centre for Women's Justice published a report, which you can find on our website, on women who kill, and that was based on looking at a series of cases over 10 years, where we looked at the number of women who kill men and men who kill women in intimate partner relationships. And you'll see that the way in which justice plays out in those criminal cases, and that then because women, for example, almost always use a weapon, the criminal justice system sees that as an aggravating feature of a criminal offence, which means that often they are getting longer sentences, or they're unable to use self-defence, and so on. And I'll come briefly back to that later. But I'll move on to the Domestic Abuse Act, which was passed into law in 2021. And that includes a new legal definition of domestic abuse. It's a very helpful definition. It includes a coercive controlling behaviour, as we described, and also economic abuse and psychological, emotional abuse. So it really kind of moves the understanding through the legal definition forward, but not necessarily through the practitioners in the criminal justice system, who still seem to be kind of stuck quite a way behind in my experience. It also it includes a kind of whole range of provisions. I'll just go through a few of them. One really important provision, which I'm sure is relevant to the work you do, is that children for the first time are recognised as as victims in their own right, children in domestic abuse relationships. I suspect today you'll be talking about a couple of provisions relating to housing, including the new legal duty on local authorities to fund support for survivors in safe accommodation. What I've put in brackets, local authorities are sucking up the money, because what we've seen, so Centre for Women's Justice work with the frontline women's sector, and what we hear is that instead of that money going to autonomous refuge services, local authorities are kind of using that government money essentially to sort of redeploy employees to provide a lot of the services, or it's that kind of constant shifting of money around, and it hasn't necessarily kind of produced the extent of what we would like to see in terms of domestic abuse services. There's a new protections in the family courts to prevent abusers cross-examining their victims, but the family, those of you who do family law will be familiar with how what a nightmare the family courts are for many victims of domestic abuse, depending on which judge you get. It also has introduced, importantly, post-separation coercive control, although that hasn't actually come into law yet. So the provisions of the Domestic Abuse Act, some came in straight away and some are still waiting to come in. And that was important because coercive control, originally defined in under the criminal whatever act it is, 2015 Act, it defined it as living together. And in fact, what we know about many abusers is that they, even when the woman leaves, they continue to stalk or seek to control her in relationships. So that's a very important addition to the law. Again, I suspect you'll be covering the next provision, which is around priority needs for housing, so I won't go into that. And there's a ban on GPs for charging medical evidence for domestic abuse. It also introduced the new post of a domestic abuse commissioner. That's Nicole Jacobs, who is domestic abuse commissioner. She comes from the women's sector. She used to work, so she's kind of a very good ally, really, because she has worked for many years, providing domestic abuse services before reaching this role. And there are a whole load of duties which you can see under sections 4 to 21 of the Domestic Abuse Act, setting out the sorts of things that she can do. We're working with the Domestic Abuse Commissioner at Centre for Women's Justice. We have something called a femicide working group, where we bring together lawyers and NGOs working around issues of femicide. And one of the concerns we have is the failure. There's all these different processes for post-death investigation, from domestic homicide reviews to inquests to independent IOPC reports where there's police failings, and that in each of these sort of different types of process, if they find that there have been failings that contributed to the death, may make recommendations, but there's no joined upness about what happens with those recommendations and actually whether there is any learning arising from them. So we're very keen to promote a domestic abuse oversight mechanism, domestic homicide oversight mechanism, and the Commissioner's Office is assisting with that. Briefly, there are a whole set of new protection orders that are to be introduced that haven't yet come into force, that are at sections 23 through to 59. That seems to be making very slow progress. I put beneath that details of something that Centre for Women's Justice did, which was a super complaint. So there's a police super complaint where you can raise an issue about failures in policing, and that first super complaint we did really highlighted, as we had identified through the the work we did with the frontline women's sector, the failures of the police to use the various different mechanisms that they had available, the powers they had available to protect women from domestic abuse, and that included the failure to use domestic violence protection notices and orders, which are a sort of precursor, although they're still in place, to the new protection noises, that should be notices, I think. So you know, we found, I think, in our super complaint that about you know, in some forces they never used these powers. They just sent women to go and get their own civil orders, their own non-molestation orders. When they got the non-molestation orders, the police didn't enforce them. So the whole point of a non-molestation order is that there are kind of criminal powers to ensure that you know, if somebody breaches it, they should be arrested. And we saw, I worked with a colleague at Dowd Street, Brenda Campbell, in a recent absolutely horrific inquest of a double homicide in Solihull of a mother and her daughter, where there was kind of a whole, you know, there were repeated kind of you know, acts of violence, repeated police call-outs, never did anything. Eventually, she obtained a non-molestation order and felt that at last she might be protected. And sadly, that seemed to just be a red rag to a bull, and he just breached the order. And it was one of the most horrific inquests, actually. You may have seen it, the case of Raneem Uday and Koala Salim. But it's just a kind of seeing played out everything that about the abject failures of policing of domestic abuse. So I'm sort of conscious I might be running a bit over, but I just want to pick up on a few additional things. There's some new criminal offences which have come into play. We worked at Centre for Women's Justice. We identified a very significant area and were successful in a coalition with other organisations in getting non-fatal strangulation recognised as a separate criminal offence. So the CPS say that they do prosecute for strangulation issues, but often they don't, or often they only prosecute for common assault, whereas non-fatal strangulation, as you will learn when you look at the dynamics of domestic abuse, is a very common tactic by coercive controllers. And if it is identified on the police risk assessments when they come to the house as a sign, a risk of potential serious harm, and I think it's really important that it's recognised as a standalone offence, which can receive a sentence of up to 5 years, because it is, of course, very high risk offence. And it is what I think where we see it played out mostly is where abusers can say, look what I can do, you know, look what I can do. So it's a kind of warning to women to behave. There are some really important areas of the Domestic Abuse Act which haven't, which were excluded, and the women's sector were very united in trying to push for a whole range of different amendments, and the most sort of one of the most you know, concerning areas is around migrant rights. There's the issue of a firewall, so that if somebody who has insecure immigration status wishes to report, you know, what is there to protect her from being, if of being referred to the immigration authorities. And that obviously is a disincentive to reporting, and there is also the whole issue around no recourse to public funds, which I'm sure you're aware of. And just very recently, you'll know we have, or you may know that we have endorsed the ratified the Istanbul Convention, which is a very important convention on violence against women and girls. However, we have entered reservations in relation to, again, into migrant rights and so on. So, you know, this, what we see playing out more generally from our delightful Home Secretary also kind of comes into the domestic abuse sphere. And then the other area which Centre for Women's Justice have done a lot of work around is issues of defences for domestic abuse victims who are charged with criminal offences. And so it's not just women who kill, but women who offend in self-defence, or women who are coerced into offending. And we know that you know, a feature of coercive controlling behaviour sometimes is, you know, to make women handle stolen goods or hold a gun or drugs for an abuser, or kind of collaborate in mortgage fraud or something like that. And there is no defence other than the defence of duress, which is virtually impossible to use. So we'll be trying to introduce a new defence modelled on Modern Slavery Act. And we also put forward a proposal. You have something called a householder defence, which was introduced in recognition of what happens when your house is burgled and you know, and a man kind of is frightened and acts with violence towards somebody intruding in the house. But that same kind of disproportionate reaction isn't recognised if you're in a relationship of violence. So we kind of wanted to introduce that. If you're interested in that issue, we've done another report, which is also on our website, which looks at the unjust criminalisation of victims of male violence. And we're also, if any of you do practice criminal law, I've brought a few flyers. We've sort of developed a whole training module for criminal defence lawyers in representing victims of domestic abuse who've been accused of offending. So I'll leave some here in case anyone is interested in that. But that's a sort of we're doing a sort of a test training day next month, and we're hoping to kind of encourage lawyers who defend to have a better understanding of the complexity of domestic abuse. I shall finish in a moment. That's just a recent report that's come out, which kind of identifies some of the key themes. It's if you're interested, it's really worth a read in looking at coercive control as an aggravating factor. It also picks up on strangulation as because interestingly, strangulation is almost exclusively a form of violence used by men towards women, or whereas weapons are as I mentioned earlier, often used by women in violent relationships, and yet you know, weapon is seen as an aggravating feature which may attract a longer sentence. But strangulation, which is a very intimate form of violence, is not seen as an aggravating factor. So it's quite an interesting read. And I'll just end here, just to, in case you hadn't noticed, the police and the Metropolitan Police are in quite a lot of trouble at the moment because not only do they not protect women from a domestic abuse, but they actually perpetrate it, as we have found and have sought to highlight in another super complaint we did, which is on police perpetrated domestic abuse. And that was actually lodged a year before the murder of Sarah Everard, and subsequently the actions we've seen in relation to David Carrick, and most recently the Casey report, which was published last week, which just shows astounding levels of violence from police officers towards women. So I think that's everything, and I shall stop there. Thank you.
Thanks, Harriet. Thank you.
Did you want to do questions, or should I just move straight? Or
Do we have?
I think a bit short of time.
Take a seat for now and we'll have questions afterwards.
Well, hopefully we will have time for some questions before coffee, but yeah, see how we're doing. Thank you, Harriet. My name's Jo Underwood. I'm a solicitor at Shelter. It's my pleasure to chair this next session and introduce our speakers. It's been really interesting to hear from Harriet and how many of those themes and issues thread through into housing and homelessness law. So hopefully we will be unpacking more of that as the day goes on. Our speakers in this panel will be looking at key issues arising in homelessness applications for domestic abuse survivors. And Harriet's talk has highlighted more than ever the need for safe housing for people fleeing domestic abuse. So we will tackle some of those issues now. I'm going to introduce our three speakers all together now. We'll hear from them in turn, and then there'll be time for questions at the end. If you're joining us online, if you could please put your questions in the chat function or the Q&A function, then they should get through to me. All of our speakers now have an impressive and inspiring track record of being involved in some of the key homelessness cases and key work in relation to homelessness, housing and domestic abuse. And so we'll be hearing more from them. They're going to take us through the different stages of the homelessness application process. We're first going to hear from Izzy Mulholland, who is a legal caseworker at the Public Interest Law Centre. She's going to be looking at management transfers in particular and getting into the detail of those. I should also flag that she's been leading on some really key work in relation to homelessness gatekeeping of domestic abuse applicants in London. And so this report is available at the back, I think, and also available on the Public Interest Law Centre website. So do have a look at that. So Izzy will speak first. We'll then hear from Zia Nabi, who's a barrister here at Doughty Street Chambers and the joint head of the Housing and Social Welfare team here. He'll be looking at homelessness applications and some of the issues that crop up in relation to reasonableness to occupy. Is someone vulnerable as a result of domestic abuse? What duty exists? So he'll be digging into those issues. And then finally, we'll hear from Martin Westgate Casey, who is also a barrister here at Doughty Street Chambers, and be looking more at how local authority duties should be performed, including suitability issues and out of area. So there's lots to get through. We're really looking forward to hearing from all of you, and I'll hand straight over to Izzy. Thank you.
Hi everyone, it's lovely to be here, and thank you to Doughty Street Chambers for inviting me to speak today. My name's Izzy, and as Jo said, I'm a legal caseworker at the Public Interest Law Centre, and I've been managing our project on housing and domestic abuse for the last 4 years. And we look particularly at trying to tackle the obstacles that domestic abuse survivors face when trying to access housing support. Today, I know our discussion is going to look at both Part 6 and 7 of the Housing Act, but I will firstly narrow our focus on Part 6 allocations, but look specifically at management transfers. I hopefully will explain why we think management transfers deserve a bit more of our attention, and I'll aim to give you a brief practitioner's guide so you feel confident requesting management transfers on behalf of your clients. I'll then finish by quickly mentioning, if I have time, our campaign on that report there, which is called Abused Twice, and that looks specifically at the gatekeeping that we feel is endemic in London. And I'll try and look specifically at the gatekeeping and management transfers as well. But first, what is a management transfer? I think. Okay, great. Yeah, so a survivor who is a social housing tenant and needs to move because the perpetrator knows where they're living and they're therefore at risk of domestic abuse can apply for what is called a management transfer. And what that does is it transfers their tenancy from their property to another safe property without going down the homelessness route. So the survivor may either want to remain in the borough so that they're near support networks, and we can talk about that a bit at the end because often local authorities try to avoid that. Or they may need to move outside of the borough for obvious reasons due to the perpetrator finding them. So why is it important to request management transfers? So social landlords rarely provide advice on management transfers and support to allow people to go down the management transfer route. They'll often instead advise survivors to go down the homelessness route. And obviously what we know about that is that then they have to relinquish their secure tenancy. So this situation leaves survivors in a complete dilemma. So on the one hand, if they want to maintain in their tenancy and keep a hold of their security of tenure, they have to put up with a potentially dangerous situation, and they may do that because of what we know, and we can talk about the chronic lack of housing and the idea that they possibly may never get a secure tenancy again. Or they'll go down the homelessness route, go into safe accommodation, but then actually lose the secure tenancy that they've got. So we think it's so important that survivors are advised about the option of management transfers, but also everything that goes with it, which I'll go into in a minute. So obviously for someone to lose their security of tenure, that means, like I just said, they may never be offered that again. And I think survivors are really aware of that. One problem to note with management transfers, and anyone who's done it, anyone who's gone down that route will know this, they take a lot of time. So what we often advise is that the survivor goes into temporary accommodation pending the management transfer facilitation, and that doesn't have to be in the homelessness route. You can ask for it alongside the management transfer. And in that, we argue that the local authority has a duty to provide this accommodation just for the period of time to facilitate the management transfer. The wording is really tiny. It wasn't like this when I made this, so apologies for that. You're not missing anything though, I'll say it all. So the different scenarios that you might come across in a management transfer situation is that your survivor might have a local authority tenancy, but they may also have a tenancy with a housing association, which brings up its own problems. And as I said, they may wish to leave the borough or stay in the borough. So I'm going to discuss with you a case study with those the first three scenarios, and I won't have time to explain how we argue remaining in the borough, but I'm happy to go through that in the Q&A. So the first case study is a management transfer via a local authority. So this survivor was a secure tenant in a local authority accommodation. She was a domestic abuse survivor, and the perpetrator knew the location of the property. So before we got on board, the client had requested a management transfer within the borough because she had support networks there and she wanted to go to a safe part of the borough. And what I always say is that boroughs are really big. There's often safe parts, and we can explain that to local authorities. The local authority in this case delayed her application for 6 months. They didn't give her any kind of response, despite her chasing, despite her living in dangerous accommodation. And obviously that's a point about gatekeeping, which we'll come to. So when they did eventually make a decision, they decided that she couldn't get a management transfer because there had been a lack of recent incidents. So we wrote a PAP in response on the following grounds, which hopefully we can discuss in a bit later. So what we'd said is that the client had suffered continued and prolonged abuse for 20 years. During that time, there were periods of quiet, followed by significant violence. The perpetrator was erratic, unpredictable, and we evidenced that by medical records which showed he had an antisocial personality disorder. The abuse that the client suffered over 2 decades was irregular, and we knew that she could be a victim at any moment. So we argued that the client was at risk despite the lack of recent incidents. And I think just to illustrate this, the most recent incident was about 2 years ago, or 2.5 years ago. In addition to that, when the client made her application at the beginning on her own, she put all of this to the local authority. She'd given Marek letters, a supporting letter from a DV organisation, her manager at work had written a letter, and her counsellor. So we argued that requiring more evidence than that and recent incidences in addition to this showed an unlawfully high evidential threshold. We also argued, obviously, that the irrespective of the cyclical nature of the abuse and that she had actually been a victim of abuse in the past was quite irrelevant, as local authorities should not be assessing whether there has been domestic abuse in the past as to whether this person is at risk or not, and that's in the Homelessness Code of Guidance at 2126. So we said, all in all, that it was irrational to conclude that she wasn't at risk when considering her specific history and her specific case. The second ground was that in refusing the management transfer, the local authority had acted contrary to its own housing allocations policy, which they often do with management transfers, and I would urge you to really check their policy at the beginning of any management transfer you do, really to hold them accountable to their, obviously, to their own policy. And this policy in particular stated that transfers would be agreed where there was a high risk to the tenant or their family if they remain in the dwelling or the area. So we felt that the client satisfied their own management transfer policy because of the high risk posed, which I just explained, and therefore a refusal was contrary to their own policy. The policy also very helpfully stated that any offer would be pursuant to the tenant's current housing need. So we argued that she should be offered one more bed due to overcrowding in her current accommodation. The third ground was about the unlawful delay in decision making, and that's another gatekeeping point. We argued that the defendant was aware of her dangerous circumstances for 6 months, but they didn't act, and that this delay was unnecessary and unreasonable and therefore unlawful. Our fourth and final ground was that the local authority had acted contrary to the public sector equality duty and Articles 3, 8 and 14 ECHR. And there's, I think, a wider conversation to be had about discrimination in these kinds of cases. But anyway, we argued that because of this dilemma that I spoke about at the beginning, between choosing a secure tenancy or losing it and going down the homelessness route, they were effectively asking her to stay in this accommodation, be subject to potential domestic abuse, which was a breach of, we said, Article 3, 8 and 14. And they hadn't displayed a sensitive or careful approach to gender-based violence, which is required by the public sector equality duty. So what was the outcome? We managed to get the client a management transfer offer within the borough, but in a safe part of the borough, a 3-bedroom property instead of her 2-bedroom tenancy that she had. The management transfer took 1 year to be facilitated, so that's obviously something to bear in mind. And she's now in that safe property with her secure tenancy intact. The second case study I want to talk about is with a housing association, and these are notoriously more difficult. This case is one that we actually took to the High Court, so I'll just go through this in a bit more detail. The claimant was an assured tenant of a Network Homes property. Survivor of domestic abuse was in danger in the property, and she applied for a management transfer. Network Homes refused this, but said they would consider her application again if there were new incidents or a supporting letter from the police or MARAC. So we brought a JR on this refusal. Another point, one of the points that Network Homes made in their response to our PAP was the issue of not being amenable to judicial review because they're a housing association. So I think it's really important to just go over the law in this area, because I think this is something that housing associations will say in these types of cases. So the law on private registered providers, which housing associations are, is that they may exercise a public function when allocating social housing and will constitute public bodies when doing so. So we argued that Network Homes was a private registered provider and exercised a public function when allocating their social housing. They constituted a public body when doing so, given that it is publicly funded, exercises statutory powers, takes the place of central government or local authorities, and provides a public service. And the judge held in this case that there was no material distinction between the position in our case and the position in Weaver Ours. That's what it's supposed to look like. And so the judge in this case effectively held that decisions taken by private registered providers relating to the consideration and refusal of management transfers are subject to judicial review. I think it does depend on the housing association in the case, but I think we can quite confidently say that there will be exercising a public function in these types of cases. And then, we've gone small again. Regarding the new incidents and the police report that Network Homes had asked for, firstly, on the recent incidents, if there were new incidents, obviously what we can all imagine is that they're effectively saying, experience domestic abuse again, and then we will have a look at your case, which is obviously irrational, and we made that case to them. In terms of the police evidence, this comes up a lot in management transfers, and I don't know why, but the threshold seems to be much higher. And we use the Homelessness Code of Guidance when this comes up. So at 2114, it says victims can experience many incidents of abuse before calling the police or reporting it to another agency, MARAC, for example. And then at 2124, housing authorities should not have a blanket approach towards domestic abuse, which requires corroborative or police evidence to be provided. And we also argued that we were very aware that the defendant wasn't technically subject to the Homelessness Code of Guidance because of the difference between Part 6 and Part 7 of the Housing Act. But we said that these paragraphs in the Code of Guidance illustrate the widely acknowledged principle that domestic abuse survivors should not be required to produce police evidence owing to the particular difficulties that we all know they face in obtaining such evidence. And I think it's also important to note that the judge didn't dispute our use of the Homelessness Code of Guidance in this case. So I would highly recommend it. The outcome was that the judge ruled the decision to be quashed, and that the matter be remitted for consideration by the defendant. And the client is now in a new property with her secure tenancy intact. I think the takeaway from this case is that housing associations are subject to the same rules as local authorities when it comes to management transfers. And like I said, I would just advise looking at each allocation scheme to really see what their specific policy is. The third and final case study I'm going to talk about is a cross-borough transfer. I feel like I keep saying the next one is even more difficult than the last one, but these are actually really quite difficult. But that is not to deter us. So in this case, we were representing a domestic abuse survivor with a secure tenancy in a housing association property. She was in danger. Marek had said that she needs housing ASAP, but she needed to move to a different borough. She requested a management transfer from the housing association, and we then requested temporary accommodation from the borough where the housing association was, because the housing association doesn't normally have temporary accommodation. So how do we argue cross-borough transfer cases? We said that the client should be made an out-of-borough offer, which means liaising with another council to organise a reciprocal transfer, given that our client was in danger in her borough and she had support networks in London, so she needed to be close by. We argued that local authorities do have the power to request other local authorities to assist with cross-boundary management transfers. And we argued that local authorities are able to seek the cooperation of other housing authorities in order to achieve cross-boundary management transfers under their general power of competence, which is under Section 1 of the Localism Act. And this Act says that this power may be used in innovative ways, that is, in doing things that are unlike anything that a local authority or any other public body has done before or may currently do. The starting point is that there are to be no limits as to how the power can be exercised. Obviously, that's quite general and doesn't exactly automatically give us a right to a cross-borough transfer. So on top of that, we cited 2141 in the Code of Guidance, which states that housing authorities will need to consider which are the most appropriate solutions for each person on a case-by-case basis, taking into account their circumstances and needs. And this may include safe temporary accommodation or a management transfer. And then 2143, which is important as it says, housing authorities may consider implementing a reciprocal arrangement with other housing authorities and providers to facilitate out-of-area moves for victims of domestic abuse. We also made the argument that she shouldn't have to relinquish her tenancy, again, just to move to another borough in order to find safety. So the outcome for this case was that it was quite bizarre. Temporary accommodation was offered by the local authority whilst the management transfer was pending. And in offering her the temporary accommodation, they decided to do something about it themselves. So they arranged a reciprocal, the local authority where the housing association accommodation was, with another borough in Hackney, it was Hackney and Haringey. So they arranged a transfer between boroughs, and then the borough who organised that to begin with asked for a property from the housing association. So it was kind of a three-way swap. The client is now in that safe accommodation with her secure tenancy intact. And also just to note that we've only tried these arguments at the pre-action stage. We don't know how these would go in the court, but luckily we've not had to go there. So in all of our management transfer cases, we've been successful. And I think that brings us on to the gatekeeping that happens in these kinds of cases. As many of you will be aware, those fleeing domestic abuse are often subject to unlawful actions and discrimination by local authorities when requesting housing, which is also known as gatekeeping. And I think the success in our management transfer cases shows that it is gatekeeping because they know they are acting unlawfully, but just need to be told to do the right thing. So I thought I would take this opportunity to quickly discuss the campaign against what we call endemic gatekeeping in London. So there's key examples of gatekeeping, including in management transfers, of severe delays. So some survivors waiting months or even years. I'm sure you'll all be aware of this. Failure to provide emergency accommodation, which isn't directly relevant to management transfers, but happens on a daily basis. Unlawfully high evidential thresholds, which we've discussed. Failure to apply the statutory definition of domestic abuse, which Harriet mentioned, so a focus on physical abuse and not the other types of domestic abuse. Survivors being inappropriately instructed to either leave a borough or stay in a borough, depending on what works best for the local authority. Unsuitable accommodation, so it may be provided in unsafe areas, that happens quite a lot, or far from support networks. And then the last one, a refusal of support until there's a threat of legal action. So because of this situation of widespread gatekeeping, we decided to launch a campaign against this gatekeeping in London with the report called Abused Twice, the Gatekeeping of Support for Domestic Abuse Survivors in Every London Borough. And as part of that campaign, we took a witness statement from a domestic abuse survivor or frontline advocate from each of the 32 London boroughs, which tells the story of the survivor trying to access housing and being gate-kept on their way. In each statement, the same kinds of obstacles arose, and we did not cherry-pick the statements, far from it. It was an uphill struggle to get the statements because, understandably, people don't have time to deal with these wider strategic points. But anyway, so we sent the report with a legal letter attached outlining all of the unlawful behaviour that was happening on a daily basis in London to the Department of Levelling Up and Housing and Communities and to the Mayor of London. In response, DLUC wrote to all of the local authorities in London, reminding them of their duties because they may have forgotten, and stressing that they fund specialist training by Shelter and National Homelessness Advice Service and encouraging them to make use of this provision. We were going to launch a JR, but apparently that was enough, so we couldn't ask them. What we wanted to ask them was to do an independent review on gatekeeping, but we couldn't. In addition, the organisation London Councils, with all of the London local authority housing departments, last week published a report in response to our report, and they've announced a pilot project where they'll be launching a project to identify the principles and processes that would underpin an exemplar housing support service model to ensure that people with an eligibility for support receive the service they're entitled to. On the one hand, this is a real sign of progress. So the interviews and evidence and law that we presented has forced London housing directors to sit down and acknowledge the problem. However, I think thinking of the scale of the problem that we've got on our hands, we're not sure a pilot project is, they've been given £20,000 to do it. I don't think that's gonna deal with the problem. Local authorities still use the lack of resources as what I call an excuse because they have to abide by the law, end of story. But I think we can also appreciate the lack of, or the decrease in funding to local authorities over the last 10 years. I think it's decreased by 63% from central government. So there is obviously a point there. But then I think we have to ask why are local authorities not campaigning together for decent funds from central government in order to enable them to do their job properly and provide safe and secure housing for domestic abuse survivors. So in conclusion, the failure to grant management transfers to domestic abuse survivors, either because of ill advice at best or unlawful gatekeeping, such as delays at worst, leaves survivors battling for their right to a secure tenancy whilst they continue to live in dangerous accommodation. Or it forces them, as I said before, to make homelessness applications and lose their security of tenure. And so by forcing the management transfer route and temporary accommodation pending, if the survivor wishes, survivors can protect both their tenancy and their safety. As I said, we've been successful in all of our cases, and I don't think that shows how good we are. I think that shows that actually local authorities understand their duty in these types of cases to provide management transfers as stipulated by their own housing allocation scheme. And so the failure to grant management transfers just sheds light on the prevalence of gatekeeping in this area. So local authorities seem to be refusing management transfers routinely, often gatekeeping support survivors are actually entitled to, but that's where we all come in. So good luck in trying to get management transfers, and please get in touch if you have any questions. Thank you very much.
Thanks, Izzy. And I think, you know, your success is a real testament to your hard work and dedication there. So thank you. Over to Zia.
Thank you. Good morning, everybody, those here and those online. Right. Well, I'm going to talk briefly, because I've only got 15 minutes, I think, about homelessness and domestic abuse. So it's a bit of a run through, and it's a bit of a skim, but hopefully there'll be one or two points that you might find interesting. I wanted to set the issue in context. So what do the latest statistics show? The Department of Levelling Up in Communities publishes these statistics periodically. And the most recent ones were for July and September 2022, and they were looking backwards. And what they say is that 75,860 households were assessed as homeless or threatened homelessness and owed a homelessness duty. And that was up 4.4% from the previous year. The number of households with children who owed a prevention or relief duty had increased 7.7%. So there was a greater increase in households with children. And I found this one quite staggering, actually. The second most common reason for those owed a relief duty was domestic abuse, accounting for 17.5% of households owed relief duty. And that was an increase of 4% from the same quarter the previous year. So it's a massive issue in homelessness. It needs specialist focus and attention, and that has been recognized by the government. It's mainly women who are the victims. I say mainly, it's perhaps mainly is understating it. In 2018 and 2019, these are the last of the figures I could get, 92% of defendants in domestic abuse cases referred to the CPS were male, and 83% of the victims were female. That's where the sex is recorded. So it's not exclusively male on female, but it is pretty largely that. And that has to be recognized. And as I think Sarah will discuss later on this afternoon, that is relevant to the public sector equality duty. Okay. And then the main housing duty. So this is looking at really last year. The main housing duty acceptance has increased from 18.1%. So the main housing duty is people who owed the highest duty under the Act. They're homeless, they're in priority need, they're not intentionally homeless, they're eligible for assistance. And that increased by 18.1%. But the number of households owed a main due to homeless and due to domestic abuse increased by 31.7%. So although there was an 18.1% increase anyway, for domestic abuse victims of a 31.7% increase. And that's really for two reasons. A, there's an increase in domestic abuse over the previous year, and that was, you may remember, a period of lockdown, which saw figures go off the charts. And then also because of, and this is progressive and much welcomed, that single people who are homeless because of domestic abuse are now automatically deemed to be in priority need. They don't have to show that they are vulnerable as a result of domestic violence. And we all know the issues of causation that arise when you have to show that someone is vulnerable because of something. Now, if you're a victim of domestic abuse, you're a single person, you're automatically in priority need. That is still feeding through in local authorities to be able to recognize that a single person can be in priority need because they are a victim of domestic abuse. Right, so that's just a bit by way of background and context. So most of you, perhaps all of you, will be familiar with the test of homelessness. And for our purposes, 175 subsection 3, that you're not to be treated as having accommodation unless it's reasonable for you to continue to occupy. And that was a section that was considered in the case of Arways, and Birmingham City Council has various names. But one of the appellants in Arways was Miss Moran. She had mental health problems, she had poor coping skills, and she left home because of domestic violence. She moved to refuge and she signed a license agreement. And that license said you can stay here for as long as you need to while you decide what to do next. She had an argument with staff. Now, she had mental health issues. This happens more than you would imagine, that there are issues between the victims of domestic violence and the staff at refuges. And she was summarily evicted from there. She went to the local authority and applied as homeless, and she was found to be intentionally homeless. The House of Lords allowed Miss Moran's appeal. They said a refuge cannot be considered accommodation for purposes of Part 7 of the Act, and therefore a victim of domestic abuse, violence, remained homeless while they were occupying the refuge. You can't be intentionally homeless if you are evicted from a refuge. That's something to bear in mind. Then, expanding on reasonable to continue to occupy, section 177, subsection 1, it's not reasonable to continue to occupy accommodation if it is probable that this will lead to violence or domestic abuse. I know Martin later on is going to have got some interesting points to make about probability and risk, but this is what 1771 says. If it's probable that this will lead to violence or domestic abuse against a person who normally resides with him as a member of his family, or any other person who might reasonably expect to reside with him. So they don't have to be living together as a matter of fact at the time of the application. And then, what does domestic abuse mean? Well, the meaning of domestic abuse was introduced by Section 1 of the Domestic Abuse Act. That led to 1771A of the Housing Act, and we'll come on to that in a moment. But then violence means violence from another person, or threats of violence from another person which are likely to be carried out. Just going to briefly stop here to talk about violence and how the meaning of violence has become more nuanced as society has progressed, frankly. So 30 years ago, violence, a lot of court involved hitting or being in fear of being hit. And then as time has gone on and the judiciary have become more aware, it was realized that violence could include mental violence, coercive control. And so this was all developing by means of case law anyway, but it has been now it has been summarized and given statutory form. And we'll come on to the Domestic Abuse Act in a moment. I've put Bond and Leicester in there because this might seem to be obvious, that where it is probable that continued occupation of accommodation will lead to domestic violence, then that's a question of fact. It's devoid of value judgments about what an applicant should or should not do. Why did the Court of Appeal have to say that in 2001? Well, the reason they had to say that is because it was not uncommon when women went to apply as homeless to a housing authority to be told, go and get an injunction. And if you don't go and get an injunction, and either things aren't as bad as you say they are, or you're making it up, or actually the accommodation is reasonable for you to continue to occupy once you get an injunction. And what the Court of Appeal have said is, do not make value judgments about what a person should or should not be doing when they are a victim of domestic abuse. The question is, will continued occupation of that accommodation, is it probable that will lead to violence? The Domestic Abuse Act defines domestic abuse. You've got to be 16 or over. You've got to be personally connected to one another, and the behaviour is abusive. And I won't say any more than that, given the limited time we have. But remember that it doesn't matter whether the conduct is a single incident or a course of conduct. So one incident of abuse is enough. Personally connected, well, it's spouses, it's partners, it's people have children together, but it's also relatives. So if you're a relative, you're personally connected. You do not have to be in a relationship with that person. It can be your father, it can be your mother, it can be anyone else who is related to you. And although the Act says that you've got to be 16 or over, if you're a child, and that's up to the age of 18, who has witnessed domestic abuse going on, then you are also a victim of domestic abuse. So please bear that in mind. And then priority need. Section 189 has been amended. So if the person is homeless as a result of being a victim of domestic abuse, they are automatically in priority need. A much needed and a belated amendment to the priority need test. I mean, Scotland doesn't have a priority need test. There is a campaign that we shouldn't have a priority need test here, that you shouldn't have to show causation. You have to show that you're vulnerable to be entitled to housing. But anyway, that's not happening anytime soon. So for a lot of other categories, you have to show that you're vulnerable. If you're a victim of domestic abuse, you do not have to undergo the causation hurdle. I've just put this up there because I had a look at chapter 21 of the Homelessness Code of Guidance. It's online. It's a really good chapter. And it has a lot of good stuff in there. And if you're writing to local authorities, I would strongly recommend that you refer to chapter 21 and pick out the relevant paragraphs, because they are hard to argue against. And there's also now domestic abuse statutory guidance, which was published in July of 2022. It's quite lengthy. It's over 150 pages. It's a very measured and considered piece of work. And again, it's really worth having if you're involved in any cases with domestic. I mean, arguably, those two codes give you all the law you need when you're dealing with an urgent situation. I just want to make some final concluding points. Joe's looking at me anxiously. I hope I haven't gone too over. I'm about to wrap up. So you don't have to be living together to be the victim of domestic abuse. As long as you're personally connected and you come within the other definitions, then that is sufficient for there to be a situation where a person is a victim of domestic abuse. It doesn't have to be a partner or ex-partner. As I said, if you're a relative, that is sufficient for domestic abuse. I referred you to chapter 21 of the Homelessness Code of Guidance. I particularly wanted to refer to paragraph 21.24. The Code of Guidance says housing authorities should not approach the alleged perpetrator, because that could generate further violence and abuse. So the housing authority has to be careful and has to be sensitive. Housing authorities should not have a blanket approach towards domestic abuse that requires there to be corroborative or police evidence. If they do, that's unlawful. And if they need corroboration, then they should be explaining why. Why do you not accept what is being said? An assessment of the likelihood of a threat of violence should not be based on whether there's been actual violence or abuse in the past. It may be that there hasn't been actual violence or abuse in the past, but it is probable that if the person continues to live with the other person, that will lead to violence or a threat of violence. That is enough to satisfy the test. You don't have to point to past violence. And again, I've made the point again. Be very careful when making contact with a victim so you do not alert the perpetrator to the application. Often, I've certainly been involved in cases where a person is making a homeless application while still living with the perpetrator, and they're making telephone calls in secret. Sometimes they can't go online because they don't have access to a computer, or if they do, they're not sure that their history won't be looked at. So authority, when it's developing its homelessness strategy, and again, I know this is something Martin is going to address, it's going to have to think about how they have systems that allow victims of domestic abuse to make homeless applications without putting themselves at risk. It's really important. And the public sector equality duty will feed into that as well. So I think there's more work to be done by housing authorities as to how to receive applications. So facilitate phone and online applications where it's most appropriate. Make clear to the person, the Code of Guidance says this, that when you make a homeless application, when you have your interview, you can bring a friend or a support worker or a domestic violence advisor with you to any appointment. And finally, victims shouldn't be asked to return to their property to collect documentation. As you know, in many homeless applications, the person goes to apply as homeless and they say, can you produce your ID, please? And the person doesn't have any ID. Now, if you're a victim of domestic abuse, that may be because you've literally fled. The authority should not say, well, we need to see your passport. Go back, pick up, obtain your passport and come back. That puts that person at risk. That should not be happening. And housing authorities also need to be aware that sometimes when people make a homeless application, that is the first time that they've disclosed the fact of their abuse. It is an incredibly sensitive and critical time. And the Code of Guidance says it is often the most dangerous time because suddenly the person who's been perpetrating domestic abuse is forced with a change of circumstances. You do not know how they are going to react. And therefore, housing authorities must be really careful. Don't insist on the victim seeking an injunction. And finally, I just want to make this point. Housing authorities must give the applicant the benefit of any doubt. If they are not sure, if the information is equivocal, the applicant must be given the benefit of any doubt. Right, thank you very much, and I shall pass.
Yes, I'm conscious of the time, so and we want to leave some time for questions, so I'm going to rush through this rather. Zia's talked you through some of the issues that arise in deciding whether or not someone is homeless. I want to pick up on some of the points about how you fulfil the duty and some of the issues that might arise on fulfilling the duty. First slide actually is well before that, which is duties to plan, which we do have to bear in mind that authorities aren't entitled to just react, that they're meant to take a proactive approach. In particular, the homeless strategy has got to take into account the needs that victims of domestic abuse have for safe accommodation. And there's a range of things in the code that are referred to about the way in which they need to cooperate with local authorities and others, and specifically with regard to refuges, and this will tie in with some of the parts in Part 4 of the Domestic Abuse Act, to make arrangements about how people can move on from being in refuges and so forth. That also ties in with their duty to provide a statutory advice service, which again has got to be designed, among other things, to meet the needs of victims of domestic abuse. And that will feed into a point that Zia made about needing to have processes that enable people effectively and safely to access homelessness services if they need it. And so what you need to have is, before you ever turn up to the HPU, that there is an advice service that tells you how to do it and gives you that support and reassures you that you can do so in a way that doesn't put you at risk and lead to the kind of difficulties that Zia identified. All of those have to take place within the public sector equality duty, which there's going to be more later on today. And also there's an important additional bit now that fits in with them, which is the duty in section 57 of the Domestic Abuse Act. I'll come on to that at the end and finish with that. So what I want to do is then ask really what are, I was going to say new, but that just shows that sort of statutes become seem more recent than they are, but the newish duties of prevention and relief. Prevention duties in section 195(2) and applies when someone applies and is threatened with homelessness, and the duty is to take reasonable steps to secure the accommodation doesn't cease to be available. That's something which perhaps has little direct impact in this context, because, as Zia's pointed out, someone who is likely to suffer domestic violence is already homeless, or will nearly always be already homeless. And there may be some examples. One given in the code is someone where the perpetrator is about to be released, and that might then mean that there's a threat of homelessness that will happen at some point in the future. But most of the time, the prevention duty may not be directly engaged. But what would be more likely would be when someone applies and they're homeless, and then the relief duty applies, which is a duty to take reasonable steps to help the applicant to secure suitable accommodation becomes available. And that's informed by a plan that has to be undertaken under section 189A to identify support and steps that need to be taken to allow them to secure and keep that accommodation. The one point I highlight there is that although the definition of when it's reasonable to occupy accommodation is qualified, as Zia explained, so that probability of domestic violence or domestic abuse means that you don't have accommodation, that's not a fully comprehensive protection, particularly because there might be gaps. For example, if the risk is not probable. Probable, Bond says, is more likely than not, but there might be something where the authority could say, well, it's not more likely than not, but of course the consequences, if it happens, may literally be a matter of life and death. And that isn't accommodated in the definition of accommodation. And likewise, there might be serious abuse, which doesn't fall within the domestic abuse definition because the individuals aren't connected. One of the examples given in the code is so-called honour abuse, where you may have people who have got a more tangential connection with the people who would be connected, but who are carrying out the abuse. And so all of those matters can come into suitability, but they don't come in as part of the definition of occupation, of accommodation. One thing that does strike me, I think, going through the code is, and it doesn't differentiate here between the prevention and the relief duties, is the emphasis that seems to be given now, and again, I think it may cut across some of what Zia said, about taking steps to keep victims in their own home. Now, the code is very clear that you ought only to do that when that's what the individual wants. But it talks about a range of things, and this comes not just from the homelessness code, but also another bit of guidance about, it's called Improving Access to Social Housing for Victims of Abuse. And what it assumes is, I think someone has applied as a social housing tenant. But it talks about taking steps, supporting them to make an informed choice, including things like reinforced doors and windows, extra locks, fire retardant letterboxes, and so on, right up to a sanctuary room. And also informing them about the option of applying to a court for an injunction against the perpetrator. Now, obviously, all of those things may be appropriate and will have their place, but one can see that there may be a risk, particularly when this all comes as part of a process of developing a personalised plan. One can see that people may feel under pressure to accept solutions like that when, for the reasons that Harriet was talking about earlier, just applying for an injunction or something like that may well be very ineffective. So there is perhaps something of a tension, something of perhaps an encouragement to gatekeeping, with applicants being potentially put under pressure to take measures sort of a move. What's interesting also is that the code doesn't seem to recognise assistance with management transfers as being a solution to the relief duty, whereas perhaps it ought to be. So those are a couple of points about the suitability of offers being made. I did have some points about local connection. I think, given the time, I'm not going to dwell on those. There's an issue about if someone flees to the area of another authority, do they acquire a local connection? There's a case NJ and Lambeth suggesting that they do. And then I set out here the tests for local connection and when someone can't be moved. The point I highlight there is that the test for not being locally connected to another area is whether you run the risk of domestic abuse, and that of course is a different thing from whether it's probable. But of course, once the local authority has decided not to refer someone, their obligation is then, subject to suitability, only to provide accommodation where it's not probable. So there are some difficulties there about risk and probability, which I won't get into. But this is, I really want to sort of conclude on this point, which is it's particularly pertinent when someone has to move outside an area, because the obligation of the authorities to provide accommodation is suitable. If someone has to move away from the area where they're experiencing abuse, then that may very often put pressure on, perhaps the breaking point of the support links they've got. And so the question then is, how can one ensure that those support networks are either maintained or replicated where they're needed? And it's obviously a part of suitability, and local authorities have an obligation to consider what support is necessary. That's a part of the personalised plan. And they've also got a power to ask local authorities to assist them. And if they do, then local authorities have a qualified duty to provide that assistance in section 213 of the Act. But those things taken together don't easily add up to providing the support. Controlling it through suitability is essentially a negative system of control. If the support isn't there, then the accommodation is not suitable, but it doesn't impose a duty actually to provide the support. And this may be, though, where section 57 of the 2021 Act is useful or potentially useful. And what it's got to do is to assess or make arrangements for the assessment of and so on, and then prepare a strategy for the provision of such support in its area. The accommodation-based support is support in what's called relevant accommodation, which is defined in the catchily named Domestic Abuse Support, Relevant Accommodation and Housing Benefit Universal Credit Sanctuary Schemes Amendment Regulations, 2021. There's a list of things. They include refugees, they include move-on accommodation and so on. But importantly, for the purposes of homelessness, the code of guidance given under the 2021 Act makes clear that you can provide support in accommodation provided under Part 7 of the Housing Act, provided it meets that definition. And so that's the duty. It's the kind of duty we've all seen before, and frankly, strategies like that don't really add up to much often. But it gets a bit more interesting because by section 57(3), a relevant local authority that publishes a strategy must, in carrying out its functions, give effect to this strategy, which is the kind of formula that you don't often have in those strategy-based type duties. And they can request cooperation from another authority, and that other authority must comply with that request so far as reasonably practicable, which again is much stronger than you normally find. There's also a duty to have regard to guidance, again, the fairly standard have regard duty. And that's subject now to the guidance, which is there, that's the title of it. And the interesting thing when one goes to the guidance is just how prescriptive it is. It very often talks, or very often looks, much more like directions from the Secretary of State rather than simple guidance. And I'll just, because time is pressing, I'll just give one example, which is on B6.1, and it says, victims must be able to access the support they need. We expect authorities to ensure sufficient appropriate support is available to meet the needs of all victims, and so on. So in formulating their strategy, they ought to be setting out how they're going to achieve objects of like that, which are obligations of result rather than simply taking best endeavours to do it. And so I don't know how this is now playing out, and that hasn't yet had any trace in the case law, but it may well be that when we go to the Section 57 strategies, we're going to find that authorities have felt obliged to produce some fairly sharp-edged duties on themselves. So that may be a route through which the support can be provided. I'm going to stop there because we need some questions. Thank you.
Thank you, Martin, and thank you to all our speakers. We've got time for 2 questions. I'm going to take one from online and one from the floor. So I'm going to put myself under pressure to choose someone if more than one person in here has a question. I'll do the one online first, and there may be a very brief answer to this. It's for you, Izzy. Someone has asked, must people be married before a victim can apply for a management transfer?
No.
No, there we go.
The same rules apply for domestic abuse. You don't need to be married to go down any route for housing if you're a domestic abuse survivor. So yeah.
Thank you. And before we break from tea or coffee, do we have any questions from, I think there's one at the back here.
Yes, hi. It's actually for Izzy again about the management transfers. I'm Tom Hooksmeyer. I'm from Notting Hill Genesis. And I've always argued actually that under the assured tenancies, we have an obligation to protect our tenants through management transfers. But the problem is, or a problem from our point of view as housing officers trying to persuade managers, is very often to do with our nomination agreements and the amount of management transfers we can carry out whilst we have nomination agreements with councils. Is there legislation or case law you think that can help with that?
I think this is very specific, but when you say nomination agreements, your agreements with local authorities as to providing housing that is coming from them, essentially from a homelessness route. Yeah. And where would that be relevant if you're dealing with stock, your own stock? Because you can do management transfers with your own stock, but might it be that you don't have enough?
Well, I think that's the problem. If we had, I mean, we don't know yet, obviously, it'd be a difficult thing to do. But I'm concerned that given when I was in homelessness, often 45% of the caseload of homeless applications were domestic abuse victims. If you were to then have those kind of numbers coming through as management transfers, I could see us barely having anything to allocate to social housing outside of our own stock.
I mean, I actually don't know the answer to that question. I'd say I'd just apply the same law. Like if you have a management transfer policy, you have to give effect to it, but I don't know the ins and outs, sorry, of the nomination agreements. But maybe someone has an answer. Yeah.
One way of dealing with that is to have the local authority do the management transfer process across the whole board with the other partner housing associations for whom they have nomination rights in that borough. So with the management transfer, the person might not end up in council housing, they might end up in housing association housing, but quite a lot of local authorities do that, where the management transfer request gets referred in from the housing association to the council. They make the decision, the person then gets that priority. And it just seems to me that quite a sensible way of doing it, because then the person gets a much larger group of properties to choose from, rather than just being stuck. If your housing association is really small, a management transfer, it might take 4 years before anything comes up.
Yeah. I think that makes sense. And like in that case that I said before, that was what happened. The housing association had the property, but the local authority where the housing association was kind of took control of the management transfer itself. So I don't know if that interferes with the nomination agreements you have, but if it doesn't, that would be a route.
Thanks, Izzy. Martin Wazir, did you want to chip in
No,
anything there?
not for me, no.
Okay, thank you.
Oh, I just wanted to say one more thing.
Yes.
Sorry. We've got a domestic abuse and housing forum that I thought I would just plug. It's for any practitioners working in this area, so I imagine everybody here. And it's a free forum for lawyers, frontline staff to share referrals, questions that you might have and lawyers can answer. And it's just trying to bring people together in this specific area because of all the complexities that there are, and trying to tackle it together rather than in silos. So if you want to join that, you can email our office email, which is office@pilc.org.uk, and we'll add you onto the forum. office@pilc.org.uk.
Thanks, Izzy. And thank you to all our speakers. Thank you, everybody, for listening. And we'll break now for tea and coffee and see you back in here at 11:45.
Thank you all for making it today. My name's Alice Irving. I'm a barrister here at Doughty Street Chambers. And what we've got sort of today before lunch is a little bit less legally focused and a bit more sort of soft skills focused. I think those of us putting together the conference, we're very aware that as lawyers, we're often tasked with working with incredibly vulnerable people, and we're not necessarily always given the tools or an opportunity to talk about how we do that safely, both for ourselves and also for the individuals we're working with. And so we thought, given that we've got people here today who are interested in housing and domestic abuse, it would be a fantastic opportunity to get some frontline people not working from a legal perspective to come and talk to us about how we work safely with individuals who have experience of domestic abuse. So I'm really, really thrilled to have two women here today to talk about that. We've got Saskia Hagelberg, who is at Solace Women's Aid, and amongst many other things she's done, she manages a project providing support to survivors of domestic abuse and sexual violence, with a particular focus on LGBTQ+ individuals. She, in that role, provides training to the NHS, social care and other voluntary services. So we're thrilled to have her here today speaking to us about working with survivors of domestic abuse. Saskia is also experienced in working at a homelessness charity in South London. I was about to say South Auckland. I've just got back from New Zealand. That's a long way away. And she's also a proud advocate for sex worker rights. So we're really privileged and thrilled to have her here with us today. And then into the table here, we've got Laura Tomza. She's the Children's Service Manager at Bernarda's. She's worked there for over 10 years. And her current role includes being a strategic lead for domestic abuse across the region. So she's got a really strong passion for working with families who are impacted by domestic violence, and she's here to bring us that sort of rounded out perspective, thinking about families and impact on children. And in particular, she's been involved in pioneering whole family approaches to domestic violence, which have been the subject of academic evaluation with really positive feedback. So I'm sure she'll have fantastic things to say. So just to give you an idea of the shape before lunch, we'll hear from Saskia and Laura, and then hopefully turn out for some questions, and that will be an opportunity for us to reflect on how we work as lawyers with individuals who've experienced domestic abuse. And then off the back of that, slightly linked to the sort of talk we've got here from Laura and working with children, Xu Xinlu, who's a barrister here at Doughty Street Chambers, who I'll introduce more fully when we turn to that session, will be talking just a little bit more about how issues relating to children intersect with domestic abuse and housing. So I think I have spoken enough, and I'm thrilled to hand over to Saskia, who's going to kick us off today in talking about working with survivors of domestic abuse.
Hi everybody, thank you to Doughty for having me. I'm really happy to be here. I'm actually going to start with a personal anecdote to really highlight the immense responsibility that we have as professionals working with survivors of domestic abuse. As well as working with survivors in a professional capacity, I'm also a survivor myself. A few years ago, I ended a relationship with an abusive ex-partner. And after I ended that relationship, I was subject to months of stalking, harassment, threats, and I was fearful for my life. I went to the police for support, and after I recounted some of the most traumatic experiences that I've had in my life, the first thing the police officer said to me was, "Why would you choose to be with somebody like that?" So as you can imagine, in that moment, I was utterly devastated. I was completely devastated to have my experiences of domestic abuse equated with poor decision making. I felt ashamed, I felt embarrassed, and above all, I felt completely undeserving of help because I felt as though I was being blamed for what I had experienced. Now that I work in this sector, I know that this is unfortunately a really common experience that survivors have when reaching out for support, which it should be said is a really difficult thing to do in the first place. Also working in this field, I now know that the best predictor of recovery from trauma is safe and supportive relationships, as well as feeling listened to, feeling validated by professionals. And if survivors don't have this, the potential impact, both short-term and long-term, on mental health can be devastating. So this, I hope, highlights, as I said, the responsibility that we have as professionals and how important it is to really be intentional with our encounters when we are working with people who have experienced trauma. So as professionals, we need to be compassionate, we need to be sensitive, and we need to be trauma-informed. Being trauma-informed means understanding that trauma can impact somebody's neurological, biological, physiological, and social development. So we really need to be able to consider that when in our interactions with survivors. And this in particular means paying attention to what our expectations of survivors are. So are they realistic? Are they fair? And above all, are we expecting somebody who's been traumatized to behave as if they haven't been? So trauma's impact on the brain is really significant, To name a few things, it impacts concentration, it impacts memory, it impacts sleep, among a lot of other things. And we really need to be considering this. So in particular, when we're asking survivors to provide details about the abuse that they've experienced, which is something that we have to do, it's really important to be considerate about this. And also, if somebody's account isn't coherent or chronological or detailed, are we questioning their account or even not believing them? If we do this as professionals, we can inadvertently create barriers to survivors accessing potentially life-saving support. And I can provide an example of this. I'm working with a vulnerable woman at the moment who is experiencing very high-risk abuse, and she has done all her life. She's in her 40s currently, and she needed housing, actually. So I know I'm not here to talk about law, so I won't, but she needed emergency temporary accommodation. So she approached a local authority, and unfortunately I couldn't support her with that call because it was out of hours. But what I heard the next day when I came into work was that when she was called by this local authority to do the initial assessment for housing, she was asked to provide every single incident of abuse that she had experienced in her entire life, including names, including dates, including addresses and corresponding CRIS numbers if she'd reported to the police. She completely panicked and wasn't able to say anything because she was traumatized, she wasn't sleeping, and as we've mentioned about the trauma impact on the brain, her memory was impacted and her concentration. So she wasn't able to say anything to this person that was asking her for details, and she just panicked and shut down. So she was denied temporary accommodation, and she was denied temporary accommodation because she didn't meet this person's expectations of what a survivor should present as and how they should articulate their own experiences. So it's really important. I think this highlights exactly how we really need to be considerate. And if people don't meet our expectations, you know, what does that mean for us as professionals, and how are we continuing to work with that person? Are we just immediately putting in a barrier for that person to receive support because they don't meet our expectations of how a survivor should speak to us about their experiences? I think it's also really important to consider that abuse is about power and control, and it's about the abuser gaining power and control by taking it away from the survivor. So we should always be considering that survivors have been disempowered, and we should be really careful as professionals not to recreate that dynamic. So for example, whenever I'm due to complete an assessment with a survivor, which involves completing a risk assessment, asking personal and difficult questions, I will in the first instance warn them that some of the questions that I'm going to ask may be upsetting, they may be difficult, and at any point that they need to take a break, they should do so. If they can't continue with the assessment today because it's too difficult, we can reschedule. So it's about kind of being flexible and giving as much power and control to the survivor as possible. This also involves, you know, giving them control over the language that they use, the pace at which they talk about their own experiences. And I'll give you an example about language. When I'm working with survivors who have experienced sexual violence, a lot of them will say that they've been forced to have sex, as opposed to saying out loud that they've been raped. And I think that's because for a lot of people, there's a real discomfort with saying out loud that word. And if somebody's saying that, I think it's really important to mirror their language. They have a right to identify their own experiences in a way that makes them feel comfortable. So be mindful of that. You know, if somebody's choosing to use a different word, mirror that language, use that language with them, let them go at their own pace. I also give people the option, if they're struggling to actually verbalize their experiences, to write it down. And taken all together, giving people options and being flexible, it conveys compassion, and it shows above all else that you're willing to prioritize their comfort above all else. And all of this is really going to help to develop trust with the survivors that you're working with. And also, at best, this working professional relationship could actually aid the recovery of the survivor, who's probably been disempowered and victim blamed by many other professionals before they've come to work with, you know, yourselves, lawyers. I would also say that an awareness of abuse is really important if you are working with survivors. I mentioned earlier about the police officer making me feel responsible for the abuse that I had experienced. So not only was this an ignorant statement, but it's really, really harmful because it's an extension of what abusers will often tell the people who they're victimizing. So, you know, abusers will often say things like, you know, I only hit you because you made me angry and you know not to make me angry, or I only did that because I love you so much and you know how to make me crazy. These are all things that survivors tell us that abusers say to them a lot. And abusers are very good at making other people take responsibility and accountability for their own behavior. So it's also important to say that this self-blame and shame is a barrier to asking for help. So it's probably prevented that person from seeking out help in the first place. So when that person does reach out for help and has disclosed the abuse, they will have probably experienced many incidents before that. So as professionals, we really need to be mindful of not saying anything that will make that person feel as though they are to blame, because we are essentially recreating that dynamic that they had with their abuser. Another thing that's really important is to not question reactions to abuse, especially in the immediate aftermath, but anytime really. So why were you with them? Why did you not leave? Why did you go back? All these questions are just examples of victim blaming. And again, we're placing the onus on the survivor to act in a way that will somehow, they'll be able to prevent the abuse that they're experiencing or not. And really, we need to direct the responsibility to the perpetrator, because nobody can take responsibility for anybody else's actions. And it's really important that that is a line that we all take. Bear with me. So this is also the case with sexual violence, and I'm referring to questioning people's responses to things. So often, and I've heard professionals say this, you know, why didn't you say no? Why didn't you fight back? That kind of thing. And not only are these also examples of victim blaming, but they're also underpinned by a flawed idea that you actually can control your responses to trauma, which you absolutely cannot. There are 5 trauma responses. Most people have probably heard of fight or flight, but there are actually 5. There's fight, flight, freeze, friend, and flop. And so flop and freeze, they're quite similar to each other. They basically refer to your body just kind of freezing and you not being able to move. Fighting and flighting. I think most people are familiar with those. And friend is about kind of appealing to the person who is going to do you harm so that you can try to make yourself less of a target. And these trauma responses are actually a biological mechanism, and we have very little control over how these happen. So, you know, if somebody was to throw something at me now, my response would be largely involuntary. I wouldn't really have much control because it would be, you know, an instant response. And when people experience sexual violence or domestic abuse, a lot of the time it is that biological mechanism that takes over, and people do have very little control, at least when faced with immediate danger, how they respond. So if you're asking people why they didn't behave a certain way, or even asking them why they did respond a certain way, that can be really harmful for a survivor. And having worked with a lot of survivors of sexual violence, I know that there is so much self-blame in sexual violence, and in particular also with domestic abuse, but obviously we know that the two are related. And people who experience sexual violence, I can't tell you how many times people have said to me, you know, my body just let me down, I didn't fight back, I wish I'd done more to protect myself. And actually, it's really helpful for us as professionals to be aware of sexual violence and domestic abuse myths, because not only can we make sure that we're not imparting those and harming our service users by re-traumatizing them, by exposing them to myths and stereotypes, but we can also gently challenge them when survivors talk about blaming themselves And that's also really important for aiding the recovery in survivors. So I think just one last thing that I want to say about sexual violence as well is around, which is related to the myths, is one about talking about kind of your body's physical reaction to it. One that's not very talked about, I think, because there is a lot of shame and kind of guilt, and people don't speak about this a lot, is it's quite common for survivors for their body to kind of have physical indicators of arousal. So, you know, like if somebody has a penis is being sexually assaulted, they could get an erection, or somebody with a vagina could experience vaginal lubrication, and also can even experience orgasm. And this is actually quite common from the little research that has been done about this. It's actually quite common for survivors to experience. And survivors will often, this will often create an additional barrier, because people will feel like, well, maybe I did consent, but I don't think I did, but my body let me down. Again, we're seeing kind of common themes around this. And again, I think there is something around sexual violence, I think, that people are less comfortable talking about than domestic abuse, but the two are related, and often sexual violence does happen a lot in domestic abuse. And I think it's really important as professionals that we don't shy away from these conversations, and that we're able to, if a survivor does disclose something like that, we have enough awareness and enough knowledge to be able to tell them, you know, that's really normal and that's not your fault, and that doesn't mean that you're any less of a victim. And I think we should shatter that whole kind of perfect victim and what that looks like, because it's oh, I nearly swore. It's not good. Yeah, that's it before I actually do swear. Thank you so much, everybody.
Amazing. Wow, I don't know how I'm going to follow that. That was really good. Thank you. And a lot of everything that you were talking about just kind of encapsulates a lot of what our service does. So it was really nice to hear that. So my name is Laura Thompson. Let me just pull up this. And I'm a children's service manager for Barnardo's. So part of my role is being the strategic lead for domestic abuse across Cymru and the southwest region of England. And I also manage and oversee our criminal and sexual exploitation services that run across Avon and Somerset. So I'm really grateful, first of all, to have the opportunity to be here today to talk about the links between domestic abuse, homelessness, and children's outcomes. And working for a children's charity, we understand the complexities that lie within children's circumstances, and how sometimes navigating through safeguarding can be quite challenging. But ultimately, it's really important that we get things right. So I'm going to talk a little bit today around some of the best practice in response to domestic abuse, some of the challenges, the impact of domestic abuse, and also some of the ways in which we're trying to influence change now as well across the sector. Okay, so working with domestic abuse in terms of sort of victims and survivors. So children are victims of domestic abuse. At least 1 in 5 children will be exposed to domestic abuse, and this is what we currently know. We know that a lot of domestic abuse happens behind closed doors. We know that a large proportion of children on child protection registers and are in local authority care have been subjected to domestic abuse. In terms of the exploitation services that I oversee, probably over 90% of children have been exposed to domestic abuse throughout their childhood. So the prevalence is huge. We know the impact, which we've already sort of spoke about, around the trauma can impact on their brain development, their ability to form friendships, social, mental health issues, education. So it's so important and vital that they also have access to support services. But sadly, it is a postcode lottery currently, and if there are services available, they're often extremely long waiting lists, or they're just not necessarily flexible enough to be able to meet everyone's needs. The domestic abuse bill is great in that it recognises children now as victims, but there's still that lack of funding and opportunities for them to be able to access support services. So as an organisation, we are really lobbying and campaigning for that in local governments to ensure that local authorities do have the resources that they need to be able to provide that. So in terms of what works with regards to domestic abuse, from 2019 to 2022,
I developed and mobilised our whole family approach to domestic abuse. Our project was funded by the Home Office under the Children Affected by Domestic Abuse grant. And we developed this model looking at in the current area in which we were delivering this, which was across South East Wales, so across 5 local authorities in Gwent. There was support for adult victims, predominantly women, which tends to be sort of the case across the UK. But there was very limited support for children and young people, and what was available, as I said, had really long waiting lists or wasn't necessarily flexible enough, and there was limited to no support available for perpetrators. So as a children's charity, we know that we absolutely need to work with children and their families, so we wanted to provide a provision that met that gap, but also looking at domestic abuse, we need to be able to tackle the root cause and the problem, so that requires us to be able to work with perpetrators. So we developed our model, which provided support to the adult victim. And we did work with male victims, female perpetrators and same-sex relationships, but probably 95% of the cases were female survivors, male perpetrators. So the female sort of survivor work would consist of immediate sort of risk management, safety planning, and then taking them on a trauma recovery journey. So they would have access to group programs with other survivors. They could also have access to one-to-one. It was no time limit in terms of how we would support that. It was really relationship-based work as well, recognizing the trauma that they've experienced, so taking them through that process. And often if they're still in the height of that kind of risky behavior that's taking place, they weren't necessarily in the right place then to be able to go on that recovery journey. So it's moving them through that sort of transition. We provided support to children and young people, so giving them a safe space to be able to make their feelings heard, have an opportunity to understand what's been going on for them. Again, really taking a trauma-informed approach to that and advocating for them, and through sort of that process, as a lot of the children we were supporting were subject to child protection plans or potentially being at risk of going into foster care or being adopted. And then we provided support to the perpetrator as well. So that it consisted of our 20-week behaviour change model, which again kind of did take a trauma-informed approach. Probably about 90% of the men on our programme had experienced domestic abuse as a child. They'd experienced at least 3 or 4 more ACEs growing up into childhood. So it was an opportunity for them to sort of reflect on their own upbringing, giving them a space to be able to understand their own emotions and feelings whilst holding them accountable for the behaviour that they've perpetrated. And then sort of through that is working in a multi-agency approach with children's services, police, and MARACs and everyone else that sort of comes around that table. We were evaluated by the Institute of Public Care at Oxford Brookes University, and we had a really positive evaluation. And the model itself has been sort of recommended in terms of how we should be working with domestic abuse. We have to work holistically. We have to work with our whole family to be able to impact any change. So there were a number of outcomes that were identified. So particularly looking at sort of having a safe and stable home environment, child to parent relationships improved, children saw a reduction in emotional stress, their emotional and mental health improved, sort of more positive peer relationships, improvements in their education. Families were able to recover from the abuse, and some families were able to stay together safely, but also some families were able to separate safely as well, and it was what was best for that family unit. Clearly, in order for us to virtually meet all of these outcomes, it was imperative that the children we supported had a home in which they felt safe and able to thrive. And the Institute of Public Care found that over 80% of children that were open to us reported that they were living in a safer and more stable environment at the end of our intervention. And this is a model, despite us not having funding in Gwent to continue this, as Home Office funding is often fantastic in setting things up, but then sustainability is almost impossible currently in the current climate. It is a model that we are sort of promoting, is what we're looking to sort of develop across the UK, but unfortunately, as I'm sure you probably recognise, the funds in sometimes doing that is a real challenge. So what makes a home a home? So according to the Housing Act, homelessness does not solely mean the lack of a home. So a person could be treated as homeless if they have no housing that is reasonable or safe, including being at risk of violence. So therefore, children that are being exposed to domestic abuse are often classed as homeless, even though they have a roof over their head, because they're living in fear, they're not feeling safe in a place in which they should feel most safe. We also know that unfortunately children that are exposed to domestic abuse, they may need to flee their home and go into refuge. And sometimes this cycle can happen quite a lot during that process. We know that sometimes families resume relationships because of the nature of domestic abuse, so there's often that flitting back and forth. Unfortunately, there are often cases where children have to be removed from their parents, going into looked after care, placed in emergency accommodation. And there is a real shortage currently in terms of suitable placements across the UK. And we've had many children, young people being placed in B&Bs and hostels overnight, which is just not appropriate. So naturally, kind of this just continues to impact on their mental health and well-being. So from a psychological and development standpoint, a child's home should form the foundations in terms of meeting their physiological needs, such as warmth, shelter, nourishment, and safety. And we can see here through Maslow's hierarchy of needs, this just encapsulates how important meeting the fundamental needs are. And if we can't achieve that basic level, then it's almost impossible to move up to the next. So in terms of thinking about the impact that all of this has on children in particular, we know that having a community around you, having your peers, having your social network, having education is so fundamental for children and young people to be able to develop their social emotional skills. It allows them to develop communication skills, empathy, problem solving, cooperation. So whilst they're kind of experiencing a really turmoil and traumatic experience as a result of being a victim of domestic abuse, they're now being forced to move from that environment into a completely different environment without those pillars of support around them. And we can't underestimate the extra sort of impact that has on their mental health and well-being, the impact that has on their ability to be able to forge new relationships. It can make it really difficult for them to be able to regulate their emotions. And if they don't have access to specific specialist support during that time, the longer term impact in terms of their progression through adolescence, they're going to be at more at risk of being incarcerated, being involved in domestic abuse relationships themselves, alcohol issues, mental health issues. And it's just imperative that they have access to the appropriate services so they can have an opportunity to recover from that trauma. I'll just read a little case study as well, which is from one of our services, which just demonstrates the impact for one of our families that did have to move into refuge. So a family were referred into our open and closed doors service from a referral from the local authority safeguarding team following a domestic abuse incident perpetrated by father, which resulted in him being arrested. Following the referral, mother disclosed that she'd been the victim of domestic abuse on a daily occurrence for the past 12 years. Father breached his bail conditions and continued to return to the family home. Due to the risks he posed, mother and the children were moved into a refuge, but unfortunately, due to shortages, this meant that they were placed sort of really far out of their home community. The impact of the family has been significant. Mother and children have lost all of their connections, their friends, their family, and they're feeling far more isolated now, which is having a negative impact on their mental health and well-being. In addition to this, the children have started a new school, which has been a huge challenge for them. Mother and children have had to have a complete change of lifestyle, whilst father continues as normal in his community, interacting with his friends and living in comfortable surroundings in the children's home. And I think this case just demonstrates just that impact, that not only the domestic abuse, but then that impact of having to kind of move completely into a different area. And we're not underestimating that sometimes that is essential, because safeguarding and safety of that family is imperative, and sometimes that has to happen. But we need to appreciate the systems, all of those, that community, their social networks play a huge role in being able to support families through this transition. So if we're removing them from that, we need to make sure that there are other systems in place to support them. Our service was fortunate in that we were able to travel to continue to support this family through that. But there are some services, due to commissioning sort of guidelines, that they just wouldn't be able to do that. And we're just setting families up to fail then. So in terms of influence and change, what are we as an organisation trying to do? So part of our Open and Closed Doors project, we developed our women's strategy. which we piloted with Newport City Council. So we're really fortunate to have a strategic partnership with Newport, which allows us to be able to sort of develop some of these tools and strategies before rolling them out to further local authorities. So the strategy explores the issue that mothers are often held responsible for the abuse that they do not perpetrate. So social work interventions tend to focus not on helping the perpetrator to cease their abusive behaviour, but on the mother's responsibility to keep the children safe. So you often get that leave ultimatum, you must make sure that he does not enter the property, or we will remove the children from you. And it's just that continuous emphasis that the mother must do everything, whilst the perpetrator is not often pulled into the child protection plan even, or through the discussions in terms of the responsibility, I'd say, needs to be on him. So we're trying to promote a change in culture, increase understanding in professionals, and while safeguarding and safety is absolutely paramount, we're looking at alternative ways in which we can ensure that this family remains safe, whilst putting the emphasis back on the perpetrator. So some of this includes training to frontline social workers and team managers. And the training consists of sort of multiple layers. So in particular, looking at coercive control, which I know we've spoke about today, which continues to be a form of domestic abuse that is often unreported, is not recognised in the severity, it's just minimised really. So we're trying to increase the understanding and awareness of that, and looking at particularly around the impact it has on children and young people. We've had to really escalate some cases where they don't necessarily see the emotional impact it has on both victims. So it's bringing that understanding to social workers so that they're able to then act accordingly. It's looking at victim blaming language that we often use, that in sort of submitting reports, writing assessments, and this gets shared into courts. So even things like, people will often say, mother is not engaging in services. And it's not that simple. We need to look at, well, our knowledge around domestic abuse is that there's a perpetrator saying, if you engage in those services, I might do X, Y, Z to you and the children. So mum is trying to keep herself and the children safe. So we can't, again, put that back on her as just not choosing to engage. But we can only kind of make that clear in terms of our reports if we really understand the complexities of domestic abuse. And again, looking at the, as I say, safety plans that are put in place, you cannot let father into the property. Again, that's not always appropriate for us to do. We need to understand how we can do that sort of safely and not set mother up to fail by the expectations that we're putting out. We're also sort of consulting and being experts in terms of managing cases and supporting children's services with appropriate plans, and giving them directions in terms of how we should manage domestic abuse cases. And again, looking at support services where we can see that the whole family is getting access to the relevant support, bringing the perpetrators in to the conversation and holding them responsible for their actions. So I'm just going to summarise, I don't know if I'm going over on time. So just some key considerations and things that obviously we would absolutely promote. The child's voice is absolutely key. They need to have an opportunity to share their experiences, to understand their experiences, and to be able to sort of reflect, express themselves in a way to be able to recover from their trauma. We need to really consider the community that sits around that family and the value that that has, and the safety and the support networks that sit within that. And yes, absolutely, we have to do what's right for that family, and sometimes that means removing them from that, but we need to make sure that there are systems in place then to support them on that journey. We need to understand the whole risks of the family, and to be able to do that, we need to really look at holistically, so assessing everyone's needs and ensuring that we're working with all elements of that family, including the perpetrators. We need to be able to understand the complexities that lie within relationships and the prevalence of domestic abuse, and have a really clear understanding, particularly around that coercive control element. And then we need to be able to be promoting solution-focused approaches so that we're able to move families on and give them the support that they need so they can achieve positive outcomes. So my key messages would be a home is so much more, as we've talked about. Children's voices absolutely need to be heard, and safeguarding is everyone's responsibility. Everyone in this room has a responsibility to safeguard the children and families we work with. Everyone has a duty to respectfully be curious and ask those questions and understand and be aware of what support is available so that we can make sure everyone has, as I say, has that opportunity to succeed. and overcome the trauma that they have experienced. Thank you.
Thank you so much, Saskia and Laura. It's wonderful to have that broader picture, because I think as practitioners, we also need to be thinking holistically and to be aware of the language we use and the myths we might come across in the documents that we receive from professionals, experts, the responses we receive, but also the myths we might perpetuate unknowingly if we're not alive to the broader picture. So we're so grateful for the expertise you've brought and shared with us today. We've got an opportunity now to ask some questions of Saskia and Laura before we move on to hearing from Shushin Lu a bit more about the legal framework as it interacts with children, children's issues in this domain. I don't think we have any online at the moment. I hope you're all awake and actually at your computers. But if anybody in the room has any questions that they would like to ask, now is your moment.
Yeah. So we often have clients who say the perpetrator might either be in custody or that's not an issue anymore, but they're remaining in the homes where the abuse happened, and they're saying that that's not somewhere they can stay, and it's not reasonable for them to continue to live there. Could you just speak a little bit about what sort of arguments we can put forth to say that that's not reasonable for them to continue somewhere that might be re-traumatizing them?
So are you saying that the perpetrator is still living in the property with the...
No, the perpetrator's not there. So quite often I'll have a local authority say it's safe now, the perpetrator's in jail or whatever, but the family are saying they can't remain there because that's where the abuse has been happening.
Oh, okay, yeah. And I guess that comes back to some of the work that we're doing around that women's strategy. It's about educating sort of professionals to understand, and even things like when we're working with clients, and I'm sure you'd be the same, is thinking about the environment. We wouldn't have a session with somebody that may have a smell that's triggering to them, or so it's all of those things about them getting to understand trauma. So being in that environment, they're continuing to see that on a daily basis. That's only going to be detrimental to their sort of mental health and well-being, and getting them to understand, that impact of domestic abuse. So I think it's just about really sort of promoting that and bringing the evidence to light that we know that the impact it has in terms of their sort of brain development, everything, and being really sort of clear in terms of why that's not appropriate for that family to stay there. Because if mum is still experiencing that and there are children present, then the children are continuing to sort of, that's just continuing to happen for them as well.
I think also, if I could just add quickly, there might be just because the perpetrator's in custody, it might not mean that the risk is completely removed. Mm-hmm. So it could be, I don't know, gang affiliations, or maybe there's family or friends of the perpetrator that, maybe mum doesn't want to be, that she doesn't want to be around, So I think it's important to look at not just hone in on what risk the perpetrator poses, but also things surrounding that. But also the perpetrator presumably won't be in custody or in prison or whatever forever. So then this is just an issue that may have to, it's going to have to be dealt with down the line anyway.
So quite often we're asked to produce evidence, and obviously we are no experts in this field. I think it would be really helpful to have a resource or some resources that we could refer to that would support our arguments. I don't know whether they'd be academic or otherwise. GPs we find aren't enormously helpful. Are there resources that you could recommend that we could use as references to support what we all have heard today, but recognised resources that we could refer to in our submissions?
Yeah, I mean, there's lots of providers that are delivering training, and on a side note, we're always happy to do that as well. But Safe Lives is a great sort of tool to sort of access. They do a lot of the sort of risk management as well around survivors of domestic abuse. So the Dash, if anyone's familiar with that, that's a Safe Lives tool. But there's a wealth of sort of information on there as well, and various links that you can go to that can just kind of support that. I don't know if you'd add anything else.
No, I think a lot of the time with professionals as well, they put a lot of emphasis on evidence from other professionals. Is that what you mean, like corroborating evidence? And I think part of the job of an advocate is also to highlight that the experiences of the survivor is also evidence, and that should be taken really seriously. You know, if someone's saying that they're frightened, I think, you know, professionals often assume that they know better or that they can identify or whatever, but the testimony of the survivor themselves is absolutely the most important thing.
I'll stand, you can't see me. In your case study, you mentioned that you were able to provide resettlement support to a family that were moved out of their community, out of their location, suggesting that this isn't something that's always kind of possible. In terms of commissioning, what would you like to see being offered in regards to resettlement support?
This is me. So in terms of commissioning, I think it's just that flexibility. I say we were really fortunate with our commissioner being the Home Office, and that we didn't have time scales attached to the support we could provide, which is really important in working with domestic abuse, working with any form of trauma, exploitation as well. That relationship-based work takes time initially to get people to trust you, to be able to take them on that journey. And sometimes some services, some commissioners, you have 12 weeks to deliver an intervention, which is just unrealistic. But there are often restraints in terms of the geographical area in which you're providing that. So it's just having that flexibility and that fluidity to understand that domestic abuse isn't stagnant, it's going to change, and we need to be able to adapt to that. So my message to commissioners would just be to allow us to be flexible. We know what we're doing in terms of kind of, we're managing our resources best we can, but we've got to be able to meet the needs of each individual. We can't have a one-size-fits-all service. And sometimes obviously funding and sort of how those cuts get tighter and tighter and the resource shrinks, you know, can make that challenging. But if we want to really see an impact and have longer term outcomes, and we don't want families to continue to come back through that, then we need to sort of invest in that in the longer term.
Thank you so much both for your thoughts. It's been really, really amazing to hear you. I have a question about sort of the way that the law and your obligations as a solicitor and potentially a barrister might conflict with your desire to prioritize the mental health and well-being of your client. And the nature of legal work I've found is that there are sometimes deadlines that are non-negotiable. For example, you know, the time limit within which to bring a really important claim is running out. And I've sort of grappled with negotiating the balance between these two things, and I'd be really, really grateful for your thoughts on this. Sort of how do you balance the sometimes competing priorities of making sure your client's position is protected, making sure they comply with the court rules and the legal process, but also ensuring that doesn't come at the expense of their well-being?
That's a really fantastic question, and it's why I'm not a lawyer, but I also, I think it's really, I mean, I think it's really important if there are things that you can't, as much as you can control, you prioritize their safety, their comfort. What you can't control, you can't control. And what I would say, you know, I'm constantly having difficult conversations with my clients in terms of, you know, housing have said that you're not able to get this, you know, oh, you went to court and this person wasn't convicted, constantly delivering bad outcomes. But you know what? So much of it is about validating and conveying belief and just saying, you know what? This is really difficult and you've been really let down. And you know what? Sometimes these systems, and often, mostly always, in fact, these systems don't work in favor of the survivors. And I'm really sorry. I'm really sorry that it's so difficult for you. You know, like it's those little kind of nuggets of compassion that go a really, really long way, because you don't have control over everything. You can't kind of like wrap them in cotton wool and make the situation kind of perfect for them. So yeah, that would be my advice, and that's how I deal with it.
And I think it just goes back to that sort of the strategy that we're talking about, that culture change. It goes beyond children's services. There's so much that needs to change in the justice system and the legal system that's just constraining families, and that's going to take a long time. But I think just advocating for that, and as you say, kind of getting those messages across is sometimes all we can do.
So we've got a question online, which then actually segues quite nicely into Shushin's presentation. So I'll do that question. I know there are more questions in the audience, but I'm afraid I'm keeping time diligently. So perhaps in the lunch break, we can pursue those conversations further. So the question I have is, do you often see children's services pushing the victim or survivor to obtain a non-molestation or non-occupation order, which might in fact increase risk?
Sometimes, yeah, it can increase risk. And I think that's, again, I just go back to the importance of that whole family approach as well. So we've almost got eyes on everyone within that family. And we're able to kind of work really holistically in managing that risk. It's about, as goes back to kind of the police as well, kind of bringing them on this journey and training and awareness so that those orders are actually utilized as best as they can be. So it can be a challenge, but I think that just stresses the importance as, yeah, that's why we all need to work holistically really to make sure that we're trying to manage that as best as we can.
Anything further?
No,
or-
just
Fantastic.
Yeah, absolutely.
Okay, well, thank you so much, Laura and Saskia. We're going to turn now just to hear from Xu Xin. Xu Xin Liu is a senior junior barrister here at Doughty Street, who's an expert in all areas of public law. It's a bold claim, but one that is in fact true. She has a strong human rights, civil liberties, and anti-discrimination focus in her practice, and she spans practice areas of community care, mental health, healthcare, education, housing, welfare benefits, immigration, and asylum. So when we talk about working holistically, I think Xu Xin is a exemplar to us of that sort of lived in practice, able to bring a wraparound approach to clients, which is really fantastic. Xu Xin is going to be speaking today, following on from what we've heard about particularly the children's perspective, about some of the tools that we have as legal practitioners when it comes to addressing the needs of children who might be our clients or might be sort of the children of our clients. So without further ado, I'll hand over to Xu Xin.
Thank you, Alice. I was given quite a wide brief for this topic, so I hope I've kind of done it justice. But I thought we would start with just looking at the scale of concerns for children in the context of domestic abuse, and then look at the tools in our toolbox, both at an international level and then a domestic level. And then I want to look at the Domestic Abuse Act, because that is obviously the flagship of what the government says that they've accomplished in this area, what it does for children, how that has improved, and then where the protection gaps are from a legal perspective. So just some statistics. Pre-COVID, I mean, when I was doing this, I was quite shocked by these statistics. So it's a shock factor to tie you over before the lunch break. But 831,000 children in England live in households that have reported domestic abuse. That's just pre-COVID. I dare not think what has happened because of COVID and after COVID. The government publishes children in need characteristics, and one of the main feature is that domestic abuse is one of the most common factors for children being assessed as in need, and that's 1 in 4 children. And I think I was reading one of Bernardo's briefings in the domestic abuse bill, and I think they were talking about 600 assessments a day in children in need, assessments a day across the country. So that's the scale. And then when you look at what is actually being provided at the local level, before we talk about the domestic abuse bill, you've got 2 out of 3 local authorities in England and Wales where children face barriers. And more than 10% of local authorities don't have anything specific for children who are affected by domestic abuse, and more than half time limited, and 2/3 requiring parental engagement, which follows on from what Laura was talking about earlier. And then you talk about different contexts of domestic abuse, because domestic abuse isn't actually just in the household. And in these are the statistics that shocked me, and something that I've not really thought very much about is children in domestic abuse situations in intimate relationships. And there's not actually a very clear picture because no data is really collected on this. But young people aged 16 to 24 are at most at risk of domestic abuse of any group, and that's ONS census data. 16 and 17-year-olds experience domestic abuse for an average of 1.5 years prior to accessing support. So that means that they were under 16 when the violence happened. And the NSPCC did a study in 2009, so yes, it's quite old, but those statistics you can see on screen are quite shocking in terms of the percentage of both girls and boys experiencing emotional and physical violence within intimate relationships. And a more recent study that the Welsh government did of 74,000 students also spoke of a very shocking proportion of children, girls and boys, facing emotional abuse. And again, a majority of local authorities don't know what to do with this. They don't know how to deal with under 16s who are experiencing intimate relationship abuse, with only 39% having any kind of specialist support at all. So that's the context that we're faced with in the UK. What are the obligations? Well, I think most of us are familiar with the UN Convention on the Rights of the Child, and most of us have at some point somewhere quoted Article 3 at a local authority or government department as to the requirement to have the best interests of the child as a primary consideration. But I'd also like to remind ourselves that, you know, Article 3 is not the only article in the Convention, and that actually it is an anchor for enforcing and realising other rights within the Convention. And obviously, the one that's most obvious in this context is Article 19 in relation to the state's obligations to put in place legislative, administrative, social, educational and policy measures to protect the child from all forms of physical, mental violence, injury, abuse, neglect, etc., etc. And obviously, forms of violence would, in that context, include domestic abuse, but also other kinds of violence within the domestic household against children, like forced marriage, FGM, corporal punishment, child trafficking. And the legislative and social policy are not, as oftentimes are assumed, to be criminal justice policy measures, but also safe housing and social welfare support. And Article 19.2 just kind of expands on that a little bit, that it's not just about support for the adult who might be the primary victim, but also children have a freestanding right and need for specialist support for their position as victims of domestic abuse. And needless to say, Article 12, as to the right to be heard, is very unique in the context of the UNCRC, which is the right, freestanding right of the child to have their voice heard, something that Laura has picked up on as well. And they are to be treated as a victim in their own right. So that's the UNCRC, but we also have the Istanbul Convention. The full title of the Istanbul Convention is on preventing and combating violence against women and domestic violence. So it's not just a convention about women's rights, it's a convention about domestic abuse and domestic violence. I mean, obviously, the UK always has to be contrarian and not use domestic violence, and they'll have to pick their own term, but there we go. Yes, the convention is focused on women and girls insofar as they experience gender-based violence, but they also provide support and protection for all children. And what's interesting, because I've been reading about this, is that if you read the convention as a whole, other than to do with FGM, forced sterilization, and forced abortion, the convention actually, interestingly, for a convention that expressly protects women, is drafted in a fairly gender-neutral language and can be implemented to support and protect boys, children, from all forms of violence covered in the convention, especially domestic violence. And what it also recognizes is that the violence is not necessarily directed at the child by way of the mother, necessarily, but that the child could also themselves be a target of violence or experience violence by being a witness to the violence. And the drafters of the convention were quite careful in this context in acknowledging both child as victims of physical, sexual, and psychological violence, and children as witness to violence between their parents. When it comes to protection and support, the Istanbul Convention requires all measures to take into account the relationship between victims, perpetrator, children, and their wider social environment. And that's quite important because oftentimes there's this temptation when you've got a statutory duty to do X or a statutory duty to do Y and a policy about Z, that you create one size fits all ways of approaching an issue. But one size fits all fails to consider the different kinds of relationships between victims, perpetrators, and the children. And the aim is therefore not to avoid looking at domestic violence as a singular thing, but to look at it as something to do with needs-based and to recognize the social reality that is maybe different because of socioeconomics or ethnicity, family dynamics, culture. Similarly, it's quite important in the Istanbul Convention that it's not just about safe place to live for victims of domestic violence. I mean, it does have an article that requires arrangements for safe accommodation. But all I would say is safe accommodation doesn't necessarily only, again, one size fits all equate to a refuge. It could be a variety of different kinds of safe accommodation. But it also, under Article 22, calls for specialist support for children as independent victims of domestic violence, and also specifically children needing age-appropriate counselling and age-appropriate best interest assessments of the needs that they need. So I think we should ought to bear these in mind when we come in to look at the Domestic Abuse Act to see if it actually lives up to the expectation. But before I do that, I just want to look at the two Children Acts. So Children Act 1989, you've got the starting point, which is children may be in need, and if they don't achieve or maintain or have an opportunity to achieve or maintain a reasonable standard of health and development. So, you know, that could potentially, victims of domestic abuse could fall within that framework, or if their health and development may be significantly impaired or further impaired without support. And Section 17(3) is a power to assist with a view to safeguarding and promoting the child's welfare. I mean, of course, domestic legislation has not caught up with the UNCRC. It still used patriarchal language of welfare as opposed to best interests of the child, even though the UK was a primary drafter of the UNCRC. Now, Section 17 and Section 17(3) doesn't really actually give you very much other than a power to assist, which could include accommodation in-kind support, but not a duty and not a guarantee. You then also have Section 47, which is the duty to investigate where there's a reasonable cause to suspect a child who lives or is found in their area suffering or is likely to suffer significant harm. But that is traditionally a fairly high threshold. You only really get a proper recognition of domestic violence and domestic abuse when you look at Section 31, which is the provision on care orders. And harm in that context, firstly, is attributable care given or likely to be given to a child if an order is not made, not being what it would be reasonable to expect a parent to give him. Well, you know, it's not reasonable for a parent to expose a child to domestic violence. So that seems to, you know, be the connection there. In terms of ill treatment and harm is defined as ill treatment or the impairment of health and development. For example, impairment suffering from seeing or hearing the ill treatment of another. Development could be physical, intellectual, emotional, social, behavioral development. What's quite interesting is this is actually an amendment that came about in 2002 under the Adoption and Children Act to take specific and express account of the impact on children of domestic violence. But let's pause there. It's Section 31 is about removal of children from all families. It's not about protecting children with the family unit that is safe. So it's in that sense, it's useful, it's important, it's highly important to recognize that in the context of removal of children, domestic violence is a basis upon which you might need to exercise quite draconian child protection measures. But what if you don't get to that point? where then in the Children Act you get provisions that firstly acknowledge expressly domestic abuse and domestic violence as a feature of welfare and a feature of harm, because the harm definition in section 31 doesn't pollinate across to section 47 or to the definition of section 1710 in need. So there is a real gap there in terms of the synergy between the different provisions of the Children Act. But also, and as picking up on what Laura said, is section 17 requires assessments, and most of you probably have dealt with that to some extent. It doesn't give you concrete support at the end of it, and it does do exactly what Laura was expressing concern about, the focus on the responsibility of the mother to keep the child safe, because section 17.1 is about the duty to safeguard and promote the welfare of the children, and to the extent possible, promote the child's upbringing with the family. Well, we'll just focus on the upbringing of the child with the family. Why isn't the mother protecting? And issues of credibility. How come you've been in a domestic abuse relationship and not done anything about it? Why are you coming for help under section 17 now? And that kind of credibility scrutiny of the mother, and therefore forgetting actually there's a child who, whatever the issues are, is impacted, and their welfare and their health is being impaired. But that's the Children Act framework, and that is our main child protection framework. We then also, of course, have a thingy that doesn't work. Right, okay, so we then have the Children Act 2004, which has two duties there. One is a duty on the local authority to promote cooperation with a view to improving the welfare and the well-being of children in their area, and again, protecting from harm and neglect. But again, harm not defined in the same way as section 31. It doesn't expressly identify the kinds of harm that local authority needs to cooperate with other local authorities and public authorities to do. Section 11 is named public authorities' duty to make arrangements for ensuring the functions are discharged, having regard to the need to safeguard and promote the welfare of the children and any services provided by another to have regard to that need. Now this obviously has been our one single important tool in the way we impose on housing authorities for the way they do decision-making focused on the child's position, because housing authorities don't have Children Act duties. Housing authorities' duties are freestanding under the Housing Act. But section 11 has been the one tool in our box to enforcing local authorities thinking about the context of impact of children in domestic abuse situations. And the only case I could really come up with in my extensive search is the case of HA and Ealing, which is a case about housing allocation policy refusing to give a reasonable preference to a victim of domestic abuse and her 5 children because she didn't meet the residence rule. And in that case, the housing allocation policy had an exceptionality clause that you can say, well, there are exceptions to the residence rule. But one of the things that it was definitely silent on is what happens, how do you deal with children who need housing, who are homeless, who need appropriate housing because they're fleeing domestic violence as a family unit. And in that case, the local authority tried to assure the court that, well, it's assumed surely that we would have considered the child's best interest. So don't worry about that. Doesn't matter that we can't produce any evidence of it. Don't worry, just trust us. Obviously, the court gave that short shrift and said that absent what section 11 required is a very structured, auditable trail of how you have considered the child's best interest in formulating this policy and also in deciding the individual case. But in that context, the child is still the hidden victim, because the focus of the policy and the focus of the consideration is having due regard, not putting them as a primary consideration. Okay, so we're finally at where I promised we would get to, which is the Domestic Abuse Act. So the definition of domestic abuse, obviously for the first time now on statute, goes well beyond physical violence, and it's applied across the board. But domestic abuse is defined as between people who are over 16 years old. If the abusive behavior is directed at someone who's under 16, it's not dealt with as domestic abuse, it's dealt with as child abuse. So you then go back to the Section 47 framework, you go back to the Section 17 framework, and it just doesn't have the same kind of teeth. And obviously it then also doesn't address the problem that I identified at the beginning of this talk, which is what happens to under 16s in intimate abusive relationship. That is not protected under Sections 1 and 2 of the Act. Section 3 of the Act, just to give the government some credit, it does recognize the child as its victim of domestic abuse, where a child sees or hears or experiences the effect of domestic abuse and is related to the person being abused or the perpetrator. So that kind of adopts and synchronizes with the acknowledgement of harm to children in the Children Act under Section 31, as the victim being, the child being a victim by virtue of witnessing the abuse. And then, you know, Section 17, Section 7, the Domestic Abuse Commissioner is to encourage good practice in identifying children as affected by domestic abuse. So this is the state, this is the high point of what we have in relation to the Domestic Abuse Act and how it relates to children. Because then we get to part 4, which is relevant to what we're talking about today, support provided by local authorities to victims. And I'm sure this has already been gone through, so I've set out the provisions there. But all I would say is it's to highlight and light on accommodation-based support, and that's premised on the victim and the child residing in relevant accommodation. And relevant accommodation obviously is then convolutedly defined in regulations and not in statute, and it's the list that you can see there. But it requires you to be in that kind of accommodation if you are to access accommodation-based support, nothing else. And this was a source of debate during the passing of the bill, and you know, Barnardo's, others, Women's Aid, etc. Everyone was pushing for also a wider framework for the duty to provide accommodation-based support, and community-based support, because a vast number of children and their mothers who are victims actually remain in households, not in accommodation, safe accommodation, but in households suffering abuse. So this doesn't actually cover them and doesn't actually protect them, and is not intended to protect them, so says the government. Why? Don't know. It's an assumption that if you fear violence, you will leave your home and you will be given a safe place by the government, by the state. And if you don't leave, then what, you don't need support? I don't know. I mean, is that the logic? So then you come to, well, where's the gap? The gap is obvious, that children as victims don't have support in their own right, that all the kinds of available community-based support that is actually quite effective, independent domestic violence and abuse advisors, outreach workers, helplines, counselling services, young people and children's workers, none of them are covered. None of them are under a framework where there's a requirement to ensure that they're made available to victims of domestic abuse, including children. And Save Lives, which has been mentioned by Laura, you know, their surveys and their briefing to for the second reading of the bill highlighted that 70% of children who are victims of domestic abuse, the people that this act was meant to protect, remain in the family home and will not get support through this bells and whistle duty that isn't a bells and whistle duty. And more than 65,000 adults and 85,000 children at high risk of serious harm are supported by community-based services, as compared to 11,000 women in refuges. That's the contrast, that's the gap. And there's also no child-specific specialist services that are required to be arranged by local authorities, perpetrator intervention support, which was another aspect that a lot of the domestic violence charities were pushing for, again, not actually in the Act, and there's no other softer law requirement to provide for that. The question, therefore, is whether or not it lives up to its objectives. And let's not even go there with migrant children and families, where the domestic violence is still hidden, because all they have is Section 17. And we all know it's a power, it doesn't have guarantees. And in the context of migrant women and migrant children, credibility as to their claim to be victims is under even more scrutiny. So I'm sorry that I have depressed everyone at the end of the morning, having had such an uplifting talk, an interesting talk from Laura and Saskia. But this is what I think is our problem, is in terms of the legal protections for children in the context of domestic abuse. I think that's an area ripe for litigation, because we still, after all that with the domestic abuse bill, mind you, the domestic abuse bill first came around in 2019 and then ran out of parliamentary time and got reintroduced by the government. So it's like 3 or 4 years coming. And it's supposed to enact the Istanbul Convention. It's supposed to reflect all the obligations that we signed up to. But this is where we've left it. We're still not protecting children, and we're still left in our toolbox with Section 11 of the Children Act 2004 for housing cases. For social care, we might have a little bit more, but we're not really all that far along. Thank you very much.
Amazing. Thank you so much, Shushan. I'm amazed as to how much you managed to cover in the time available. I'm sure that there are questions, so I'll open up again to the floor for questions for Shushan initially, and then if we have time, I've got the panel still at my disposal, so if there are any further questions just generally, we'll open up again. And then we have lunch. I've been watching sandwiches being delivered at the back of the room, so 15 more minutes and then lunchtime. We're all stunned and awed into silence. Anybody feeling like they have any queries?
Hello. I presume it's on. Hello, thanks so much for that. I'm just a bit worried, and I think it comes to your point, Laura, that the children as victims is going to be used against survivors, because a bit like yourself, and I appreciate it crosses over between the law and the casework that I do, but women have been really blamed relating to social services interventions. And I have many clients where their children have been taken off them because of domestic abuse and them not doing sufficient amounts to protect their children, despite the fact that they may have done Herculean efforts to protect their children. So I don't know what's emerged yet because it's so new, but have we seen that the children as victims sort of Section 3 being used against survivors? I haven't particularly heard of it. I'm just really concerned about this, because although it's a really useful protective tool, these protective tools are often inverted against our clients, as you were rightly identifying. So I'm just a bit worried about that. I just wondered if there's any reflections about the potential downsides, regrettably, of that inclusion.
I mean, I think perhaps prior to the Domestic Abuse Act, our framework for child protection was more patriarchal and patronizing, so that we're here to save you, we're here to assess you, we're here to tell you what your welfare is. I think, you know, I hate using the words of rights-based approach, but it does, you know, I mean, I know I've like kind of basically torn it apart, but let's build it back up, which is that its purpose is to put victims at the center and look at what the victim requires as opposed to what we're going to tell them to require. And I think you have to almost turn Section 3 and the recognition of children as freestanding victims as a means of saying the child needs to be heard in its own right. There shouldn't be an assumption of responsibility by the parent. Obviously, parents naturally have responsibility for their children, but in recognition of them as freestanding victims, you've got to look at what their needs are, irrespective of the ability of the parent to protect. And so it's about changing it in that context of child rights based, the right to be heard, the right to have their needs considered as a freestanding issue. It's an argument that you can make. It's an argument to turn on its head this idea, the old style idea of welfare, and we're going to tell you what you need and what you should do. I think that's probably the one change from a policy angle that the Domestic Abuse Act has accomplished. You know.
Hi, my question was actually for the panel as a whole. One of the things that we experience a lot is clients who are approaching us for housing support after an application has been refused, for example. And in getting instructions from the client, often for the very first time we've spoken to them directly, we are asked to sort of get instructions from them as to the extent of their abuse. And I found it quite difficult at times. That conversation is obviously very difficult for the client and can often be re-traumatizing. So I was looking to just sort of to get some advice on how best to approach those kinds of conversations, and particularly at the end of the conversation after we have elicited, you know, these instructions from the client, which can be disclosing, you know, years worth of abuse. It's a very difficult conversation, understandably, how to sort of end that conversation with an appreciation of the seriousness and you know, the brevity of something that was discussed.
Yeah, great question. I think it's really difficult because no matter what you do, that is going to be difficult. And I think just having an awareness of that goes a really long way. And like I said, you know, you can even directly acknowledge that by saying to your client, you know, is there anything that I can do personally to make you feel safer in this meeting? I'm aware that these are really difficult things to discuss. You know, you can directly acknowledge it and ask them directly, because again, you're kind of putting the power back in their hands. You know, this is your time, you know, what do you need? But it is difficult. And to answer the second part of your question about at the end of a session, once they've made a lot of disclosures, again, you know, that it's really difficult. But I always finish kind of calls and meetings just by asking if they've got anything planned after, you know, treat yourself, get yourself a takeaway, or go call your friend. Just like, again, like little kind of, it's just those little parts of humanity, which you're never going to be able to not make that situation painful, but by not being kind of like robotic and, you know, just because I think some ways people ask questions about incredibly personal things as well. It's almost like they're asking, you know, what you had for dinner last night. And obviously, if you're asking about domestic abuse and sexual violence, it can never be like that. So I think just slow, let people take it at their own pace. And again, acknowledge how difficult it is. I think you'll be surprised how far that goes with a lot of people.
I'd just add as well, sometimes if there is a multi-agency network around that person, and it's really useful to tap into that. If they give you consent to speak to them, because, you know, working in a trauma-informed way, we don't want to have to expect survivors and victims to retell their story to every professional. We should be sharing the most relevant information with each other. So sometimes it's about having that conversation. If they would feel you more comfortable maybe obtaining that information from someone else, they can share that assessment so they haven't got to go through that process.
I've just got a question online, and then I can see a hand here next. So we've got a question. In terms of changes in law to better protect children from domestic abuse, what do you think the priority would be? So I might come to Shushin first, having identified some gaps, and then I'm sure that Laura has some views.
Well, firstly, expand the definition to encompass children. But obviously, I think Section 3 is important in that children are victims for seeing and witnessing. So it's not just for experiencing the actual direct violence. So it is important to have that. But children also experience the direct violence. And I don't think the child abuse framework works in this context, because people are oftentimes in that context thinking about gross abuse, sexual abuse, child sexual abuse. They're not thinking about domestic violence at the same level. I mean, even though violence is violence. So that's one thing. So change the definition, expand the definition. The second thing is expand the obligations relating to services directed at children specifically. Because I was just having a look at Section 57. Although it says it's for victims of domestic abuse, where it defines accommodation-based support, it says support in relation to domestic abuse provided to victims of domestic abuse or their children. So there is an assumption that children are not the victims, and therefore they are just the add-on to whoever is eligible for the support itself. And I think that's a problem, because it's not a child-centric way of dealing with trauma and dealing with recovery. And that's actually what's reflected in the Istanbul Convention, that you need child-specific recovery support. And that is not reflected in the Domestic Abuse Act.
Thanks, Shushin. I mean, yeah, I just absolutely agree with everything shared there. I think, yeah, having access to support is essential, but being really clear in terms of whose responsibility, where's that money coming from. There's often the expectation, well, local authorities must provide this, but yet we know that their budgets are getting sort of cut. So whose responsibility is that going to be, so that we can actually, yeah, have those services in place?
One of the amendments that we tried to put forward was to impose a duty on the Secretary of State to ensure a budget for domestic abuse specific support. Because even the 57 duty, it sounds glamorous, even now, although narrow on accommodation base. There's no sort of overarching obligation on the state to ensure that there's a ring-fence budget for the accommodation-based services. And we all know about cash-straps, local authority and austerity perpetuating for the last decade and more. And it's pointless to have these duties if you're not going to actually follow through with the money. And that is a requirement at the central level, because everything is determined at that level. So, I mean, that's the other thing that I think is important.
Great. I think there was another question from the audience, and then I think we'll wrap up for lunch. I'm hoping you can't hear, but my stomach is in fact audibly grumbling, telling me that it's time to wrap up the session. So
this is a very practical question. So for you, if you don't mind, Saskia. Basically, when I take instructions, I take very detailed instructions, and it is practice for me to confirm the instructions back to the client in writing at the end of the appointment to make sure that the instructions are accurate. And it is important because quite often those instructions will form the basis of any future submissions. Obviously now, having listened to today's session, I'm becoming quite aware that that could also in itself be a trigger. I mean, do you have any advice on how to manage the conflict between wanting to be clear on what your instructions are, following various requirements of your regulatory bodies, and et cetera, without necessarily triggering or causing distress?
Yeah, I mean, I just tend to do it verbally. There are always times when maybe you're unclear about what somebody says and you want to double check. That's obviously good practice in any, but yeah, maybe just saying oh, so if I understand correctly, blah, 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 maybe you could just have that interaction verbally as opposed to writing it down. And then you could, the onus could be on you to kind of make sure that when they repeat it, you're taking notes about what they're saying to, I wonder if that would be a way around it. I don't know if that's massively a helpful answer, but that's all I can kind of think of.
Fantastic. Well, I can see already some discussion happening on the floor. I'm sure that we've got discussions to be had about. There are a couple of questions I think that really drew out something interesting, which is how we balance our desire to work safely with our clients and in a way that is, you know, as empathetic as possible with some of the demands and rigors of our job and the requirements as lawyers, just sort of the boxes we have to tick, the deadlines we have to hit, and how those things can sometimes be in tension. And I'm sure that part of the conversations that we'll continue together as colleagues today is an opportunity to share and reflect on how we navigate those quite difficult aspects of the SAS area of practice. But I just really want to thank Saskia and Laura and Shushin for coming today and bringing sort of these additional angles to our discussion about domestic abuse, making us really alive to sort of the holistic approach and some of the myths and other trauma-informed aspects of the work, and for Shushin for putting all of this when it comes up in relation to children into that broader context that we should be aware of in terms of the overarching frameworks that can apply to children and how that might assist or perhaps fall down in some of our cases. So thanks to the panel. Final round of applause would be wonderful. We're now going to break for lunch for an hour. And when we're back, we've got domestic abuse and tenancy, so back into some sort of crunchier law, the kind of standard fare you might expect at a conference. But we'll see you across the lunch break. Thanks, everyone.
I am Dominic Preston. I'm a barrister at Doughty Street Chambers, and we've got 3 speakers for you this afternoon on the first session. The topic is domestic abuse and tenancies, the common problems. And that's going to be broken up into 3. But if I just introduce the speakers first. Sue James, who sits beside me, is Chief Executive of Legal Action Group. We've had to prize her away from all the other events and things that she's doing. She is a former director and solicitor at Hammersmith Law Centre. She says she's forgotten all her housing, but I don't believe her. And she was in 2017 a winner of the Legal Aid Lawyer of the Year Outstanding Achievement Award, which those who know her will not have been surprised. Daniel and Marie are both barristers at Doughty Street Chambers. They focus on housing, social welfare and community care. If I turn to Daniel first, those of us in Chambers who don't have encyclopedic knowledge, just ring Daniel, very useful. Marie is proving equally knowledgeable, and indeed it was prizing her away from Shu Shin today was quite difficult, as I think she's been picked on to do all sorts of work, interesting work, with regard to Home Assist this afternoon or tomorrow. I'm not quite sure what your deadline is. I hope you can stay. So welcome to all 3, and my thanks to them for attending. It's breaking it up into 3 parts. Dan is going to talk about the options available to the victim in the context of tenancies, and that's the Family Law Act principally, other elements as well. Marie is looking at the financial context, both as a means of abuse, but also as how you might escape that financial abuse, and in the context particularly of benefits. And Sue is looking at the elements of the Domestic Abuse Act which relate to tenancies and the various rights involved in landlord-tenant context. So, can I start? I'm going to invite Dan to go to the podium first. I think there's a microphone there.
Yeah, there should be. It looks as though it's on, but if anybody can't hear me either in the room or through the equipment, somebody can flag to me and I'll press something or raise my voice. And I think this should click me through my slides. Is that right? Yes. Okay. So thank you very much, Dominic, and thank you everybody for attending and for staying for our session in particular. I'm going to speak, as Dominic said, principally on options available to victims under the Family Law Act 1996. And this is really, I suppose, the primary legislative set of provisions that are available in relation to domestic abuse in the context of tenancies, in relation to tenancies. And I'll come to give an overview of what rights and what powers the court have in that respect. Before moving on to that, I thought I'd start by just having a quick look at the types of issues that might arise in relation to tenancies as a result of abuse, because the Family Law Act suite of provisions are really quite wide-ranging and powerful, and it's worth thinking as we go through the types of issues that they might be able to address. So perhaps the kind of first and most immediate risk that we're talking about, or issue, is the issue of the continuation of abuse. That particularly if a tenant or if a client is forced to continue living side by side or in contact with an abuser, then there's a risk that abuse will continue. There's also risks that arise in relation to the exclusion of the client from their home by the abuser, or indeed whether that's a kind of physical unlawful eviction type exclusion, or the client having been forced to flee in order to escape the abuse. And that raises different issues in relation to the continuation of the tenancy, where the abuser is a sole tenant, and so the client who's been excluded or had to flee has no private law right to occupy the property. And then obviously the situation is slightly different where the victim is either the sole or joint tenant, and so we'll think about some of those issues. There's a specific risk, which I suppose feeds into those categories, which is the risk of termination of the tenancy by the abusive partner. And that's obviously where the abusive partner is either sole or joint tenant. And that's because a sole or joint tenant can give a notice to quit. And even if it's a joint tenancy, it doesn't require the consent of the other joint tenant. And indeed, not only can an abusive partner do that, but it may happen very quickly because a landlord can agree to accept short notice. So that's a situation where you might have to be thinking very quickly about what remedies are available to the client. And then I've also said that there are other risks that might arise to the tenancy, not just a loss of security by non-occupation or termination by the other partner, but for example, there may be breaches of tenancy as part of the conduct that's being perpetrated by the abuser. And there may be also rent arrears that arise as a result of financial abuse or loss of income in the context of relationship breakdown. To some extent, I think the provisions that Sue's going to look at later will deal with the first of those to some extent, and Marie's focus on financial issues will obviously deal with the second issue about how a client may go about protecting their financial position in order to continue paying the rent. And then the final issue that I'll look at is about long-term security and transfer of tenancy. So once you've dealt with the immediate risks to a tenancy being terminated by an abuser or coming to an end by some other route because of the abuse, there's also a question about who's going to keep the tenancy long-term and how the client's going to secure their position. So in overview, then the Family Law Act effectively consolidated and extended a number of pre-existing provisions and powers in relation to relationship breakdown and abuse. In particular, we'll see when we come on to it in a moment, it introduced the concept of associated persons, and so dramatically expanded the scope of people or situations in which orders could be obtained. The broad kind of categorization of topics that I'm going to look at is first home rights, which are the automatic rights that are held by spouses and civil partners. Then occupation orders, which may be made in favour of both spouses and civil partners, but then also the whole extended range of other associated persons who I'll come to. Then to non-molestation orders, which are effectively injunctions preventing continued abuse. and then finally to transfer of tenancies in that long-term position. The thing I should say at the start, I suppose, in the context of a conference directed primarily at housing practitioners, is that these applications are dealt with under the family procedure rules, and they fall in the civil legal aid category definitions, fall within the category of family law. So these are, I think it's fair to say, primarily the terrain of family lawyers, but it's obviously absolutely crucial for us as housing lawyers to be aware of the scope of the territory, what remedies might be available, and if nothing else, to know when we might be referring people to family lawyers, when that's going to be helpful or not helpful, and particularly when that needs to be done very urgently. And it may also be helpful just in terms of bridging the gap to be able to give your client a kind of broad indication of the territory, even if you're not going to be advising on specific detail. So the first part of part 4 of the Act is in relation to home rights. And as I've said, these are the automatic rights that arise, and they arise only in relation to spouses or civil partners. So in relation to cohabitees or former spouses, former civil partners, former cohabitees, they're all dealt with by way of a court order under subsequent provisions. They also only apply, as indeed most of these provisions only apply, where the home in question either was the matrimonial or civil partnership home, or was intended to be at some point the matrimonial or civil partnership home. So this doesn't deal with properties that are perhaps owned by another partner but completely separate and were never intended to be shared in that way. So where A, being one spouse or civil partner, has a tenancy or a right to occupy the joint home, and I should say these provisions all apply also to other interests in land, such as where you've got owner-occupiers, but given that this presentation is dealing with tenancy issues, I'm talking just in terms of tenancies and other right to occupy. So where A has a right to occupy or tenancy and B does not, B has the following home rights. First, if B's in occupation, they've got the right not to be evicted by A without leave of the court. Or if B's not in occupation, they've got the right to enter and occupy with leave of the court. Then two further provisions that are of importance, particularly where the abuser is the sole tenant. Section 30 provides that payment of rent by B, who's not a tenant, is treated as payment of rent by A for the purposes of the tenancy, and occupation by B is treated as occupation by A for the purposes of security of tenure. So all be familiar with the tenant condition in relation to secure and assured tenancies. These provisions link back to the issue that I talked about, where you've got a sole tenant abuser who has left your client in occupation. Without Section 30, there might be issues as to whether the tenant condition was still fulfilled, or whether your client could pay the rent. Section 30 deals with that. Important to note, though, that Section 30 only continue, or the automatic rights in Section 30 only continue for as long as the marriage or civil partnership subsists, unless the court orders otherwise under Section 33. And so if there's already been a divorce or a dissolution of the civil partnership, these automatic rights won't apply. But we'll see that Section 35 does deal with that situation. And it also only continues for as long as the partner who does have a right to occupy continues to have a right to occupy. And what that really means is that the orders under Part 4 operate to regulate rights as between A and B, but they don't create rights as against third parties, so as against landlords. So you can't create a right to occupy where neither has such a right. It's only about regulating between partners. Also noted there that home rights can be released in writing in relation to the whole or part of the dwelling. So that's the automatic rights. Those are home rights, and they're only for spouses or civil partners while the marriage or civil partnership exists. Sections 33 to 41 deal with occupation orders, which are the orders that the court can make to intervene and create or restrict or manage rights. And I've set out there that there are 5 key categories of occupation order. So the first is occupation orders in relation to associated persons where they already have an existing right to occupy, and that includes home rights. So if your client is a joint tenant, for example, or the sole tenant, or they have home rights under Section 30, you'll be looking at Section 33. The next category of occupation order is where one former former spouse or civil partner has no right. So that's, as I said, where your home rights have ended because this marriage or civil partnership ended, but the other party has a right to occupy or tenancy. Then you've got kind of similar iterations in relation to a cohabitant or former cohabitant. Then Section 37 is where neither of the spouses or civil partners or former spouses or civil partners has a right to occupy. And that's what I said about not creating rights in relation to third parties. And then finally, you've got the equivalent position where neither former cohabitant or cohabitant has a right to occupy. And again, I've reiterated the point there that these are about regulation of rights between A and B, and not creating rights as against landlords. So the main provision, I suppose, in relation to occupation orders is Section 33, and the rest of those can be looked at in relation to Section 33. Section 33 applies to all associated persons, and an associated person is defined very widely, as I said at the beginning. So it includes current or former spouses, current or former civil partners, current or former cohabitants, current or former household members, which can go beyond the context of a relationship, family members, etc. And there's a full list in Section 62(3). So it's a very broad scope of people who can apply. Again, it only applies where the applicant, where your client has an existing right to occupy or home rights in relation to a joint home. And they may then apply for an order for one or more of the menu that's set out in Section 33. So they can apply for orders to enforce their right to remain in occupation as against A, to require A to allow them to enter and remain in either the whole property or part of it, to regulate occupation by A and or B, to prohibit, suspend or restrict the exercise of A's right to occupy or their home rights, to require A to leave the property or part of the property, and even to exclude A from a defined area in which the property is included. So you can see it's a really very broad range of powers that the court has there. And it's in accordance with that, the courts have stressed that occupation orders are a draconian power, and that the general rule is that they should only be made in exceptional circumstances. Having said that, in practice, and particularly where occupation orders in theory apply to the whole range of relationship breakdown cases. In cases where you're looking at domestic abuse, applications for occupation orders, often in combination with non-molestation orders, are often made, and the courts have made clear, for example, that there doesn't have to be physical violence in order for an occupation order to be made. So it's worth being aware of authorities that kind of push in two directions on that these are serious draconian orders which aren't to be used just as a matter of course in any relationship breakdown, but equally there's not some insurmountably high threshold to be crossed where they are appropriate. Having said that about the scope and power of these orders, it's worth noting that these don't, these can deal with the issues about exclusion of your client by an abuser, or about the abuser remaining in the home and continuing to perpetrate abuse. They don't deal with the long or short-term security of the tenancy. So they don't deal with transferring the tenancy to your client. They don't deal with the risk of the abuser terminating the tenancy by way of notice to quit. We'll see the provisions for that later. Set out there that the court may also order. We saw previously that home rights end on the cessation of the marriage or civil partnership. The court has a power under Section 33 to order the contrary. And the court has to look to various factors, including the housing needs and resources of the parties and any relevant child, the financial resources, the likely effect on health, safety or well-being of A, B and any relevant child, and the conduct of A and B in relation to each other and otherwise. So that's the kind of broad factors to be taken into account. There's also a specific test that has to be applied called the balance of harm test, which is that if B, your client, the applicant, or any relevant child is likely to suffer significant harm from A if an order is not made, the court shall make the order unless A or any relevant child is likely to suffer equal or greater harm if the order is made. So you can see why that's described as the balance of harm test, but that gives a kind of focused approach where your client is at risk of harm. So then moving to section 35, this is in relation to former spouses or civil partners. So this picks up where section 30 finishes. If your client's marriage or civil partnership has already come to an end, then there's a right of application under section 35. Again, it's where the other party has a tenancy or a right to occupy the joint home and your client does not, then your client can apply for the same orders effectively as under section 33, but the court has to consider some additional factors, which include the length of time since your client and the respondent ceased to live together, the existence of any pending financial proceedings, and the length of time since the marriage or civil partnership was dissolved or annulled. And it's important to know that these orders can only be made for 6 months at a time, albeit that that's renewable. So you can see that the kind of the approach of the Act is that while there's a marriage or civil partnership in existence, these things should be open-ended until the end of that, and then afterwards it becomes a situation where the court has to review and consider more the circumstances of when the marriage was and when it ended, etc. As I've noted there, while the order's in force, but only while the order's in force, the provisions of section 33 to 6 apply. So that's that payments by one spouse count as payments by the other, and that occupation by one counts as occupation by the other. So that was where one former spouse or civil partner has a right to occupy and the other doesn't. This, moving to section 36, is where one cohabitant or former cohabitant has a right to occupy or tenancy and the other one doesn't. I've noted there that cohabitant is defined as where two people are neither married nor civil partners, but living together as though they were a married couple or civil partners, and that's a familiar test from, for example, the succession provisions in relation to secure and assured tenancies. The position under section 36 is essentially the same as in relation to former spouses or civil partners under section 35, but the court, although required to consider the balance of harm test, it doesn't produce a mandatory outcome in the same way that it would for spouses and civil partners. The court is also required to consider, I suppose, because the range of relationships, because the relationship won't have had the formality of a marriage or civil partnership involved, the court has to look at the nature of the parties' relationship and the level of commitment involved in assessing all of the circumstances, including the length of cohabitation and whether A and or B has parental responsibility for any child. So then, finally, in relation to occupation orders, you get to the situation that I talked about where, whether you're talking about a spouse, civil partner or cohabitant, or indeed a former spouse, civil partner or cohabitant, neither of them has any existing right to occupy. And where that is the case, the court can still make an occupation order, and it essentially has more or less the same menu of powers available to it as under section 33, but minus those orders which are about regulating the party's rights to occupy, because obviously neither party has a right to occupy. But it can still make orders as between A and B, requiring one to permit the other to enter or remain on the property, to regulate the occupation as between the two of them, to require one to leave or to exclude them from the area. under section 37, in relation to former spouses and civil partners, it's the same matters to be taken into account, and the balance of harm test applies. Again, as with all of these, it's for a maximum of 6 months at a time, but that's renewable. And the position under section 38, which is former cohabitants or former cohabitants, where neither has a right to occupy, it's essentially the same position, but the balance of harm test doesn't produce the mandatory outcome. So then, finally, in relation to occupation orders, you have section 40, which makes additional provision. So everything that we've looked at so far is really about regulating occupation as between A and B, and who can live in the whole of the property or part of the property, etc. Section 40 includes some important additional powers. Upon or after making an order under section 33, 5 or 6, the court may impose obligations as to on either party as to repairs, as to maintenance of the property, and as to payments of rent, etc. It may also order one party to make periodical payments to the other in respect of the tenancy or right to occupy. So, for example, you might have a situation where one party is excluded, but the other party is required to make some payment in relation to them. And then the court can also make orders in relation to use of furniture and other contents, requiring one party to take reasonable care of furniture and other contents, etc. And in doing so, the court shall have regard to all of the circumstances, including the financial resources, needs and obligations of the parties, including to each other and to any relevant child. So linking back to where I started with the kinds of issues that you might be looking at, Marie, as I say, is going to come on to financial issues in more detail, but here's one way in which an issue of rent arrears arising in the context of relationship breakdown might be addressed, because the court has a power on making an occupation order to order one party to be making payments in that respect. Worth noting, obviously, that because this order is auxiliary or these orders rather are auxiliary to a main occupation order, they come to an end on the end of the occupation order, so they're things that have to be thought about together. Moving on then to the third of my four headings under the Family Law Act, non-molestation orders. These are effectively, as I said, injunctions in the context of domestic abuse, prohibiting the respondent from molesting an associated person, and we saw the breadth of the definition of associated person before, and or a relevant child, and those orders can be made preventing molestation generally or in relation to specific acts or both. And clearly you can see that you're likely to, in the context of particular facts, want prohibitions on particular acts, even if you also have a general prohibition. The court can make a non-molestation order either on application or indeed in any family proceedings listed in the Act without an application for the duration of those proceedings, simply on the basis that the court considers that it's appropriate to make the order. The court has to have regard to all of the circumstances, including the need to secure the health and safety of the applicant and any relevant child, and breach of a non-molestation order, and this is where it has a significant advantage as compared with ordinary civil injunctions. Breach of a non-molestation order is an either way offence punishable on indictment by up to 5 years. So you don't have, there's not an issue about committal proceedings. There are criminal proceedings that will be pursued by the police. Sections 43 to 49 make further provision in relation to both occupation orders and non-molestation orders. So the court can make an occupation order or a non-molestation order ex parte where it's just and convenient, having regard to all of the circumstances, including any risk of harm to the applicant or relevant child if an order is not made immediately, whether an application is likely to be deterred or prevented if it's not made immediately, and whether the respondent is deliberately avoiding service and that's causing prejudice to the applicant. Perhaps needless to say, the authorities have made clear that an occupation order and indeed a non-molestation order is a draconian power. where an applicant's trying to persuade the court to make those without notice, the court's going to be particularly hesitant before imposing those orders, but the power is there. Section 46, the court can accept an undertaking from any party in place of making an order, save where the respondent has used or threatened violence against the applicant or a relevant child, and the protection of a power of arrest or non-molestation order is necessary to protect them. And then section 47 makes specific provision in relation to powers of arrest. That the court shall attach a power of arrest to an occupation order where the respondent has used or threatened violence against the applicant or a relevant child, unless it's satisfied that they will be adequately protected without it. So you can see that if you're in the context of a relationship involving abuse by way of use or threat of violence, there's automatically a presumption in your client's favour, although on an ex parte application, that requirement is a discretion, because the court is left free to consider a wider range of factors, including the fact that the respondent isn't present to represent themselves. I think my penultimate slide, or actually no, 3 more slides. Moving on to the fourth part of the powers under the Family Law Act. Schedule 7 deals with the transfer of tenancies, and giving a kind of very brief overview, because again, these are really family proceedings that are going to be dealing with these in detail. The power applies to relevant tenancies listed in the schedule, so that's including secure tenancies, assured tenancy, rent act tenancies, and agricultural tenancies, in fact, of a matrimonial or civil partnership home, or a home where cohabitees have cohabited. The court can make an order where one or both of the partners are the tenant, and in the context of spouses, it's on or after making a divorce or nullity or separation order. Civil partners, it's whenever it has the power to make a civil partnership property adjustment order, and with cohabitants, it's if they cease to cohabit. So there's a wide temporal scope. It doesn't necessarily require your client to still be in occupation. Court has to have regard to all of the circumstances, including the circumstances in which the tenancy was granted, the matters relevant to the occupation orders that we saw previously, and the suitability of the parties as tenants. I've said there that part 2 contains the kind of technical provision about how these orders work. And finally, the court may order compensation to be paid in respect to the transfer of the tenancy, and it also has power to make other orders in relation to liabilities under the tenancy and where they should fall. So that's really the provision dealing with the long-term position in relation to tenancies. It's also worth noting that in accordance with the usual principles on interim injunctions, where your client has a application or claim for final relief in terms of a transfer of tenancy, if there's a risk that the subject matter of the proceedings will be destroyed in the meantime, i.e. the other partner will serve a notice to quit, and so there will be no tenancy to transfer, then your client may be able to obtain an interim injunction to prevent that. Here I've just summarised some other relevant statutes. As I say, part 4 of the 96 Act is really the kind of main suite of powers. But of course, your client may be able to also apply for a injunction under the Protection from Harassment Act 1997, and there's also a criminal offence under that Act. There's the Matrimonial Causes Act 1973, which makes provision in relation to financial relief for parties and children on divorce. And that obviously, the tenancy issues might be just one part of a broader suite of issues that are going on in financial proceedings on divorce. Similarly, the Civil Partnership Act 2004 makes that provision in relation to civil partnerships. And the Children Act 1989 makes provision in relation to finances for a person named in child arrangements order. So where the court makes an order in relation to what's going to happen in relation to the custody and care of children under that Act, it can then make additional provision, including powers to order settlement to be made for the benefit of the child and transfer of property to the child or to the applicant for the benefit of the child. So that's just a kind of very, very broad sweep of the other powers that might be relevant. And finally, I've just put up a slide here on legal aid. Paragraph 11 in part 1 of Schedule 1 of LASPO makes specific provision for civil legal services provided in relation to home rights, occupation orders and non-molestation orders. So there's a squarely within the scope of legal aid. There are also then under 11.2 any civil legal services provided in relation to the following circumstances arising out of a family relationship, and that's an injunction following assault, battery or false imprisonment, or the inherent jurisdiction of the High Court. So where you've got a family relationship, which is defined as being a relationship between associated persons as defined under the 96 Act that we've looked at, then those matters are in scope. And there's also paragraphs 12 and 37, which may also be relevant. As I've said, though, if you look at the category definitions for under the 2018 contract, these are all the home rights, occupation orders, etc., are matters that come under the family contract. So my understanding is that you wouldn't be able to deal with those under a housing law contract. So with apologies for a slight race through some quite detailed provisions, I'm going to leave it there and hand over to Marie to talk about some of the financial issues in more detail.
While Marie goes to the stage of, I was writing notes and I got apply for an injunction to stop the tenant terminating the tenancy by NTQ. So you've got to get in there before the tenancy goes. Get your Section 30 rights to prevent the landlord serving an NTQ of their own, and then apply for transfer. I'm sure it's more complex than that. Marie.
Hi, hopefully this is going to be a little bit more familiar to everybody. So it's a really broad overview of lots of the common problems that come with domestic abuse and finances. Obviously that has an impact on rent arrears, and quite simple solutions that I think lots of us might not remember most of the time, and local authorities often forget about too. So there's going to be lots of times where they've completely missed a provision which would wipe out or really significantly reduce somebody's rent arrears. So, and then at the end, I'm just going to talk about some issues that arise with antisocial behaviour claims. So here I've outlined some of the common benefit problems that lots of us have seen. So the first I've spoken about here is economic abuse, and I've also included neglect. So what I mean by that, especially economic neglect, is you may be in a situation where a person who's experiencing domestic abuse might not strictly be liable for the rent under the tenancy agreement, so they're not getting any benefit of their own, but the person who is liable for the rent isn't paying it. So that leaves that person experiencing domestic abuse in a very sticky situation, facing possession claims, sometimes with very high rent arrears, and it's not always their fault. It's often not their fault at all. There's the costs of temporary accommodation. So I'm sure lots of us have seen this before, where somebody is very keen to move away from the property, has done a lot of work in, emotionally to prepare themselves to move away from the property and from the abusive partner, but there's financial realities and they're very nervous about the cost of temporary accommodation. So whether that's refuge accommodation, shelters, or just straightforward TA under the Housing Act. Related but separate, there's the other issue of having to claim for two properties. So I think it's very good to remember that you can claim for two properties, and I'll explain that in a bit more detail. So that is particularly useful when you have a person who has maybe a secure tenancy, an assured tenancy, where they used to live with the abusive partner, and for obvious reasons they're not keen to abandon that property. They intend to return, but temporarily that property is unsafe for them to stay in. Broad issues regarding children. So what I'm thinking about here is, and I've seen it pretty often sadly, is when there's domestic abuse issues, the children become involved, and sometimes are temporarily or permanently taken into care. So a property that was fully occupied suddenly becomes under-occupied by quite a significant margin. So a property where there used to be 3 children and 3 bedrooms, suddenly it only becomes occupied by 1 person. That becomes very expensive very quickly, and arrears mount up. And unfortunately, landlords, including social landlords, are quite keen to issue proceedings even in those circumstances. I'm sure we've all seen it. And finally, migrants' rights. So I'm certainly guilty of this. Oftentimes, when somebody comes to you and they don't have access to public funds, you feel stuck. There's absolutely nothing you can do. But there's actually some progress on this recently, which means at least temporarily you might be able to get them some financial assistance. I'm going to try and whiz through some solutions to these problems. Obviously, I'm not going to be able to solve the entire issue of economic abuse in one presentation, but as I said, these are just some simple solutions that it's helpful to remember. And the relevance to all of this to housing beyond the obvious is A, if a local authority in particular or a social landlord has, a local authority has completely miscalculated the benefit, or a social landlord or a local authority has just not provided any support and has not taken up some of these very easy solutions to the rent arrears problem, well, then you're probably going to have a decent public law argument. And as Sarah and Jamie, I think, are going to be talking about later, you might also have some disability discrimination arguments if the tenant is disabled. So the first hurdle is having to prove abuse to the DWP or to the local authority. It's an extremely difficult thing to do. It's an extremely difficult thing to speak to your clients about. Saskia very helpfully spoke to us this morning about how to do that sensitively, but there is a prescribed way to do it. There are requirements in order for the DWP to believe your client that there is some abuse that they've recently experienced and entitled them to a lot of these exemptions that I'm about to go through. So what you'll need to do is you'll need written evidence from a person in an official capacity, and I'll explain what that means later. That evidence will need to say that your circumstances are consistent with a person who's experienced domestic abuse or been threatened with domestic abuse in the last 6 months, and that you've made contact with that official to tell them about any incidents in the past 6 months. So a person acting in an official capacity, the DWP guidance is quite prescriptive about this, but I think particularly in the bottom category, it's easy to find hopefully some agencies that can help you. So the obvious one is a healthcare professional. So if your client's been speaking to their GP, as they often do, we always see that they're the first port of call sometimes for these sorts of problems. Have a look at their GP records. If there's a registered social worker involved, so a family support worker, something like that, if they've spoken to them about incidents of abuse, that's very helpful. A police officer, your employer, or a trade union representative. So that's expressly included in the list there, so that might be useful. And then finally, any public, voluntary or charitable body which has had direct contact with your client about domestic abuse. So if there's any people from law centres or legal charities in the room, then obviously that's very helpful indeed. See if I know how to use this machine. Okay, so helpfully we've had the Domestic Abuse Act come into force last year, or in 2021 in October, and Sue's going to hopefully speak to, oh no, she's grimacing, speak to us in a bit more detail about it. But one of the very useful things that it has done is really broaden the definition of domestic abuse, and in particular to include this idea of economic abuse. So as defined by the Act, it's any behaviour that has a substantial adverse effect on B's ability, so the survivor's ability to acquire, use or maintain money or other property, or obtain goods and services. I think that's a very broad, and it's designed to be a very broad definition, and quite clearly issues regarding rent arrears and payment of rent will fall within that. So in the context of housing benefit or your housing element of universal credit, that could include the perpetrator being paid the universal credit housing costs directly and spending it. So I know when they were introducing universal credit, lots of charities and agencies were saying they should automatically split the money between the couple just because it's obviously going to cause this problem. But unfortunately, they didn't. It goes into one single household. Or the perpetrator monitoring the survivor's benefit accounts to prevent a move, so they can see what you're doing and they can stop that before it starts. Very ambitiously, I've I've labeled the slide economic abuse solutions, but there are some limited solutions and, as I say, hopefully quite effective. So the first one is the alternative payment arrangement schemes. So I think lots of us will know about APAs because that's normally what you're asking a landlord to do, to take the rent arrears and the rent directly. But it's also open for a survivor of domestic abuse to continue to claim universal credit as a couple, but ask the DWP to split the award. So half of it will go to the perpetrator, who previously would have gotten the whole sum, and then the other half will go to the survivor. Usefully, if you're the primary caregiver, the guidance says that you might be allocated a higher proportion of the payments. The way you do that is you can basically do it in any way that you can contact the DWP. So you can apply by the phone, through the job centre, or through your online work journal. Obviously, that's going to cause some problems if your partner is monitoring the work journal, so probably best to do that by phone or by contacting the job centre. The second is to deal with this idea of financial neglect. So where a person is liable for the rent, so normally the person named in the tenancy agreement, the ordinary position is that housing benefit or universal credit won't be paid to anybody else. But what you can do is you can ask to be treated as liable for the purposes of universal credit or housing benefit. And you can do that if you meet all the following criteria. So if the person who's meant to be paying isn't, that's pretty simple. If you need to pay rent in order to stay in the accommodation, so very often you're going to have defendants in possession proceedings where it's quite obvious when the arrears are £14,000 that somebody needs to start paying the rent or else they're going to be evicted. And lastly, it's unreasonable to make any other arrangements. So the idea that the DWP is thinking about there is whether somebody else can be paying on their behalf. Again, I think for most of us and for most of our clients, that's going to be a fairly straightforward hurdle to overcome. And overall, it's reasonable to treat you as liable. I've had to apply for clients to be treated as liable a few times now, previously in the law centre and also now. I've yet to have somebody have this be refused. I'm gonna, oh no, Lou's looking at me saying that there's been a few. There we go. So if you challenge them, they back down, but certainly worthwhile. And I think your position in law is very good. And it's something you can raise at a first possession hearing if you see it. So the other issue is the cost of a temporary absence. So how can housing benefit and universal credit help you there? So the usual position is if you're absent from a property, the maximum amount of time they're going to pay you for is about 13 weeks for housing benefit. But if you can establish to the DWP or to the local authority that your absence is due to a reasonable fear of violence or a threat of violence, that housing benefit can continue in your absence for up to 52 weeks. That's if you intend to return to the property. But even if you don't intend to return to the property, but you've got a contractual obligation, it can continue for about 4 weeks afterwards. There's equivalent provisions in the Universal Credit Regulations, so 12 months. Now, both of them say fear of violence, which I think is quite a problematic provision, and I would have liked them to amend that as part of the Domestic Abuse Act, but they haven't. But helpfully, the DWP guidance is clear that the DWP has adopted the definition of domestic abuse as part of the Domestic Abuse Act 2021. And at paragraph, at paragraph 5.3, it expressly says that. So when you're talking about all these provisions that I'm explaining, if the DWP or the local authority comes back to you and says, yeah, I see there's economic abuse and I accept that there's economic abuse or any other kind of abuse, but there's no violence, point to that guidance, because I think it's an irrational reason to refuse. Similarly, there's provisions in housing benefit regulations and the universal credit regulations that allow you to claim for 2 properties. So obviously that's very helpful. The timescales are identical, so it's 52 weeks. and 12 months for universal credit. Again, both of those are pretty reliant on the person saying that they intend to return home. But in circumstances where they don't intend to return home, you probably wouldn't want them to be paying rent anyways, and they'd probably be asking to surrender the tenancy. And again, this idea of fear of violence should really be replaced by the definition of domestic abuse in the Act. So the bedroom tax. So as I said, this happens a lot where you have a client who, A, their partner has left, some of their children may be no longer residing in the property long term, and immediately they get stuck with the bedroom tax. So there are narrow exceptions. The one that I've pointed out here is the sanctuary scheme. So it might be something that everybody's familiar with already, but it's quite useful to be reminded of. It's a scheme to help domestic abuse survivors basically fortify their homes so they can, as part of the local authority, they'll help you to put in security measures to make sure that you can stay at your home and stay safe there. From the 1st of October 2021, the bedroom tax is not going to apply to people whose homes have been upgraded as part of the scheme. So I've provided the regulations there. So the requirements are that you've had home security equipment installed and that the perpetrator no longer lives at home, which will hopefully be the case. Oddly, there's an exception there for if the perpetrator is a qualifying young person. But again, I think that's probably going to be quite an unusual set of circumstances. What you do need is written evidence, again, from a person acting in an official capacity. So same rules apply as before. And that's not there out the kindness of the DWP's heart. It's because they were challenged, the JD&A, where the European Court of Human Rights said, well, it doesn't really make much sense for you to be penalising people to stay in their property when you've introduced this sanctuary scheme in order to let them stay there, which is lovely. And then we have the local housing allowance. So ordinarily, if you're under 35 years old, regardless of what accommodation you're living in, the shared accommodation rate of the local housing allowance is going to apply to you, and you're going to end up in rent arrears really quickly, unless you've got some other kind of income. That's not going to apply to you from the 1st of October 2022 if you provide written evidence that you've experienced domestic abuse at any time since the age of 16. Don't ask me what it has to be since the age of 16, I find that quite strange. For universal credit, you're going to receive the 1-bed rate, regardless of whether you're staying in shared accommodation or not. And for housing benefit, it's a little bit more difficult. You'll receive the 1-bed rate only if you have exclusive use of at least 2 rooms, so that's a bedroom and a living room normally, or exclusive use of 1 bedroom and 1 kitchen or a bathroom, unless you qualify for the severe disability premium, in which case it's the same rule as universal credit. And where all of those solutions aren't going to help you, one safety net that remains is the discretionary housing payment scheme. So obviously this is discretionary, but it is always worth a punt. So when there's gaps in rent caused by domestic abuse issues, so I've set out some examples there, that can be addressed at least temporarily by DHP. If any of you have ever instructed me, you'll know my advice is to make clear when you're making these applications that it is only going to be temporary, and to say why it's only going to be temporarily needed. So my client is hoping to downsize in X amount of months, or my client is hoping to take in a lodger in X amount of months. That makes it very easy for the local authority to make a DHP payment, where they might be very reluctant if they think they're going to be paying it for 10 years. But again, it is worth remembering that the DHP scheme isn't there because local authorities are nice. It's there because that's how they've avoided discrimination findings in various courts, and that's expressed. So that's at paragraph 14 of Annex A of the DHP guidance manual. It is there specifically to address inequities caused by the benefit reforms. And the way that they get around it is say, look, we can see that it might be discriminatory, but don't worry, the DHP scheme is there to help. So make them put their money where their mouth is and help your client out. And finally, migrants' rights. So again, I don't have all the solutions, but this is at least a temporary one. So it's possible to apply for the destitution domestic violence concession if you intend to apply for indefinite leave to remain on the basis of surviving domestic abuse, so it has to be for that reason. You've previously had leave to remain as the spouse, civil partner, unmarried partner, or same-sex partner of a British citizen, or a person settled in the UK. And you are homeless or cannot afford to meet the cost of housing or your family's basic living needs, so it's basically destitute. So the DDV concession entitles you to 3 months leave to remain, which is lovely, but also access to public funds for those 3 months. So that's really useful if you've got a Ground 8 claim or something like that, where the timing is really important. And then, on a completely unrelated note, I'm going to talk to you a little bit about antisocial behaviour and what you can do.
Not for long.
Not for long. Okay, that's great, because I don't have much to say. The first is to think about what your landlord can do for you under the Antisocial Behaviour, Crime and Policing Act, which is basically they can apply for an injunction. So obviously applications for an injunction can apply to just one person. And they can help you get a possession order against the person and then maybe re-grant you the tenancy. That seems a long-winded way of doing it, but it's possible. I've seen them try to do it. The difficulty with this statute is that oftentimes landlords will use it against you. So I have seen more cases than I'd like, where a landlord will apply for an injunction when the only allegations are things like, it's horrible, but things like the person screaming in the property, and they know full well why that person is screaming and shouting, or even trying to get a possession order for the same reasons. Obviously, the first way around that is to always rely on the court's discretion if it's not a mandatory ground. And certainly with an injunction, the court will always have a discretion not to make a possession order and not to make an injunction if the only things that are being raised are obviously arise as a result of domestic abuse. That's a very compelling argument to resist. And also, especially for social landlords, take a look at their policies, because they will have, almost all of them have very detailed policies about domestic abuse, but they say very lofty things. So again, make them put their money where their mouth is, and make sure to refer it to them if ever they issue proceedings, which are obviously silly. And with that, I'll leave it to Sue.
Thank you very much, Marie.
Hi everyone. Oh, great. I will be about 10 minutes.
Crossing my fingers.
Unlike my colleagues there. I'm really thrilled to be here and to see so many people who are interested in this, because at LAG me and a couple of barristers wrote a paper for the magazine a couple of years ago, and it remains one of the top 5 hits since then over the last 2 years. So it's a really important subject, and certainly something that we really need to get to grips on. And you can see from, I wasn't here this morning, unfortunately, but just listening to Dan and Marie, it's complicated. There's a lot in there, and we get very siloed in the way that we approach things. And so one of the things that I want to do at LAG is to try and have training materials that bring in lots of areas, and domestic abuse in housing is one of them. So apart from loving being in the same room as lots of housing lawyers, because I miss them, I'm really pleased to be here to talk about this. So first of all, it's interesting because I've got a report here from, Women's Aid, and I think it's worth looking at. It's 2020, and I'll try and not touch the thing, but it's 2020, and essentially it says domestic abuse is by its very nature a housing issue, and I think it really fundamentally is. And some of the stuff that the survivors are saying in here, if you leave an abuser, it's to be safer. If you're leaving for a life different but equally bad and unsafe, you might as well stay. And I think that's a really terrible position for a survivor to be in, to think that that's their journey. And we know from experience that that is often their journey. And the detail here is, 1/5 had moved over 3 times in more than the first year. And I think, we can do a lot better. So moving on to my next slide. So what does the Domestic Abuse Act do, 2021? And the paper that I'd written said it was a missed opportunity, and I think it was a missed opportunity for a variety of reasons. But it did extend the definition of domestic abuse. And you can see there the remit of that, and Marie touched on it as well. But I think what's interesting is that this is 2021, we had lockdown, and now we're starting to see the effects of what this actually means. And I had a conversation with a barrister from different chambers this morning, and she said she had a case at the moment where the local authority was saying that the survivor had, the property was now being put in a manner which made it more safe for her, and therefore she should stay there when she didn't want to. And the abuse carried on, and the police had got involved, and because it was just text messages, the local authority had said it's just text messages. So I think it will be really interesting to see how this kind of plays out in time, and you may well have got some experience of that you can talk about when we hopefully have enough time to have some questions after. So what it does do is it creates a lifetime tenancy. So it brings in 81ZA, and the local authority must grant a secure tenancy that is not a flexible tenancy to a former tenant or joint tenant if the tenancy is offered to a person who is or was a tenant of another dwelling house under a qualifying tenancy. And the local authority has to be satisfied that there is domestic abuse, the new tenancy is granted for reasons connected with that abuse, and the qualifying tenancy means that it was a secure tenancy. So we had hoped that, you know, there would be a lifetime tenancy for all survivors, but it isn't. You need to have had that secure tenancy first. Interestingly, Schedule 2, Ground 2A, domestic violence here, it is a ground for possession, but unfortunately, it seems as if local authorities don't use this. They very rarely use this against perpetrators, and it's something that they could do and something that we could look at in terms of trying to push that forward. The dwelling house has to have been occupied by the couple, civil partners, or a couple living together. One or both of the partners has to be a tenant of the dwelling house, and the partner is left because of violence or threats of violence by the other towards that partner. And the court has to be satisfied that the partner is left is unlikely to return. And we see that replicated again in the Housing Act 1988. So the guidance for local authorities that goes along with the Act does actually set out that where they're exercising a public function, as they are with housing, they have to have regard in the exercise of those functions to a number of things. And I've just picked out some here, but I think it's worth getting this guidance and going through it. The part on housing is, I think it's in chapter 6 of the guidance. So it's worth having a look at that, because it says that local authorities have a strategic duty under Part 4 of the Domestic Abuse Act to provide safe accommodation and accommodation-based support. And I think the person who I've spoken to earlier today, very much the local authority was saying that her accommodation was safe. So I think it's worth looking at this in relation to the duties that the local authority have in when there's a transfer, or when they're looking at whether or not that accommodation is really safe. Housing providers should have policies in place to identify and respond to domestic abuse, and so that's challengeable if they're not. And then housing authorities should work cooperatively with other local authorities and commissioners to provide services to tackle domestic abuse. So it'd be interesting to see what is actually happening on the ground and whether that is actually playing out. And then Tier 1 authorities in England are required to appoint a domestic abuse local partnership board to support local needs assessments and local strategies. And that doesn't apply in Wales. So my final bit is something that Dominic kind of sent over to me to think about what we could do with social landlords. So I think this is more of a discussion really in terms of this. Because social landlords clearly have management transfer policies. I mean, I don't know what you're seeing in terms of people, survivors applying and being turned down, and whether or not there's any challenges that can be made there, but that's obviously a possibility. Failure to investigate, could this be discriminatory if they don't, because the majority of survivors are women? And then again, the claiming possession. So the equivalent of the 2A is ground 14A of the Housing Act 1988. And it's my experience previously that it was very rare for social landlords to use this as a ground for possession against a perpetrator. But, you know, in different parts of the country, I might be wrong, there might be that being used, but I don't think so. I don't think we are actually seeing that. So there isn't very much in terms of other implications from the 21 Act into local authority and social landlords. And I think it's an opportunity for us to kind of push for that. And certainly there's been a consultation very recently from the government about joint tenancies. And I think Dan touched on the joint tenancy, and it really is a failing. And I think it's also a way of perpetrating further abuse by to the survivor, that if the tenancy is severed, then the tenancy ends, and so the perpetrator can hold that over the survivor. And so I think, you know, the government is looking at that at the moment. It's an opportunity. The consultation is now closed, but that might be something that will change. So hopefully it will. But I don't know when the results of the consultation and any changes will happen. So thank you.
Thank you very much, Sue.
Oh God, sorry. I had one left.
Do you want to speak to it, or should I leave it?
Well, we can. Sorry.
I think we'll take questions if that's okay. I'll just check. I don't think there are any questions online, but if there are any questions from the room, can I ask you, when you do get the microphone, just to speak clearly into it, so that anybody can hear? That's assuming that there are any questions to ask. Whilst you're thinking about it, I did note in Marie's talk the reference to antisocial behaviour, and that the way local authorities react, they get the complaint from the neighbours, not the victim, and they're only thinking about the neighbours. And somehow, strategically, we have to get them to think about that differently in that particular case, so that they stop those proceedings, etc.
Yeah, I've just got a question, I think, for Sue on 81ZA about having a new secure tenancy if you've had one before. I'm still quite hazy about how that works. Is that with the same local authority or after a homelessness application? How's that supposed to work?
I think it doesn't have to be with the same local authority. That's what I understand. It's if you've had one before, and I think, you know, the purpose of the Act is that you should be able to, you know, within there, that you should be able to go to another authority and apply. But I don't know if it's 21 Act. I don't have experience of people.
I can see how that would work with a reciprocate, but if someone's actually gone and applied as homeless
Yeah.
somewhere else, they're going to be owed the normal duties, which can be ended with a private sector tenancy. I'm just trying to work out how we could argue that it shouldn't, that it should be a social tenancy.
Yeah, I mean, I think it's interesting, isn't it? Because I think with one of the ways of protecting survivors is to give them you know, somewhere to move to instead of going through the homeless route, which we know is really bad. And so it gives that, it suggests that it gives that protection for survivors
It's
to.
difficult, isn't it? Because you can't be allocated social housing other than by Part 6. So
Yeah, so you may have to go through, which would then mean that you're going through the process of a homeless application, but at the end of it, you get a lifetime tenancy, but you're still going through that horrible process of applying. And you can see from, you know, the report by Women's Aid, you know, some survivors are moving, you know, there was one 9 times in a year. And you think that's just awful, and often children along with that, and then schooling and all those kind of problems. And so it's almost like we need to be going back to going upstream and trying to get the transfer or the change without going through the homelessness route, because that is crisis management really, isn't it? So it's kind of like maybe thinking and having some discussion about how we can do that and fighting for it, I think, really.
I've suddenly got this burning desire to ask Izzy Mulholland a question from this morning. And in fact, I've just seen her hand go up. So the question was, did she get a secure tenancy? Yes. Did she get the extra room? Yes. But did you get the lifetime tenancy as well?
Yeah.
I wonder if you could take the microphone.
Yay. So how did it work, Izzy? Sorry.
No, that's okay. I did a talk on it this morning, so I think everyone has notes.
Okay.
But now that we are talking about this and I have the microphone, I was going to ask a question. That is a question I get asked all the time, and it's about joint tenancies and management transfers. And I got this question again today after I gave the talk. And I've spoken to quite a lot of barristers about this, and the only advice I get from barristers is to advise that the survivor with the joint tenancy gives a notice to quit to their partner or ex-partner to then evict them from the property, and they can then transfer that tenancy to a safe property. But in many cases, that's not actually that preferable, especially if the survivor doesn't want to make the perpetrator homeless, because of all of the other things that happen in domestic abusive relationships, which is that there is also love, which we have to acknowledge. And so I was just wondering if we could use this opportunity to discuss that a bit and the solutions, possible solutions.
I'm going to ask.
Well, I mean, I suppose the kind of very broad answer on that, I realised that I spoke for the longest over time, so I don't want to take up lots of time here, but the powers that I've talked about under the Family Law Act give, I mean, certainly they give the courts powers to, for example, transfer a tenancy from joint tenants to sole tenants. That avoids the need to do things by way of notice to quit and termination of a tenancy. It doesn't obviously deal with the issue of, in effect, wanting to turn, I mean, it gives you a route for turning a joint tenancy into a sole tenancy of somewhere else. It doesn't give you a route, I don't think, to turning a joint tenancy into 2 sole tenancies. And that's the difficulty that I think really is at the heart of your question. I think that's probably quite difficult because of the apparent policy imperatives behind the various pieces of legislation. I think the courts would be quite reluctant to say that somehow because of domestic abuse, an abuser can be entitled to split the tenancy in that way, and so effectively get an additional, you know, the court's approach would be an abusive joint tenant should lose their tenancy and the other tenant should have somewhere to live, whether it's there or somewhere else. And I suppose the courts might see that as an abusive tenant because of the abuse being rewarded by getting another tenancy, if that makes sense. So I think that's half an answer and half another question.
Certainly the legislation doesn't look at it as grey areas. It looks for the victim and the abuser. And and identifies consequences from each. I've just got time, I think, 2 minutes for a question online. It's partly in relation to earlier discussion, but the question is, can you please clarify whether a move by management transfer and Home Assist application, fleeing, will both result in protection of a lifetime tenancy, i.e. must the local authority grant a lifetime tenancy in a Home Assist allocation if the reason is domestic abuse? Any takers?
I mean, it seems to me that that essentially touches on the same point that Lou raised.
Yeah.
It seems to, I mean, it's not something that I've looked at in detail, but looking at 81ZA now, it seems to me that the answer is open. I mean, certainly the wording of the section doesn't require it to be the same local authority, and it just requires that the tenancy is granted for reasons connected with that abuse, so the abuse that's been perpetrated. It's certainly a possible interpretation of that a tenancy granted at the end of a Part 7 process where somebody is homeless because of domestic abuse is a tenancy granted for reasons connected with the abuse. But I don't think we can be sure at this stage whether that is the case, and that obviously then means risk in relation to advising a client.
We're going to draw it to a close. Firstly, my thanks to the panel, very grateful to them, and my thanks to you for putting up with us as well. If you don't mind showing your appreciation to the panel.
So thank you for sticking with us all day. This is a session on domestic abuse, housing and the Equality Act. We've heard a few references throughout the day, in particular to the PSED, and this is an opportunity to explore that as well as other aspects of the Equality Act in a bit more detail as it may relate to the topic of today's conference. I've got Sarah Steinhardt with me. I'm sure she needs no introduction, but she did introduce herself this morning, in fact, for those of you that were here. She is a member and, in fact, co-head of our housing team here at Doughty Street, as well as a discrimination law specialist, which comes in handy for this panel. Joining her, we also have Jamie Burton Casey, who's the head of our Chambers Community Care and Health team. Much like Shushan, who we heard from earlier, he spans a broad and impressive range of areas of practice, including health and social care, homelessness, social security, and the rights of disabled children, or people, children and migrants, I should say. And in fact, Jamie and Sarah were a team on the highly publicised case of Natasha Abrahart, which was a discrimination claim that was incredibly novel against her university. You may have read about that in the newspaper. And so they're excellent people to be speaking to us today about the discrimination kind of angles in relation to housing and domestic abuse. Jamie will be kicking things off with an overview of some of the key aspects of the Equality Act, and Sarah will be following up with some case studies, some comments on PSED, and then bringing in some really interesting points about Practice Direction 1A, which is new in terms of kind of special measures that you might be looking at for your clients, for vulnerable clients in court proceedings, which fits in nicely with the discrimination theme or the Equality Act theme when we're thinking about reasonable adjustments we can attain for our clients in the context of proceedings themselves. So without further ado, I'll hand over to Jamie to take it away.
Thank you very much, Alice. Good afternoon, everybody. I'm sorry I haven't been able to be with you earlier today. It sounds like it's been a really great conference. In fact, I was speaking at another conference in Cardiff in Wales, which was remarkable for two reasons that I just wanted to highlight before I got stuck into the Equality Act. The first is, it was a human rights conference about the right to housing attended by about 4 members of the Welsh Government, which of itself I found quite surprising. The Minister for Social Justice, Jane Hutt, spoke about human rights with genuine knowledge and intention to use them. Can you imagine such a phenomenon in your government? No shame at all. Outrageous, obviously. But more seriously and relevant to today's topic, I was introduced for the first time to the Welsh Government's Violence Against Women, Domestic Abuse and Sexual Violence Strategy 2022 to 2026. And there you can see, I mean, I can't pretend to have studied it in any detail, and there may be some people in this room who know it much better than I. But again, really remarkable to see what a set of policies might look like when you're really serious about addressing an issue across a number of different domains involving multiple different stakeholders, properly funding civil society to deal with a proper legislative background upon which to act. I mean, extraordinary. And it just leave you wondering, you know, how much we have to put together our solutions from the scraps that we've got at the table, rather than being able to co-design with government, which really does address the problems that our clients are experiencing day in and day out, and which seem to be getting worse and growing in number. So by way of inspiration, I just thought that's good to know, that you can have a government that's interested in human rights, and you can have a government that's interested in implementing a proper strategy. That isn't to say the Equality Act isn't helpful, of course it is, but we all know the Equality Act has its inherent limitations. It's not really set up to deal with structural issues of discrimination, doesn't really allow for positive discrimination, and the PSED, such as it is, as Sarah will be setting out in due course, may have reached the end of its natural utility. All of which begs the question, do we need an improved legislative scheme in which to better ensure that the rights of women who are subjected to domestic violence, sexual abuse, are able to obtain relief? I'm sure Martin might have something to say about that in his closing address. Maybe not. Sorry, Martin, if you didn't intend to do that. Now you've got to. So leading on to the slides here, we've got a joint set of slides. As you can see there, I'm dealing with prohibited conduct under the Equality Act, and then Sarah is telling you how to apply that in practice. And just moving on, I've got to do this simultaneously. I may not be great at that, so yeah. So you can see there, set out first of all are the spheres of activity that the Equality Act covers, and in respect of which prohibited conduct is by and large prohibited, with some degree of variation across those different sectors. And of course, the ones that we're most likely to be concerned with in the context of housing are the first two: services and public functions and premises. And then the different types of prohibited conduct are set out there. You'll be familiar probably with all of those terms: direct discrimination, indirect discrimination, disability discrimination, failure to make reasonable adjustments, harassment, and victimisation. The subject being what it is today, really I'm only going to look at direct discrimination, indirect discrimination, and then a very little bit at harassment and victimisation. If we tried to shoehorn disability into today's session, it wouldn't have been possible in the time that we've got. Just important to keep in mind the importance of statutory guidance in this context. It must be taken into account. It's mandatory statutory guidance in that regard, and there is indeed specific guidance on disability that you should probably be aware of. But the first set of guidance concerns services and public functions, and will therefore be relevant, particularly if you're dealing with public authorities. So the protected characteristics, I'm sure we're all reasonably familiar with those, but just a quick reminder of them. And of course, the one that we perhaps are most concerned with today is section 11(6). Direct discrimination. So direct discrimination is, of course, concerned with where a person discriminates against another because of a protected characteristic. A treats B less favourably than A treats or would treat others. The comparison must be such that there is no material difference between the relevant circumstances of the claimant and those of his or her comparator. I mean, the basic point here is about direct discrimination is this is, of course, discrimination based on the protected characteristic itself. When you're looking for a comparator, it can either be somebody real, somebody who's actually been affected by the decision maker in one way or another, or a hypothetical one. If you think the case can be made out, that it's clear that the treatment that your client has experienced would have been different had they not shared the protected characteristic in issue. You do need to keep in mind, of course, that direct discrimination is something that is very rarely admitted, and there are provisions in the Act, and I think Sarah's going to talk a bit about burden of proof in that regard. The other point to keep in mind about direct discrimination is sometimes you're dealing with proxies for a protected characteristic, i.e. a matter that so closely relates to a particular protected characteristic that it is effectively the same thing. And so in the context of age, for example, pension entitlement could be treated as a proxy for the protected characteristic, and therefore you're in the territory of direct discrimination as opposed to indirect discrimination. Also important to keep in mind, just that last bullet point there, that direct discrimination obviously also includes perceived and associative discrimination. If you are perceived to have a particular protected characteristic and are treated adversely as a consequence, that can result in a violation of Section 13. So indirect discrimination. Oh, not working. So very important to understand, I think, conceptually, before we look at the provision, what we're really dealing with here and why it's different from direct discrimination. So the rule against direct discrimination aims to achieve formal equality of treatment. There must be no less favourable treatment between otherwise similarly situated people on grounds of colour, race, nationality, or ethnic or national origins. Of course, that's not the full list of protected characteristics. Indirect discrimination looks beyond formal equality towards a more substantive equality of results. Criteria which appear neutral on their face may have a disproportionately adverse impact upon people of a particular colour, race, nationality, or ethnic or national origins. And again, of course, that is just doesn't purport to be an exhaustive list of all the protected characteristics. But the key point here is you're dealing with something which appears neutral on its face, but nevertheless has a disproportionate impact on a group who share a particular protected characteristic. So just continuing with this theme of trying to understand conceptually what indirect discrimination is concerned with, the law of indirect discrimination is an attempt to level the playing field by subjecting to scrutiny requirements which look neutral on their face, but in reality work to the comparative disadvantage of people with a particular protected characteristic. The resulting scrutiny may ultimately lead to the conclusion that the requirement can be justified. There are two important parts to this quote. The first is one which I think is very useful sometimes, particularly when dealing with judges who are perhaps not that familiar, or indeed opponents who don't seem that familiar with indirect discrimination. Sometimes they can contend that because you're dealing with a relative, what appears to be a neutral rule or a neutral measure, you're trying to gain some kind of advantage for your client by saying the measure shouldn't be applied to your client in that way. Of course, that's not really true. The point is here that you're trying to level the playing field. The rule itself creates a disadvantage in fact, and what you're trying to do with your discrimination claim is eliminate that disadvantage. Sometimes that isn't immediately obvious to decision makers, including judges. It looks like to them, to the untrained eye, well, you're trying to get something extra for your client. So, for example, I did a case not that long ago about discrimination in the context of housing on behalf of people who weren't of British origin, and it was about a residence rule. And our case was, well, the residence rule shouldn't be applied to us. We shouldn't have to demonstrate that we've been living in a particular area for 10 years before we qualify for housing. And the other side's case was all about, well, you're trying to gain advantage from people from abroad. And we were actually at point trying to really stress that it was the opposite way. We were just trying to level the playing field to give people who are from abroad the same access, putatively at least, to housing. The second important point that comes, of course, from this quote is that indirect discrimination, unlike direct discrimination, can be justified. It may well be that the justification for the seemingly neutral measure is such that the discriminatory impact is not so bad as to mean that the measure should be deemed unlawful, effectively. And in due course, we'll see that in the provision itself. Another important point to understand about the difference between direct and indirect discrimination is about how causality works. In the context of direct discrimination, you've got to show that the difference in treatment is actually a consequence of the protected characteristic. Sometimes that's done by way of inference, but you're still inferring the causality. You are treated differently because of the protected characteristic. Not so in the context of indirect discrimination. Indirect discrimination is not really concerned with the cause, at least in terms of establishing that there's a difference in treatment. It might be relevant to justification. All you need for the purposes of indirect discrimination is to be able to demonstrate the causal link between the measure itself and the adverse impact on a particular group, which may or may not be intended. It doesn't actually matter if it's intended or not. So section 19 actually gives us the definition of indirect discrimination. A person discriminates against another, or A discriminates against B if A applies to B a provision, criterion, or practice which is discriminatory in relation to a relevant protected characteristic of B's. For the purposes of subsection 1, a provision, criterion, or practice is discriminatory in relation to a relevant protected characteristic of B's if A applies or would apply it to persons with whom B does not share the characteristic. So there you see the neutrality provision. It puts or would put persons with whom B shares the characteristic at a particular disadvantage when compared with persons with whom B does not share it. So A, apparently neutral provision, everybody's treated the same. B, disparate impact on the group who share the protected characteristic. C, it actually puts B at that disadvantage. In order to bring a claim on behalf of an individual or group of individuals, you need to demonstrate they actually do experience a disadvantage. And then in terms of justification, A cannot show it to be a proportionate means of achieving a legitimate aim. So there we see this notion that indirect discrimination can, of course, be justified. So in terms of that definition, shares with, the important characteristic of indirect discrimination is that the person claiming that a PCP is discriminatory must be at a disadvantage as a member of a group of people, whether real or hypothetical. So it's not just about disadvantage experienced by a single individual. And therefore, the comparative exercise that's necessary under Section 19 is between a pool of people who share the person's characteristics and those who do not. Not all members, however, of a protected group need to be disadvantaged by the PCP. You just need a disparate impact. So you must be able to demonstrate group disadvantage, but unlike in the context of direct discrimination, it's not necessary to show that everybody is adversely affected. So if you have a particular housing rule, for example, that favours people who are in full-time work, that may have a disparate impact on women. Women tend to, as a question of fact, be less likely to be in full-time work. But it doesn't, of course, mean every woman's not in full-time work. Some are, and they may nevertheless benefit from the rule. But that rule may still be discriminatory and require justification if there's a disparate impact on women who share the protected characteristic, of course, of sex. And interestingly, it's the wrong approach to do what was done by the judge in the Gulu case. In fact, the one I mentioned earlier about housing and residence requirements. What the judge did in that case was say, well, it may well be right that somebody from abroad is less likely to meet the requirements of this residency rule, 10 years residence within the area of Hillingdon. But so might somebody who's not from abroad, i.e., as the judge suggested, somebody from Aberdeen or Glasgow, maybe just as unlikely to meet the requirements. They may have come to London just in the same way somebody might come to London from France. And he said that meant that there wasn't any discrimination that needed justification. And unsurprisingly, one might think that was considered to be the complete wrong approach by the Court of Appeal, who said he was missing the point that you had to look at groups of people and how they were affected generally. And the point was, generally speaking, people who are from abroad were more likely to be unable to meet the residence requirement than people from the UK. And therefore, there was a discriminatory impact that required justification. So what is a PCP? Policy, criterion, or practice? Well, it's a very loose definition. It's not limited, as one might think, to strict policies as such. It's not limited to what a particular service provider or public authority says. This is our policy, by the way, and this is how we treat everybody. That is not a prerequisite to bringing an indirect discrimination challenge. But you do need to be able to demonstrate, even if the particular PCP has only been applied once to your particular client, that it is something that would ultimately be applied to other people. It has to have the feel of being a rule independent of the person it's being applied to, if you can see what I mean. Now, it's not actually a particularly precise legal definition, but the courts don't struggle too often these days, Sarah, you might have a different view, in identifying a PCP. But you, when advising your clients, need to be aware that you're not necessarily restricted to finding, as I've said earlier, clear policies or things which are said to be policies or practices that have clearly pre-existed for some time. It can indeed be established by reference to only a single instance of applying a particular approach to a particular scenario. I hope that's reasonably clear, or as clear as it's going to get. Just a couple of points about evidence gathering in the context of indirect discrimination. One of the points about the reformulation of indirect discrimination under the Equality Act, which was designed to benefit claimants, was it was no longer necessary, at least not always necessary, to have statistical evidence of the disparate impact. Sometimes it could be assumed. So again, just for the purposes of the example, the Gulu case I mentioned a moment ago about the residence requirement, we didn't require evidence to demonstrate that as a question of fact, the number of people who were failing to comply with that residence requirement, who were from abroad, was greater than the number of people who were failing to comply with it from within the UK. That wasn't a necessary prerequisite for us to establish discrimination that then required justification. It was assumed to have that disparate impact because it was so obvious that it would, as a conceptual point, rather than one which is empirically demonstrated. Now, that doesn't always flow, and it does depend on the particular PCP with which you're concerned. But you need to ask yourself this question. Is it obvious that this particular rule is likely to have a disparate impact on a particular class who share a protected characteristic? Or can I otherwise demonstrate that by reference to publicly available information, which may simply confirm your hunch that it's highly likely to have that impact? Or do I in fact not know one way or the other whether indeed it does have that disparate impact and need to work it out and see if indeed that's true? It may well be your client tells you, look, I happen to know many other women are similarly adversely affected by this rule. Or it might be that you have to do some digging around yourself. And here is just a list of some of the sources of potential information or data that might help support your contention that a particular PCP has a discriminatory impact pursuant to section 19. So justification and proportionality. I mean, the most important point, I guess, about justification and proportionality, which is in the slides and should be, is the burden is on the duty bearer to demonstrate, once you've established disparate impact, that it's justified. I.e., they need to be able to show that the particular measure in question achieves a legitimate aim, and the importance of that aim is such that the discriminatory consequences are nevertheless acceptable or justified. And you can see straight away that there's a strong element of social policy to that. And indeed, what the case law really establishes in a nutshell is that if a public authority has an ostensible justification, which it has considered and properly gone through the process of considering, identifying the disparate impact, if you like, owning it and saying, despite that, we're still going to pursue our policy, then it's quite difficult to persuade the courts to intervene. On the other hand, if, as is sometimes the case, a public authority says, oh, we don't accept this has any disparate impact, only for you to then demonstrate that it does, it's much harder for them to then justify that disparate impact because they haven't thought about it at the time they formulated the rule. Not impossible, still permissible for there to be what's described as retrospective justification, but it's harder for the public authority. And one important component of that analysis is whether or not the public authority can be shown to have complied with the public sector equality duty. And Sarah will talk a bit more about that. But there is a connection between an apparent failure to comply with the PSED at the time that you formulate your particular PCP and your capacity as a public authority to subsequently justify discrimination that's consequential to the particular PCP in issue. GULU is in, it's not there. Why is it not there? The interesting point about GULU, which for some reason I missed off the slide, just give me a moment. Oh, where have I gone?
Mine.
Really isn't
Oh no,
right.
you've spoiled the surprise, David.
Oh no. Why is it going the wrong way? Hold on a minute. I really have ruined the surprise here. Is that
Yeah, you have.
I can't
Don't everyone close their eyes.
Why can't I get back onto my one?
Go back.
Right, I thought I was going back. I'm really sorry about this.
None of you need to hear from me now. It's fine.
Seminar's
Got it
ended.
all.
Thank you very much, everyone. Okay, I'm really sorry. Can someone else do this? I don't know what I've done.
I think Ray looks like she's coming to the rescue.
Anyway, natural pause. I told you there's no way I could do two things at once.
16.
Oh, well done.
Oh, it will be, yes.
It's the one that
We need an image of a little girl with a chalkboard and a rag doll, don't we?
Oh, it's 101. God, I really have made a mess of this. No, keep going. Hold on, slow down. Yes, thank you. Let me just, I'm just going to check I'm doing this right.
Right.
Shall I take that off you, Jamie?
Possibly, hold on a minute. Why is it not, it's really not moving now. Can you leave it on one? See, it wasn't just me, I knew it wasn't.
I've not pressed anything. Shall I try now?
Hey.
Back in action.
Right, back to it. So again, on the question of proportionality and justification, these are a couple of cases which, there are thousands of cases on justification, right? And a lot of them are just based on their facts, so there's not necessarily a lot you can glean from them. But I've tried to just bring out a couple of points here which are kind of relevant to the housing context. H and Ealing is a case about allocation schemes. And what's interesting about this case is a particular feature of the allocation scheme was the identified PCP. There was a rule within the scheme about how a proportion of the council's housing stock was allocated to certain people based on priority, I think, in relation to working. And that was shown to be discriminatory because it clearly had an adverse impact on women and disabled people who are less likely to be in work. And therefore, there was discrimination that required justification. But when it came to justification, it was legitimate, the Court of Appeal decided, for the local authority to point to the impact of the scheme overall on women and disabled people. And they came out better than other groups who share protected characteristics when you looked at the scheme overall, in the sense that they were more likely to be allocated social housing than other groups. So although the particular PCP that had been the focus of the claim was discriminatory in effect, it was nevertheless justified because when one looked at the overall scheme, one could see that people who shared that protected characteristic did fairly well. That's to be contrasted with the scenario in Gulu, where what the local authority tried to argue there was we could clearly show that the 10-year residence requirement had a disproportionate impact on people from abroad, which required justification. And what the local authority tried to say about justification was they couldn't point to the scheme itself as benefiting people from abroad in some overarching way. But what they tried to say is, yeah, but we do help people from abroad by use of our homeless provisions. So we can justify it by reference to that statutory scheme. Which the more I say that out loud, the more bonkers that submission sounds. But that's actually what they said in court. And interestingly, the Court of Appeal rejected that. But what they said in the context of that was that you couldn't justify discrimination in the context of Rule A by looking to Rule B. So there's a subtle difference between those two scenarios, which hasn't really been fully tested in the case law as far as I'm aware, but you just need to keep an eye on it because local authorities and others may have may be attracted by the idea of trying to justify a particular PCP's discriminatory impact in that way. The C case is only relevant because it's another example, and in fact there's been a more recent one, with the ex-passport case, Ellen Kane, where the Supreme Court have allowed administrative convenience to justify a discriminatory rule, i.e. it would just be too much effort to correct the discrimination. I'll just leave that one with you. And then finally, a couple of cases there, which were brilliant cases brought by Shelter, who wanted to address the no DSS policies that many private landlords had, which have been shown to be discriminatory on the grounds of sex and disability. Why? Because people, women and disabled people, more likely to be on benefits and therefore more likely to be affected by the rule, and there was no justification for that rule. Can we move on, please? Nearly finished. Yes, on the question, related really to the question of administrative convenience, is cost. It used to be considered correct to say that you couldn't justify discrimination by reference to cost alone. In other words, you couldn't have a discriminatory rule and say, well, you know, we can't afford to give everybody the benefits of the particular service in question. That can never justify discrimination if you think about it. You know, like, how could that possibly explain why some people get it and some people don't if it's just about money? You know, then you just have to create a way in which you give everybody the same access to the benefit, irrespective of their protected characteristic. However, over time, that rule has been changed into what's been called cost plus, which is costs are a relevant consideration to justification so long as there is some other independent reason for it. Heskett is an annoying case because what they sort of said in that case, well, costs can be a reason that it's low effectively, because the plus can be the need to stay within budget. So I've set a budget, and now if I've got to meet it, so that's my extra reason on top of cost. Leave that one with you. Yes, and the last bit there is also potentially more likely to be practically relevant, that there may be justification for short-term indirect discrimination, even if one couldn't justify it in the long term. Can we move on, please? Okay, very quickly now, harassment, another form of prohibited conduct. This is where A engages in unwanted conduct related to a relevant protected characteristic, and the conduct has the purpose or effect, important distinction between those two, of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. Just a couple of points about that. Related to is intended to be a broad test. It doesn't have to be because of the protected characteristic, it has to be related to it only. And it's a bit like disability discrimination. If you can demonstrate that the disadvantage as a consequence of, if you can demonstrate, sorry, that the treatment is related to the disability, i.e. maybe relate to some manifestation of the disability, then that may be sufficient to bring it within the parameters of disability discrimination under section 15. Under section 26 in relation to harassment, it's the same. If you're harassing somebody not because they're a woman, but because of some aspect which is related to them being a woman, then that may be sufficient to demonstrate harassment. And next slide, please. Oh, yeah, just the point, unwanted conduct can include inaction, failure to do something, failure to respond, for example, to complaints, etc. Next slide, please. Victimization, finally, is where A victimizes another person if A subjects B to a detriment because B does a protected act, or A believes that B has done or may do a protected act. And protected act is effectively complaining about discrimination in one means or another. And of course, that's very important because sometimes we do see our clients treated as complainers and as a consequence subjected to further adverse treatment, principally because, of course, there is either a non-acceptance of the underlying discrimination or there is a failure to treat it appropriately as discrimination. Okay, that's me. Thank you very much. Over to you, Sarah.
All right, thank you very much, Jamie. It's important to bear in mind when we're talking about discrimination and the Equality Act in the context of domestic abuse, that the Act only covers vertical relationships. It doesn't cover the relationship of one intimate partner towards another intimate partner. That doesn't mean that it isn't relevant, but that it's a really important thing to keep in mind. So the sorts of solutions or questions or points of interest that we're going to be looking at they have to be viewed in that light. So as Jamie said, we're going to be looking at really part 3 and part 4. So part 3, services and public functions, and part 4 is premises. So because the Act only covers vertical relationships, there are 2 situations really where it's going to arise in the context of domestic abuse. The first is where the landlord themselves is the abuser, and the second is where the landlord has in some way piggybacked onto that abuse. They've failed to investigate it, they've failed to deal with it, or they're making some sort of adverse decision, including a decision to seek possession, of course, on the basis of some feature or some aspect of the domestic abuse. Now, you may think, and this is where I had my big surprise point that it's not going to happen now, but you may think, I'll pretend that you didn't see the slides already. You may think that it's unlikely that the landlord would be the abuser in a domestic abuse sort of situation, but sadly you would be very wrong. So the figures for what has been called the sex for rent scandal are quite horrific. So you can see the reference at the top to a man being jailed. That's because there's now a specific offence of pursuing a sex for rent arrangement. A recent report found 60,000 women had been affected by this, 1 in 10 of poorer female renters. So this is a big deal, actually. More headlines here. So the point here is that while we as housing lawyers typically deal with tenants of large social landlords, where we expect a certain level of professionalism and reasonableness and so on, and a certain depersonalization of the landlord-tenant relationship, it's important to bear in mind that there are an awful lot of women who are in much less secure, much more precarious arrangements. And this might just be private tenants renting from a dodgy landlord, or it might be more informal housing situations, so lodgers, house shares, things of that nature. And these are some of the rather horrendous figures that were produced by Generation Rent and Mumsnet. So 4% of respondents being offered free or discounted rent in exchange for sexual favours, 14% experiencing suggestive remarks, 4% experiencing unwanted touching. This is from your landlord. It's pretty horrible. So, as I say, I'm going to deal first of all with the situation where the landlord themselves is the abuser, and then I'll deal with the sort of indirect issues that we can deal with under the Equality Act. So where we're looking at the landlord themselves, there are 2 sections which are relevant really. Section 33, which is to do with disposals, that's when you're applying for a tenancy or you're asking for a tenancy. And the second is where you are already a tenant, so that's section 35. And here's section 33. So these are the sorts of situations which Jamie talked about briefly. So for example, not getting a tenancy because you're on benefits. It also covers the sex for rent sort of situations that I mentioned a moment ago, so being offered cheap or no rent. And bear in mind, of course, disposals covers not just an application for a tenancy or a request for a tenancy sort of from the start. It also covers transfers, management transfers and things like that. Section 33 also prohibits harassment and victimisation. Section 35 is what we're normally going to be dealing with. So that covers the landlord-tenant relationship, although actually that's rather narrower. I'm expressing it in a rather narrower way than it truly is, because it's really important to bear in mind the word occupies. So we're not just looking at formal landlord-tenant relationships, but anyone who is occupying let premises. Again, there is a prohibition on harassment and victimisation, as well as discrimination. And that's why we talk about prohibited conduct instead of just discrimination. That's because technically victimisation and harassment are not forms of discrimination under the Act. I haven't actually put what section this is. This is section 38. And this is just to reinforce that we're not always looking at formal tenancy we're not always looking at who is the landlord, who is the tenant, and that it also covers, you can see it section 38(4), it also covers being granted a license. So that would cover lodger arrangements and house shares and things like that. It also means that you don't have to worry about landlord-tenant technicalities and land law issues. So section 35 applies to both public and private landlords, and it can be used as a defence to a claim for possession. As I'm sure you're all very familiar with using this in the context of disability discrimination, and particularly section 15 discrimination. But it can also be used in the context of sex discrimination, which when we're looking at domestic abuse, it is often going to be. It provides a defence to mandatory grounds as well as discretionary grounds, and that will be important when we think about some of the examples that Dan gave in his talk. So, for example, a joint tenant serving notice, or it might cover a closure order that has been made in respect of the abuser's behaviour, frankly, and which causes a closure order to be made. It might also cover non-occupation, where a victim or survivor has fled the premises, perhaps leaving property empty. So it's important to have this as part of the tools that we have available. Section 109 covers the liability of employers and principals. This is important where you are dealing with corporate landlords who may or may not be a sort of real company, in the sense that it may just be one man who calls himself a company, or it may be one of these rather dodgy offshore property investment companies with a shady list of directors and no publicly available information about them. So in those circumstances, the person that you have been dealing with as your landlord, they are liable, that they make your landlord liable. There is a defence that employers can rely on in that situation, and you can see that defence at subsection 4. But they have to plead it, they have to argue it, and they have to prove it. They have to prove that that defence applies, and that can be quite difficult. So strategically, that's why section 110 is also important, because section 110 puts liability on the individual employee as well. And so that means that when you're bringing a claim of discrimination, which is in respect of this sort of behaviour, so not a kind of corporate failing, but the behaviour of one individual. When you're looking at that sort of situation, actually it's helpful to bring it against both. You bring it against the individual and against the employer, and strategically what often happens is that you agree to release the individual on the basis that the employer will accept responsibility for their behaviour. So you use it as a bargaining chip, the fact that you're bringing a claim against both. So here's an example, and I've got a few examples to give of cases that I have done. They've all settled. None of them are of any sort of weight at all, and I don't know how any of these cases would have worked if they had gone to trial, but hopefully they explain a little bit about how some of these arguments might be framed. So this was a person, I'm calling her Ms. A. She moved into a property having been given the tenancy by a Mr. B, I'll call him. Now, Mr. B was only interested in Ms. A. He wasn't actually, this wasn't a business arrangement. This was a vehicle for him to sexually harass younger women. That's exactly what it was. And when she didn't submit to his advances, he came up with some absolutely ridiculous story about how he hadn't been involved, and then he said, I think that she was his ex-girlfriend. I mean, he came up with all these ridiculous explanations. I mostly remember this case for the fact that he denied having been involved at all in granting the tenancy, but we managed to get Gumtree to disclose all his information, all the adverts with his phone number on it and his email address on, and all the correspondence. And it was just one of those glorious moments that you imagine from TV is going to be your entire career, where you get to go, aha, but you haven't seen this, and they sheepishly crawl off into the corner. And anyway, it wasn't quite like that. But after a couple of exciting hearings, we did settle the case. But the point is that, as well as all the sort of obvious points and factual points that we were making, we also argued that that this was sexual harassment, and sexual harassment is different from harassment related to sex, because it is harassment which it's unwanted conduct which is of a sexual nature. So it's a different sort of behaviour. It's about making advances towards someone, being rejected, and the way that one responds to that rejection, and so on. Here is another example. Ms. B was the tenant of a private landlord, and after she had not been in the property for very long at all, her account was that her landlord raped her, and that he told her she didn't have to pay rent. And I don't think it was ever particularly clear whether that was a sort of, he imagined that he was buying her off, or what the deal was, but those were her instructions, and they were and some of what she said was not disputed. So the landlord brought possession proceedings on grounds of rent arrears, because she wasn't paying the rent, and the claim was defended on the basis of again, victimisation, sexual harassment, harassment related to sex, and trespass against the person. And again, the case was settled. You can readily imagine how that is not the sort of case that you really want to litigate in the county court in the context of a housing case. So that's the situation where the landlord is themselves the abuser. But of course, most often we're going to deal with it in the situation where it's not so direct as that, but rather we're looking at the landlord's failure to investigate, failure to deal with, failure to address or understand the situation insofar as there is domestic abuse. So this might be a breach of the PSCD. We'll come to that in a bit more detail in a moment, as part of a public law defence. And as Jamie mentioned earlier, I think we as housing lawyers are all pretty pessimistic about what the PSCD has to offer us. But worth bearing in mind, perhaps, that when one is looking at sex as a protected characteristic instead of disability, a lot of landlords just don't even think about it. We don't have to get into, have they understood the full depth and scope of their duties, because they haven't considered it at all. They haven't done anything. They haven't even got off the starting blocks. So it could be part of a public law defence, or it could be, as I've already indicated, part of a defence and potentially a counterclaim to a possession claim. So first of all, the public law defence and the PSCD. So this case here of London Quadrant and Patrick, I'm sure most of you are familiar with this. It's only a High Court case. It's not the most authoritative, but what it does do really helpfully is just sum up all the principles that we need to look at really when we're looking at the PSCD, and it's become a bit of a sort of one-stop shop for everything that we need to consider. So here is the PSCD. You're all familiar with that. I'm not going to dwell on it. Something that I did want to mention in the context of section 149(3). So this is that having regard to the need to advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it involves having due regard, in particular, to the need to remove or minimize disadvantages that are connected to that characteristic. And if you've ever heard me talk at one of these things before, I'm at pains to bang on about the fact that when one is looking at the PSCD, you have to really read it. You have to really go through all of it and understand what each line is saying and what each part of it is doing. It isn't, as lots of landlords will tell you, a duty to have regard to the PSCD. That is very often what they think it means, and you end up with this sort of bizarre circularity. So when we're looking at removing or minimizing disadvantages suffered by persons who share a relevant protected characteristic that are connected to that characteristic, domestic abuse is a disadvantage which is connected to the characteristic of sex. But you may have to say that. You may have to say that quite explicitly. That's what it is. That's how domestic abuse becomes relevant in the context of the PSCD, because it is connected to that characteristic. And likewise, in respect of section 149(3)(b), it is, or it may relate to or lead us to needs which are different from the needs of persons who do not share that characteristic. And it may require treating a person more favourably. So the statutory purpose of the PSCD, which is important to bear in mind, is that really it's about making consideration of those statutory imperatives a routine part of the decision making of a public body. That it should be at the centre of the decisions that they make, and it should be considered. And that's why it's so important when I said to you a moment ago about the fact that so many public sector landlords don't even think about this as being a protected characteristic at all. They think about disability, if you're lucky, but sex and domestic abuse, it doesn't, it's not something which is considered in any particular depth. So Patrick came up with these 7 things to bear in mind. So I'm going to follow that structure. So the PSCD comes up and needs to be applied whenever a decision is being made, whenever a function is being exercised. And Freeman Roach tells us that really it's going to be much more relevant when one is looking at evaluative decisions, so what is reasonable, for example, than it is about factual decisions. The nature of the duty. It's not a duty to achieve results. It doesn't lead to any particular conclusion. I'm sure that you all know this, but it is about understanding the situation that a person is in and putting that understanding of a particular person's situation into a wider context. And that wider context is about driving forward equality of opportunity. So while it's not a results duty, you can easily see how when one's looking at indirect discrimination, and I've also referenced Zimmernos discrimination, which is not under the Equality Act, but I think helpful to sort of bear in mind. When one's looking at indirect discrimination, it does often lead to the conclusion that actually they should have done something in particular. That if you've got some sort of disparate impact, if you've got a discriminatory impact, that the logical conclusion from that is, well, then they should have done something about that. They should have done something differently. So while it doesn't necessarily follow, it often will. Inquiries. So part of the duty under the PSCD is to find out about the way that a protected characteristic is impacting somebody, the way that their situation fits into that context of promoting equality of opportunity, eliminating discrimination, and so on. Understanding what their situation is and throwing a light on it. It must be considered, the statutory objectives must be considered consciously. The conscious approach and the state of mind, the duty must be carried out in substance, with rigour and with an open mind. It's a trite principle of law that a public sector landlord shouldn't have blanket policies, but of course they often do. But they shouldn't. What they should be doing, certainly where a protected characteristic is engaged, is think about how they are carrying out their functions, what they might do differently, how they can promote those statutory imperatives. And it's a continuing duty. Now, in most cases, it's not going to matter too much that it's a continuing duty, because the local authority will have made its decision, and that will be fine. But very often, especially in the cases that we are involved with, perhaps there hasn't been a great deal of communication with the landlord, and the landlord only finds out that there is this background of domestic abuse when we tell them, when we say this is what's been going on. At that point, once a public sector landlord knows that this is an issue, at that point, then they need to start thinking about those things that we have seen earlier set out in section 149. And because of the nature of what the duty is, of course, it has to be carried out before a final decision is made. Otherwise, it's all just a bit pointless, isn't it? Recording and reasons, and we'll come back to this in a moment when we're looking at the burden of proof. But essentially, a public sector landlord should be in a position to be able to prove that they have complied with the PSCD. And finally, it isn't for the court to make a value judgment on the decisions that a public sector landlord has made. If the PSCD has been complied with, then the weight that should be attached to the different competing factors as informing its decision, that is a matter for the landlord, and it's not for the court to interfere in that. So I've talked about the PSCD. The other issue that will come up is indirect discrimination. And that will often overlap, of course, with the PSCD, because frankly, indirect discrimination often comes up because a public sector landlord hasn't thought about the situation enough. So legally, they're entirely separate concepts, but practically, they often come hand in hand. And the other point which might come up is third-party harassment, which Jamie mentioned. Now, indirect discrimination, Jamie's already dealt with, so I'm not going to come back to that. And harassment, he has also already dealt with. Just the point that Jamie made about unwanted conduct can include a failure to act, but only where, by failing to act, the landlord is themselves creating that offensive, degrading and hostile environment. So it's more than just a failure to act. It's a failure to act which is of such a level of severity, if I can put it that way, that really the victim feels like they're in on it, that they're part of it, that they've become a part of the abuse, that they've adopted the abuse as their own. So the way that it's described in Conte is, to the extent that the failure to support him or her actively made the position very much worse, effectively ensuring that there was no light at the end of the tunnel in remedy of the situation. But it's not just a failure to act. A failure to act which is caused by incompetence does not amount to harassment, because the incompetence is not related to sex. So Conte and Parking Partners was a situation involving racial abuse. Nailard and Unite the Union was about whether or not an employer could, in fact, there was a whole issue about whether or not they were the employer, but we can park that for now. Whether or not an employer could be liable for the sexual harassment of its employee. And the point, and in that circumstances, they couldn't, because although they had totally failed to deal with it and totally failed to investigate or do anything, it was sheer incompetence. The reason why they had failed to investigate was not related to the woman's sex. That said, of course, if you had statistical evidence which showed that they did investigate other sorts of complaints, of course, you might be in a very different position. So some examples. So this was a case of mine a couple of years ago where Ms. C had what they call an intermediate market rent tenancy. I don't know if any of you have come across with these. I think it might just be L&Q that offer them. I feel like I've given something away there. This unknown social landlord had let the property on an intermediate market rent. And as part of the process of getting one of these tenancies, which are below market value, they do a means assessment, and they want to be confident that you can pay it out of your earnings rather than on benefits. Well, she had a violent and abusive husband, and he was ejected from the property, leaving her with the children in the property, but she couldn't afford it on her own. It was too expensive. And she asked to be transferred to another unknown social landlord tenancy. And they said no. They said no, because you've got an intermediate market rent tenancy, we're not going to give you any of our normal fully assured tenancies, and you are not eligible for another intermediate market rent property because you are on benefits. And as you will have seen from all the no DSS cases, that is indirect discrimination, because most recipients of housing benefit or the housing element of universal credit are women. But it was also, we also defended the claim in relation to the PSCD, because of course, here was a victim of domestic abuse asking for a really fairly straightforward thing to deal with the consequences of that abuse, and the landlord just doing absolutely nothing and giving it no thought whatsoever. That one also settled / capitulated by the landlord. Ms. D, and this is a situation which comes up all the time. So I've called this person Ms. D, but it could be Ms. E, Ms. F, Ms. G. Very common situation. Marie already mentioned it, and so did Dan. So Ms. D is the tenant of a local authority, and her neighbours are disturbed by hearing screaming, yelling, and banging and thudding. And after she's separated from her abusive partner, she gets visits from him, banging on the door, yelling up to her window, and so on. And her landlord brings possession proceedings on the basis of her nuisance behaviour, the liability of her for her abuser as a visitor. And again, defended on the basis of indirect discrimination, and the authorities' failure to apply the PSCD. Most people that are in this situation are going to be women, and the failure of a local authority to think through this sort of behaviour, where it's quite clear what's going on. You know, the neighbours were complaining, but they actually weren't complaining in a particularly hostile way. They were complaining because they were being disturbed, yes, but they were also complaining because they were worried about their neighbour. They weren't saying, oh, here's this terrible neighbour of mine, why don't you kick her out? They were saying, I can hear all this awful stuff going on, you need to deal with it. That's what they were saying, and yet the authority were not thinking it through at all. So some technicalities about bringing Quality Act claims, which I'm not going to dwell on because we're running out of time. But I did want to say something about the burden of proof provisions. The really important thing to bear in mind with the burden of proof provisions is that they are not just a reversal of the burden of proof. If they were, it probably wouldn't do all that much, because most cases don't turn on who bears the burden of proof. They are far more extensive than that. And Section 136 provides that if there are facts from which the court could, not should, not must, not prima facie case, but could decide, in the absence of any other explanation, that a person contravened the provision concerned, the court must hold that contravention occurred unless the person shows that they did not contravene the provision. It is a high threshold. If you can adduce those facts so as to reverse the burden of proof, so as to take advantage of Section 136, it is quite difficult for the other party to then discharge their burden of proof. And Eigen and Wong has an appendix to it, which has got guidance on the way that the burden of proof provisions apply. And it's really important that you understand that these provisions are brought in because no one will ever admit that the reason why they didn't hire someone was because they were black, or that they have been harassing their tenant for sex or whatever it is that they've been doing. No one is ever going to admit that. And so the only way that these cases are ever going to be proved is if you can use the burden of proof and draw appropriate inferences. And that's why it requires cogent evidence to displace the burden of proof once it has been reversed. So you can shift the burden of proof with statistical evidence. You can also even shift it sometimes if there is a lack of documentary evidence. So this is coming back to that point about documenting the PSCD. If the landlord has not been keeping records, not been dealing with any of these things, actually they're potentially in a difficult situation. Also worth bearing in mind, this is the case of EB and BA, that the burden of proof provisions apply not just at trial, but also at the case management stage. So they can help you to get disclosure of documents that you might want. In this case, EB and AB, it went all the way to the Court of Appeal, and that case concerned a different protected characteristic and concerned gender reassignment. And in that situation, the claimant was saying that essentially she got given fewer contracts after she transitioned than before. That's what her account was. And her employer said basically, well, you prove it. You prove it. And she's, well, I can't do that. You've got all the records of all the contracts that were awarded and who else had all of these contracts. And the Court of Appeal said basically, you can't do that. If we're going to make these rights meaningful, if we're going to actually give anybody a realistic prospect of being able to prove discrimination, then the burden of proof provisions have to be reflected at the case management stage. I am going on far too long, I'm really sorry. But I would be remiss if I didn't say something about vulnerable parties, because this was actually the main thing that I wanted to talk about. The reason why I wanted to talk about this is Practice Direction 1A, which is to do with special measures and vulnerable parties and witnesses. The reason why I wanted to talk about this is that you may not realise that every single judge in the country has had mandatory training on exactly this issue, on the provisions of the Domestic Abuse Act, the Practice Direction 1A, and dealing with vulnerable parties and witnesses. Judges should at least be absolutely hot on this, and I'm not sure that we are yet. So really take some time to have a look at what Practice Direction 1A says, what it requires in terms of the identification of people that might not be able to give best evidence at trial. Look at the breadth of the reasons why a witness might be vulnerable, might need those sorts of special measures, and it might be putting up a screen. But the thing that I find really gripping is that it also can mean directions about how cross-examination is to be carried out. And I'm sure we all have witnesses that we think would do a lot better if they were not cross-examined in quite as a harsh or confusing or directive way as other witnesses are. Have a look at what Practice Direction 1A says, but also have a look at what the Equal Treatment Bench Book says about special measures, because it's got a whole menu of different things that you can ask for, from the hearing being carried out in a small room, to the hearing being carried out without anyone wearing robes, to cross-examination being carried out with open questions, delightful, to having questions in advance. I mean, there really are a lot of options which are available, which we're not really using at the moment. Yeah, I don't have time for that. Remedies, you all know about injury to feelings, I'm sure, but bear in mind that one remedy that is available under the Equality Act is an injunction. And that may be something that you might want to have in a situation, particularly with a particularly dodgy private landlord. And that is it. I'm sorry, I talked for far too long, but thank you.
Thanks so much to Sarah and Jamie for that. I'm particularly interested in hearing about the breadth of special measures when we think about what we heard this morning about trauma-informed understandings of how people can respond to domestic abuse and how helpful some of those measures might be for some of our clients. We've got time for maybe just a handful of questions before we hand over to Martin to give our closing address and to segue into drinks for the evening. I've got a good question online that I'll start with, and then I'll ask if anybody in the audience is keen. I see some eager hands already. This is, when I speak to lawyers in other areas of law, especially employment, about the difficulties in running PSED arguments in housing cases, they are often surprised. How can we as housing and public law lawyers make these arguments more attractive to judges?
I've talked from well more than my share.
Well, 2 quick points. PSED can't be raised in private law proceedings very easily anyway, so I'm not quite sure what the comparison is. Doubtless it's a good question. I think reaffirming the value of the PSED is something we all are tasked with doing, giving it true meaning. There are actually quite a lot of good successful cases on the PSED. It gets a bad press. It's always trying to do quite a lot of work for us. I mean, that's the bottom line. You know, we don't have the kind of remedies we'd like available to us. It's the only way you can try and attack a sort of failure to remedy a structural scenario, or much more likely a policy which exacerbates structural discrimination. That's much more likely to be the scenario we're in. And certainly if in the context of cuts to public services or cuts to charitable services which help victims of violence, etc., then, you know, PSED can be one of the few things in your armoury. So not sure I entirely agree with the premise of the question, but I'm sure we can still do more to advance the cause for PSED.
I would just add the point that I made earlier, and which I always bang on about, which is that you just have to actually read what it says and be really, really specific. You know, don't just say, oh, you've generally failed to take account of the PSCD. Say, this is something which is related to my protected characteristic, and you have not had regard to that. And because you have not had regard to that, therefore you are in breach of section 149. And I think, to me, that's the solution.
Right. Cool. Sarah?
Thank you. I wanted to ask a bit about clients with a history or a legacy of domestic abuse. So perhaps I've got, for example, a rent arrears possession case where the client isn't currently in an abusive relationship, but she has been in the past. And I think that's informing her approach and making her more vulnerable. Just thinking about her giving evidence, we haven't got a medical report because it's not a present issue, but would there be an opportunity to give her some support as a vulnerable witness because of the way cross-examination is going to, I think she'd find quite threatening, that kind of issue?
If you look at what Practice Direction 1A says, it's really broad, and it doesn't necessarily lead you to very extreme special measures. It might just be little tweaks that are necessary to enable somebody to give their best evidence. And I would also say that these measures and the emphasis on which that they have been given to judges, it is part of a sort of wider move, which is supposed to be getting judges away from assessing the demeanour of witnesses and enabling parties to put their case in the best possible way. And I think if you look at what Practice Direction 1A says and what the bench book then says to complement it, you may well find something that will help you to make those sorts of arguments. I mean, obviously, there still does need to be factual findings about whether or not a person is vulnerable or whether or not their evidence is likely to be diminished. And so that might require some sort of expert evidence. And certainly I've been now, whenever I commission an expert report, address those things. Just routinely, like, is there anything that we should be doing to help this person to give evidence? And yeah, I think that there are lots of options out there now.
Hi, just a couple of brief questions about discrimination claims against private landlords. And could section 109 and 1110, which you referred to about the principal agent, could that be used to establish liability where you're unsure who the landlord is? Because quite commonly there's arrangements where you have the owners appointing agents to manage the property or to grant tenancies. And the second question was just where you're claiming injury to feelings and damages, and there's been multiple incidents of discrimination, what type of sort of level of damages are you looking to claim in the county court, and what is the sort of maximum really?
So in relation to your first point about section 109 and the liabilities of employers and employees and principals and agents, I mean, ultimately you would still have to have a finding that they were an agent for a principal. So you still have to identify who those parties are, or an employer and an employee. And you still need, if you're relying on section 35, which you probably are, that they are that at least one of those people was the person who was the manager of the premises. So ultimately, you're going to need to make those factual findings. But at the beginning of stages, yes, it means you can probably plead it in such a way that you're covering a number of different scenarios, and then you make Part 18 requests, or whatever, appoint an investigator. I've done it on a few occasions. There are things that you can do then to investigate it, but bearing in mind that the limitation periods for Equality Act claims are quite short, sometimes you do just need to get the claim in plead it as broadly as you can, and then worry about defining who the parties are later. Sorry, the next point was in terms of level of damages. I mean, it's so hard to know. So on my slides, which you'll get a copy of, you'll see what the Vento bands currently are. To narrow those down, there are quantum reports on Lawtel, and there are also quantum reports on Harvey on industrial relations, but nobody is keeping quantum reports for non-employment cases, really. And so it's you have to sort of work from those and just do the best you can. There's an entire section on Harvey's on multiple discrimination, so but it is a bit finger in the air.
And perhaps that's a good moment to sort of put out a rallying cry that if you've got any of these cases, I know a lot of discrimination cases can sometimes settle, sometimes with non-disclosure aspects, which make disclosing the sums that you're getting in that context difficult. But if you've got a case where you've got a figure, do write into the legal action group. Let's start sharing that information, because it is a difficult exercise to value these claims. But otherwise, I know we've got some other questions online, but I'm mindful of time. So big thank you to Jamie and Sarah. And I'll wrap up now, and then we'll have Martin, who you've seen earlier today, give a closing address.
Well, thank you, everybody. It's been tremendous to see so many people here for this conference. It's even better to see so many of you still here after what's been a day where there's been an awful lot to take in. I just want to start with one point that's a bit sort of off point, which is that today has, I think, really demonstrated the value of housing law as a discipline, because what we've been able to do is focus on the intersection, for the purposes of that sort of vital aspect of well-being, of a huge range of things, going from immigration, international law, child protection, and so on. There's a great long list I've got written down here, but it's too long to read. But so it's a sort of shout out to housing law and to housing lawyers. Unfortunately, we can't give you much of a reward apart from the refreshments, which will shortly be available. I just want to, I suppose, draw out a few themes. What we've covered has been so diverse, it's quite difficult to pick out themes that stand out. But I want to say a bit about responsibility and power, education, support, and gaps. So far as responsibility and power is concerned, I want to really focus on our own, because as lawyers, we tend to do our legal stuff. We find out what we need to do our legal stuff, we do it, and then we go on to some more legal stuff. And those of you who like legal stuff, as I do, will know that we've had lots and lots of it in this today, particularly this afternoon. It's all been excellent, and I, for one, intend to pass it off as my own whenever I can. But we know there's much more to it than that, and the legal bit is only a part, not necessarily the most important one. And wrapping around it all the time is a human encounter, where it's very easy to forget the power that we have in that encounter. And even if we get the right result, we learned today in the particularly powerful session about dealing with, working with survivors, that we could very easily end up reinforcing abuse unless we take appropriate steps not to. And it's a very valuable reminder. We're dealing with clients who've very often been let down in the past, have to recount things that anyone would find difficult in an environment which is unfamiliar, where they're under pressure, they feel judged, and so on. And we had some invaluable insights today into the need not to make expectations about how people should behave as domestic abuse survivors, to take them on their own terms. One of the passages in the document that Sue James shared with us made the point that every survivor's experience is different. And we were given a bit of a masterclass in ways to reassure clients, make them feel safe and able to participate. And if you take one phrase away from today, for me it would be nuggets of compassion, which you heard referred to earlier. And that's compassion extends, I think, to yourselves and your colleagues, because one of the virtues of a day like today is it's an opportunity to swap experiences of dealing with cases like that, to understand that we're not alone in finding it hard, and to discuss the best way forward. So don't forget our own power. So then I'll come on my second point is education, which really follows on from this. And by that I mean our own and that of who I'll call, for want of a better word, our opponents. And obviously there's a good deal of training and refreshers on the information that we can access for dealing with survivors of domestic abuse. There was a reference made earlier to the Safe Lives website. I don't know if you had an opportunity to look at it. I had a quick look in the course of today after we were signposted to it, and it's an extremely useful source of all sorts of ways in which you can improve your own understanding. But also, we do need to be aware of the need to, again, educate, for want of a better term, defendants in claims where we want to argue that they have approached evidence gathering wrongly, they've making the wrong assumptions and so on. And the code, homelessness code in particular, is very good on this, as is the domestic abuse guidance. But it may be that we'll need more than that, and certainly one of the questions I think was asked earlier today was asking about what sort of sources there might be for academic support or research support or something like that we could use to either make submissions in a letter or to deal with in pleadings. Now, again, the Safe Lives report, the Safe Lives website's got some very useful research materials on that and a lot about good practice. But specific to housing, perhaps that's something that could be taken forward from today, that what would be beneficial would be if there was a source of quotable resources that we can refer to. Obviously, we have to take account of our own pressures, that we don't have time to necessarily go through all of these things point by point. So perhaps that's something that could be taken forward. Joe isn't here anymore, so I'll volunteer shelter and I'll speak to them about it. But it's something that perhaps we do need to take forward from today. My third sort of theme is support, which of course is crucial to enabling the survivors to live safely and to take back control of their own lives. But one of the things that has emerged from today is that the legal foundation for any obligation to do that is surprisingly thin in our domestic law. There's lots of statements in international law requiring it, with the Istanbul Convention particularly. But domestic law fails to give effect to any particular comprehensive duty. As Xu Xin pointed out, the Domestic Abuse Act obligation in Part 4 is very specific to particular kinds of accommodation. And other than that, you've got a mixture of powers, some under the Housing Act, some under the Children Act, some benefits guidance and so on. And a lot of it is dependent on voluntary agreement with authorities. And some of those authorities may not initially have responsibility unless they voluntarily take it on. So there's a challenge about how to try and establish some sort of overarching obligation or some overarching approach to support of that kind. It may be a role for the Commissioner, and we'll have to see how she exercises her powers to encourage best practice and to report. We've also learned that support's very complicated. Support to some survivors might be seen as undermining others. And you might need to work with regard to the interests of the perpetrators, because a durable and fair solution may need to have regard to them. So it's a very complicated issue. And then we've also learned about gaps. Harriet, in her opening address, reminded us of how long the history of combating domestic abuse has been, and how much has been done, much of it, frankly, thanks to her. And when you look at the timeline, on the her website, you can see it sort of grows like a tree as we reach the present, with more and more measures being taken. But there's still a lot missing. Xu Xin reminded us that child protection seems to be better at removing children rather than supporting them. And she pointed out the gaps in the 2021 Act. Harriet again reminded us about immigration exclusions, and that's a particular problem in our area, because when you look at the Homelessness Code of Guidance, it optimistically refers to the domestic violence concession that was again referred to later on this afternoon, but it fails to cover the fact that you only get to that if you're eligible already. So, or you only get any advice about it if you're eligible already. So it's a classic catch-22 problem. And then we heard about the joint tenancy difficulties, and the ability to serve notice. And then there are also gaps that fall between areas. So, for example, you've got a failure of any kind of integrated approach between housing and childcare and other areas. Again, this may be something where the Commissioner will be able to shed some light or be able to encourage some kind of better working, but we'll have to see how that develops. And so that raises the question, well, what is to be done? Where there are frank gaps in the law, then we can't, as lawyers, fill them. But obviously there are, for example, use of discrimination arguments may assist of the kind that you've just heard about. But although there ought to be new laws, at the same time, there's a lot to do with the laws we've already got. And that's one of the encouraging things we can take away from today. So right at the start, we heard about what can be done with close attention to allocation schemes and closely focusing on what powers authorities have got to cooperate with one another. It might not be quite as simple as it was suggested that they just need to be told to do the right thing. We might find that that depends on who's doing the telling and how they do it, but you get the idea. And similarly, close attention to occupation rights and benefits of the kind that we were talked about earlier this afternoon will help to secure stable homes, safety and security. And there's a great deal of ignorance about those which we as practitioners need to be able to combat. And then there's things like being able to use grounds for possession where they're available, because perhaps too often the solution is reached for to move the survivor and not the perpetrator. So those are some of the themes that came out of today. There's a question really about where we should go from here in discussing this. There's a lot of themes which are going to develop over the course of the next years. There will be questions about how the definition of domestic abuse plays out, particularly in the housing context. There'll be questions about how the support duties in Part 4 of the Act are implemented and whether they turn out to be as specific and potentially enforceable as they might be, or whether that turns into a bit of a dead end. There'll be questions about what use the Commissioner makes of her powers. And all of those will be things that will be useful to revisit in some way, and we'll need to try and find a way of doing that. Probably not by another full-day conference, but it's perhaps something we should come back to either with a shorter session or as part of a wider conference on other topics. So it's certainly something that needs to be picked up and kept an eye on. So I think it only remains for me to give some thanks. Firstly to the organisers. I'm not going to name names, but to make sure this went extremely smoothly today from all aspects of the organisation. Particularly the slides that were able to be run through smoothly despite Jamie's determined efforts to stop that earlier today. I'd also like to thank the speakers who put in a tremendous amount of work, and finally to thank you for being such an excellent and attentive audience and asking us some really probing questions. So thank you all very much.